Have your lordships kind leave, my lord? I am
No. Call on the list, please.
grateful to you.
Commercial Division, original site. Day list, item number 2, the state of West Bengal and others versus Mrs. BBM Enterprise
For judgment to board.
for judgment.
For judgment about.
For judgment, item number 2, the state of West Bengal and others versus Mrs. BBM Enterprise.
Yes, who is there for the judgment? For nobody is here. 12টার সময় রাখো তো। Next.
Item number 3, Mrs. New Build Corporation.
My lord, I have indicated in this copy, my lord, with pencil.
The correction?
Yes.
Have you shared with
Yes.
the
Lordship,
Yes, ma'am.
the figures are correct.
microphone, please?
Let the figure indicated in your lordship is by pencil, my lord, it's correct.
Yes, learned counsel appearing for the Union of India seeks correction of two figures mentioned in paragraph 12 of the judgment dated 10th July 2023. Stop. Next paragraph, the advocate on record of the petitioner is present. Stop. Next paragraph 12 of the judgment should read as EC 272 of 2022 is accordingly disposed of Purota Ligbe by directing Purota. Balance amount of rupees 38,89,885. Is that what you've
Yes,
written?
yes.
Why don't you write in pen? I can't even understand. To দেখিয়ে নেবে। তো করে ব্র্যাকেটে লিখবে rupees 3,88,98,8. But what about the bracketed portion?
My lord, the amount which has been
My lord,
paid is,
instead of, I'm telling your lordship, my lord.
But if you
instead
have
of-
corrected the first figure, then the bracket will not change.
no, bracket will also change, my lord.
But you have not corrected that bracketed
Three point
portion.
five zero will be 3.50
তুমি Korean হয়।
089.
What is this, Mrs. Banerjee? Why do you do all this half-baked work? You have corrected the figure before the bracket, so the bracketed portion will also change,
My lord,
isn't it? Then what is this? দেখে নাও কি হবে। To the award holder within 3 weeks from date. এগুলো দেখে নাও, figures গুলো। This direction is also in terms of the recording in the order. Now, date, close quotation marks, full stop. Next, let these corrections be incorporated in the judgment and be made part thereof. দেখে দাও ওনাকে। Next,
Item number 4 and 5, Pratyusha MRJV.
But I appear for the petitioner. But my notes, but is ready.
which
Right.
is this matter?
But this is a section 9 application and a section 11 application taken up together. Where in section 9 application, I was paying for security that the respondent is a joint venture company. But their obligation towards the contract which they were performing for their employer has been discharged. The obligation, the contract has been performed.
No, it's a section 11.
It's a section 9 and section 11, both were taken up together. Section 11, Malad, is
So the ground of limitation will will be relevant for both.
my lord,
or
both
one?
the matters, both, Malad. That's their common point in section 9 and 11 application. My notes is ready, Malad. I have already cited, Malad. My learned friend has also cited judgments, Malad. I had also cited judgments, but Malad, in my notes, I have added 3 judgments which I will put my learned friend on notice. Because, Malad, insofar as, Malad,
Yes,
they
but
have.
if you haven't cited, I have to give Mr. Basu a chance.
Yes,
I'm
Malad.
grateful, Manoj.
Yes, Malad. May I file my
And
notes?
Mr. Basu, are you all right now?
Yes, Manoj.
I'm talking about your conjunctivitis.
Yes, Manoj, I'm completely fine now.
Yes,
Malad, may I hand up?
just so as to, for your learned friends in the sitting in court for that. for that reason. Yes.
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 But may I file my note, my lord? And my lord, I'll indicate the judgments that I have
Yes.
My
additionally
lord, you will
cited.
kindly keep the matter on Friday for us to distinguish the judgments that my learned friend is relying upon now.
Mr. Dashgupta, then don't give your note now because it will invariably get misplaced. Give your notes
Very well.
together.
Right.
Yes, learned counsel appearing for the petitioner seeks to rely on decisions which were not cited previously, which were previously not cited. Stop. Next, list this matter on, I'm keeping it on 31st. On 31st July 2023 for learned counsel appearing for the respondent to distinguish those decisions. Stop. Please give the citations to Mr. Basu.
My lord.
Grateful.
My lord, I'll give it. Great.
Item number 6, Sifcon Construction Private Limited.
Lord, item number
I'm appearing for respondent. my lord.
6 and 7, my lord, are my section 11 applications, my lord.
Yes.
My lord, on 2017, my lord, July 2017, my lord, Hindustan Aeronautic Limited, my lord, floated a notice inviting tender, my lord, for my lord, construction of a NDT meteorology lab, my lord. My lord, the petitioner herein was the successful bidder, my lord. And
Yes.
upon being declared the successful bidder, my lord, on 31st March 2018, my lord, they, my lord, issued a work order upon the petitioner.
Yes.
My lord, pursuant to this work order, my lord, an agreement was entered into. The agreement, my lord, is at Annexure B, page 28, my lord. My lord, clause 5 of this,
Date.
my lord, this is, my lord, the agreement is, my lord, dated page 28, my lord. My lord, this agreement is of 2018, my lord. My lord.
Don't say of 2018. What is this? You're not ready or what?
Yes, my lord, I'm ready with the matter, my lord. I'll just indicate, my lord, the
You're giving me the page and you don't know the date.
10 for 2018, my lord, 10th April 2018.
Yes.
My lord, clause 5 of this agreement, my lord, is, my lord, the arbitration clause, my lord, which stipulates that any dispute arising out,
Page.
my lord, that is at page 28, clause 5.
Yes.
My lord, clause 5, my lord, states that any dispute arising in terms of this agreement, my lord, will be referred to arbitration appointed by the manager, my lord. My lord, during the pendency of the contract, my lord, the contract duration was, my lord, 12 months, my lord, due to latches on their part, my lord. It was our contention that the contract had to be, my lord,
Ashes on their part. What were they supposed to do?
my lord, there was different latches, my lord. One was not payment of RA bills timely, my lord. 2, did not provide drawings, my lord. 3, the site was not clear, my lord. These were, my lord, intimated to them by several correspondences, my lord, which were not adhered to, my lord. Thereafter, my lord, I issued a claim, my lord. On, my lord, 6
Claim.
January
Claim
2000,
for what?
claim for, my lord, the losses which I had suffered, my lord, the payment of the RA bills, my lord, these were not done, my lord. They were outstanding on it.
So you did not complete within the 12 months.
I had asked for extension, my lord. Extension was granted, my lord. Subsequent,
One more question and I'm going to dismiss the petition. You are supposed to get ready and present the facts properly.
yes, my lord, I had asked for extension, my lord, and the extensions were initially granted. Subsequently, my lord, they had said that extension will not be granted, but you will be liable to complete the work by 2022 September, my lord.
2022 September.
Yes, my lord.
So the original contract was till 2018 and then 4 years extension given.
Yes, my lord. Initially, the extension was given. In fact, my lord, we had said, we had intimated them that unless you complete the breaches, my lord, it was not possible for us to go ahead with the contract.
So
my
they
lord.
gave you a one-time extension of 4 years.
No, my lord.
Then
Extensions were granted all along, my lord. Whenever, my lord, it was sought for, my lord, since, my lord, extensions, it was on their latches on their part, my lord, they granted the extensions, my lord. Subsequently, my lord, and these extensions were given, my lord, without imposition.
and they said that latches on our part, therefore extension.
It was not specifically mentioned, my lord, but no LD was imposed, my lord. My lord, extensions granted without imposition of LD, my lord.
Yes.
And subsequently, my lord, it is on 6th of January, my lord, 6 January 2023, which is annexure O, my lord, to my petition, which is page 62. I intimated them, this is, my lord, my demand for around 88 lakhs 8,706. Unless you pay the same, it is impossible for us to proceed with the work, my lord. My lord, this letter, my lord, was not,
So all along you were working without money.
we were paid, my lord, on ad hoc basis, my lord, and not in terms of the agreement, my lord. RA bills were not being paid
Payments made on account of the running bills or no?
on account of RA bills, my lord, but my lord, not on a timely basis, my lord. And the outstanding, my lord, came to around 88 lakh on 6th of January 2023, which we asked them to pay, my lord. That is, my lord, annexure O, page 62, my lord. My lord,
Yes.
this demand notice was never replied to by them, my lord. Under such circumstances, my lord, on 27th of January 2023, which is my notice invoking arbitration, which is annexure P, my lord, at page 64, I requested them under section 21 of the Arbitration and Conciliation Act to kindly appoint an kindly, my lord, proceed with arbitration. My lord, they denied arbitration, my lord. We said that
They denied arbitration. What does that mean?
my lord, we said that you do not have the right to, my lord, appoint an arbitrator because of, my lord, the judgment of Perkins Eastman, my lord. Therefore, my lord, we suggested that we proceed and appoint an arbitrator, my lord. They declined to do the same, my lord. Under such circumstances, my lord, the present section 11
So
application.
they replied to your 21.
Yes, my lord. That reply, my lord,
To
is,
say that.
yes, my lord. They replied in annex on 19th May, sorry, my lord, 29th May 2023, annexure Q. They did not deny the arbitration clause.
Annexure Q, you want the court to find the page.
My lord, annexure Q, my lord, is the last annexure, which is at page, my lord, 69, my lord. My lord, this is where, my lord, they do not deny the arbitration clause or the existence of the arbitration clause. They only say that your claims are not maintainable. These claims are illegal and devoid of merit, my lord.
Yes, what do you have to say?
Well, the annexure Q reads as under,
I can't hear you, microphone.
the annexure Q reads as under, my lord, they are not mentioning the proper place, my lord.
Not
We had
mentioning
by
the
our
proper-
letter dated 27 January recorded our claims under different heads as per annexure A3 was enclosed. More than, oh, sorry, this is not, this is your letter, annexure Q.
Yes,
Page 60.
none
But I am
of,
not admitting any of the claims, my lord.
very good.
Kindly record it.
then you agree to an arbitrator. Yes, what is the claim as of today?
My lord, the claim as of today is, my lord, 88 lakh 8,706, my lord.
That
This-
was of 6th of January 2023.
yes, my
What
lord.
is it now?
My lord, at present, my lord, that would be, my lord, interest would accrue on that, my lord. So, my lord,
At what percent?
my lord, we have, my lord, on that day, my lord, calculated interest at the rate of, my lord, 18%. My lord, 18%. That is at page
You are
68A.
Mr. Banerjee.
Yes, my lord, page 68A, my lord.
Mr. Banerjee, you have to pull up your socks. This is the second time. Why are you not ready properly?
Yes.
It should be at the back of your, on your fingertips, the facts. What is this?
I apologize, my lord.
In my court, not to be tolerated.
Right, my lord. My lord, page 68A, my lord, I have said 18%, my lord. That's how I have calculated.
The dispute between the parties would be evident from the series of correspondence on the demands made by the petitioner, comma, as the contractor for construction of a laboratory for the respondent HAL. Stop. The agreement between the parties is of 10th April 2018, pursuant to the petitioner emerging as the successful bidder in a tender floated by the respondent sometime in July 2017. Stop. The contract was initially for a period of 12 months, but was admittedly extended by the respondent on several occasions, culminating in an agreement whereby the petitioner was to complete the contract by September 2022. Stop. Next, the petitioner's grievance is that the petitioner raised bills, running account bills on the respondent, comma, some of which were paid, but payments remained outstanding, which amounted to approximately rupees 88 lakhs as of 6 January 2023. Stop. The petitioner, this is the last letter of demand issued by the petitioner on the respondent, to which the respondent did not respond.
No, my lord, kindly record the response at page 69, my lord. Page 69.
If you interrupt, I will impose costs. You finish hearing what I'm saying and then you interrupt. Ki bola? Did not respond. Stop. The petitioner was therefore constrained to issue a notice under section 21 of the 1996 Act on the respondent on 27 January 2023, invoking the arbitration clause, which is clause 5 of the contract dated 10th April 2018. Stop. The respondent replied to this letter on 29th May 2023, raising disputes, but not to the existence of the arbitration clause. Stop. Next. There is no doubt, there is little doubt. There is hence little doubt that not only is there an agreement between the parties governing the contractual relationship between them, but also that there is a dispute with regard to the unpaid bills of the petitioner, which amounts to, which is in excess of rupees 88 lakhs along with interest, along with the agreed rate of interest. Stop. Next. The advocate on record of the respondent disputes the contentions made on behalf of the petitioner. Stop. The view of the court of an existing dispute between the parties is not displaced by the position taken on behalf of the respondent. Stop. Next. AP 47, the parties would hence fall under section 11 within bracket 6 within bracket small a of the 1996 Act. Stop. Next, AP 475 of 2023 is accordingly allowed and disposed of by, what is the claim now? 88 lakhs.
88 lakhs, but along with interest at 18% per annum. My lord.
So how much would that, and from when will that interest be calculated? How much will the claim amount to now?
My lord, on 6th of January, it was 88 lakhs and odd, my lord. Thereafter, my lord, 18% subsequently from 6th of January, my lord.
Give me the approximate value. What is wrong with you? Can't
It
understand.
would come to around 95 lakhs, my lord.
The, ki bola last time? By appointing blank as the arbitrator to resolve the disputes and differences between the parties, subject to the learned arbitrator communicating his consent in the prescribed format to the registrar, original side within 3 weeks from date. Stop. The petitioner shall communicate this order to the arbitrator by 27 July 2023, along with relevant particulars of the contact person of the petitioner. Stop. Yes, call on the next one.
7, SIFCON.
7 is my section 11 application between both the parties, HAL and the petitioner, my lord, SIFCON, my lord. NIT for construction of internal road, my lord, was issued, my lord, on 21st February 2018. My lord,
So this is a different contract.
different contract, my lord. This one is for internal road, my lord, construction.
Yes, place your facts properly. No questions from the
My lord,
court.
thereafter, my lord, being the successful bidder, my lord, a work order was issued on 1st September.
And what is the contract about?
My lord, is for construction of internal road, my lord. And
External, internal?
internal road, my lord.
Yes.
And my lord, the petitioner being the successful bidder, my lord, was issued a work order on 1st of September 2018, my lord.
Yes.
And pursuant to this agreement, my lord, pursuant to this work order, my lord, an agreement was entered into on 10th October 2018, my lord. This agreement, my lord, again contains the arbitration clause, being the clause 5 of this agreement, my lord. I'll refer to this arbitration clause, my lord, subsequently, my lord. During, my lord, the pendency of this contract, my lord, several disputes had arisen. However, this contract, my lord, was fully completed, and a completion certificate was also issued to the petitioner, my lord, and that is at page 28, my lord, wherein, my lord, the respondents had stated that the petitioner had successfully completed the project, my lord. However, my lord, despite issuance of this completion certificate, my lord, they did not pay the entire RA bills and as well as withheld amounts on account of LD, liquidated damages, and for other reasons, my lord, those reasons not being disclosed to us, my lord. On such circumstances, my lord, again, my lord, we issued a letter to them, my lord, demanding, my lord, a payment of 33,72,057 rupees, my lord, which is at page 33 of this petition, my lord. My
What
lord,
is the date of this letter?
this is 6 January, my lord. 6 January, this letter was issued, my lord. I'm sorry, my lord, 6 January. My lord,
The
kindly, my lord,
counsel appearing for the petitioner needs to get ready in the matter. Stop. List this matter on 31st July 2023. Next.
Eight, the New India Assurance Company.
I'm for the response.
I appear for the petitioner in this matter, my lord.
It's a 36.
Lord, this is an application for extension of time to furnish bank guarantee in terms of an order dated 5th July 2023 passed by your lordship in an application under section 36.
Where is the order?
The order starts at page 11, my lord. The operative portion is at
But
page.
wasn't the application disposed of on
Yes,
that
my
date?
lord. It
Then
was
how can I,
Lord, so I filed another application for extension of time. This is an
please, I've given a judgment on this. Cannot be done.
this is another application that has been filed in the 36.
I've given a
extension of time.
judgment on this,
Very
that
well.
if the application is disposed of, you cannot do that.
Very well, my lord. Very well.
What was the direction?
The direction, my lord, was to furnish security to the tune of approximately 11 crores 68 lakhs, which was half of the award amount of 24 crores. My lord, half of the amount.
MSME?
Yes, my lord. Half of the amount directed to be furnished as security was to be done by way of a demand draft, and the remaining.
Within 2 weeks?
Yes, my lord. And the remaining half was to be done
2
by
weeks is, takes us to 19th.
19th July, my lord. Half was to be done by way of a demand draft, half by way of a bank guarantee. The demand draft, my lord, has
You
been.
filed the application a day after.
Yes, my lord, we mentioned on 19th, my lord, when your lordship indicated that such an order could not be modified on mentioning. We filed the application on the very same day, my lord, for extension of time by around 7 days.
So what have you done? You've given the 50% by
Demand draft, my lord.
cash.
You deposited a demand draft.
No, what about the cash deposit?
Cash deposit.
That was the
That is,
direction.
that is by way of a demand draft, my lord. My lord, I show your lordships the relevant annexion. 22 of the 22 of the application, my lords.
And the balance was to be by
Done
way of a
by
bank guarantee.
my lord. My lord,
So what is the extension you want?
my lord, to furnish the bank guarantee, my lord, there was a slight delay. My lord, we finally got internal approval to have the bank guarantee sanctioned on 18th. We immediately approached the bank, my lord. The bank told us they would require 3 working days to provide us the bank guarantee. So when it became clear to us, my lord, that we would not be able to furnish it within the stipulated time, we mentioned before your lordships upon notice.
Yes, Mr. Talukdar, what do you want to say?
Yes, my lord. In my respectful submission, my lord, and their instance, my lord, your lordship was kindly, my lord, allow them to deposit 50% of the amount by way of bank guarantee. Now, my lord, kindly see that order, my lord, was passed on
5th of July.
5th of July, my lord, page 10.
Yes,
Now, kindly come, my lord, to page 14.
yes.
First, second, third, fourth paragraph, my lord. The petitioner will secure 50% of the total amount of such and such, which comes to be such and such by way of cash deposit. Number 1, my lord. And the balance by way of bank guarantee with the registered original side of this Hon'ble court within 2 weeks. Now, 2 weeks, my lord, is 19th of July. Now, my lord, they did not take any step before 19th of July to have, my lord, the bank guarantee, my lord. Kindly come to first, my lord, page 16. Sorry. Page 20. Kindly come to page 20.
Yes.
Now, my lord, kindly see, this is much, your lordship was pleased to pass the order on 5th of July. This is on 6th of July. From Sanjay Rana, such and such to Surya Prakash.
Now, who are these people? Just tell me.
Yes,
They
my
are
lord.
officers of the petitioner company.
Petitioner. So
Yes.
just tell me that it's a petitioner, that's all.
Yes. Now, here, my lord, they are saying,
Petitioner is writing to who?
right, my lord, from Sanjay Rana. That's, my lord, the bank. No, sorry.
My lord, these are all internal communications of the petitioner.
No,
Legal officer, my lord. This is an
Mr.
internal
Talukdar,
document.
what is the point? What is the point?
My lord, before 19th of July, my lord,
Yes.
they did not take any step to have the bank guarantee.
No, no,
my
but
lord.
this is 6th of July. So what
Kindly
is the
see,
point?
This is the only letter, my lord, of 6th of July.
So who is writing to who? Just tell me that.
My lord, this is an internal document, my lord. One bank official to another bank official.
Very well. Yes.
You are requested to kindly arrange for necessary approval. My lord, this is of 6th of July.
But this
Now-
is, the petitioner is not a bank. So why are you saying internal document?
No, this is, my lord, between the bank officials.
So say that. Why are you saying petitioner? It's the
No,
bank.
between
Yes.
the officials. my lord.
You
Now
say
kindly
internal
come to-
document, then I thought it's a petitioner. Yes.
Yes, now I'm sorry, my lord. Now we not kindly come to page 16.
Yes.
Now we not kindly see the date is 18th of July, my lord, 2023.
Yes.
Now, my lord, that is just before, my lord, the final date. Now, my lord, kindly come to page, my lord, page 18.
Mr. Talukdar, you have to complete the point. Why are you showing me page 16? Just show me,
Lord,
tell me
I'm
the
showing-
point.
My lord, I'm showing the page 16, my lord, because of this reason, my lord, that, my lord, it was written between the bank officials, my lord, on 18th of July, 2023. 18th of July. One
Yes.
bank official, my lord, writing to another bank official.
Yes.
Now, that was, my lord, on 18th of July. Now, kindly, my lord, come to page 18.
Yes.
This is also, my lord, same thing from Shujjo Prakash, that is, my lord, New India Corporation, and then to Nikita Rathi, such and such, copy to. This is also an internal document, and, my lord, the petitioner was given a copy of this letter, my lord, on 20th of July.
Very well. So what is the point?
No, but before 19th of July, my lord, they did not take any step. The
Very well.
bank-
So what is it that you want? You don't want the security?
The deepest of respect, my lord, not all the submissions that have been made
My
are correct.
microphone, please.
Not all the submissions that have been made are correct, my lord. The steps, we started taking steps from the day after the order was passed.
Very well. So you can do it in the course of the day?
My lord, we need another 3 days, my lord, to have it furnished.
No, no. 3 days you had asked
Yeah.
for from the date of the application,
The prayer
which
in
is
the-
20th.
The reason being, my lord, the prayer in the application is for 7 days from the date of the order. We had received the bank guarantee on, we had received the original bank guarantee on Friday itself.
7
which
days
is
from the date of
21st.
the order.
Yes, ma'am.
So that part has
The
gone.
order passed in this application, my lord.
So then
Then
7
they-
days from the date of the order is 5th to 12th July.
your lordship,
But you filed the application on 20th.
yes,
What
my
is
lord.
this?
The reason being, my lord, that we had received the bank guarantee on the very same day. It was not in correct form. We had to send it back to have it affirmed in the correct form.
Whatever it is, your prayer is senseless. Hmm. The petitioner wants extension of time to comply with the order passed by this court on 5th July 2023 in an application made by the petitioner for stay of an award dated 3rd April 2023. Stop. By the said order, the petitioner, the award debtor, was directed to secure 50% of the total amount of approximately rupees 11.68 crores by way of cash deposit and the balance by way of a bank guarantee with the registrar, original side of this court. Stop. The compliance was to be done within 2 weeks from the date of the order, which comes to 19 July, which comes to 12th July, 19 July 2023. Stop. Next. The present application was filed on 20th July 2023, but the petitioner, strangely enough, has asked for extension, has prayed for extension of 1 week from the date of the order, which is 12th July 2023. Stop. This is hence completely without any sense,
My lord,
since
if-
the application was made on 20th July 2023. Stop. Next, the internal correspondence between the bank, which was to furnish the guarantee, shows that the petitioner took steps for compliance from 5th July 2023, but the bank but the bank continued to correspond within itself till 20th July,
Lord, if I may-
till 19th July, till 19th July 2023. 18 July 2023. Stop. Next. Whatever the other contention, comma, made by learned counsel appearing for the respondent award holder, comma, is that instead of the cash deposit, comma, the petitioner has furnished a demand draft of 50% of the awarded amount. Stop. Next. Whatever be the case, comma, the petitioner should be given one extension to fulfill the direction passed by the court. Stop. GA1 of 2023 is disposed of by directing the petitioner to furnish the bank guarantee by 28th July 2023 in accordance with the terms as contained in the order dated 5th July 2023. Stop.
Lord, if I may make just one submission, Lord, the prayer is for an extension of a period of 1 week from the order passed herein, my Lord. So your Lordship may kindly not record that we had asked for an extension from 5th of July.
Prayer is not specific. Next. Call on the
And
next. matter.
second, my Lord, the correspondence are not within or not between the bank and the petitioner company. They're all internal correspondences of the petitioner.
If you have not understood the order, bad luck. Call on the next matter,
Yes,
please.
with your lordship.
9, Cholamandalam Investment.
This is my application under section 9 of the Arbitration and Conciliation Act. My lord, in this matter, my lord, already there were previous orders, my lord, of security, of show cause for security was passed by the coordinate bench. Lord, thereafter, this coordinate bench of this,
Where is the affidavit of service? They have appeared.
they have appeared. In fact, my lord, I'm just indicating the background. And thereafter, my lord, there was a direction by this, the coordinate bench of this honorable court, to take physical possession of a property situated at Raipur. Lord, the receiver was appointed. The receiver had gone to Raipur, my lord, but was unable to take possession of the property, pursuant to which, my lord, there was a direction upon the Inspector General of Raipur to furnish a report. The Inspector General furnished a report indicating that there has been a proposal for settlement, which has come from the respondent, and in view of that, this matter can be kept at abeyance. The respondent appeared on the last date and they submitted before this court that they want to settle this matter and they will give a proposal for settlement.
So you are this is a 9 or a what is
Section,
it?
this is a section 9 application.
9. So you are willing to wait for the settlement.
My lord, we haven't received any proposal for settlement, my lord, and since we have been unable to, my lord, execute,
Very well. Tell me, I will keep the matter on some other day and then give them one final chance.
but kindly keep this matter on Monday. In the meantime, I will also file a supplementary affidavit bringing on record the statement of accounts, which would indicate, my lord, prima facie case of default, so that I can pray for an order of security, my lord. But I'll intimate
Very
this to my
well.
lord.
No one appears for the respondent. Stop. The last order passed by the court dated on 11 July 2023 records that the respondent had relied on that the respondent had submitted that the respondent had indicated a proposal for settlement between the parties. Stop. Next, list this matter on 1st August 2023 as a last chance to the respondent to state its position. Stop. If the respondent remains unrepresented, the court will proceed to hear the matter and pass appropriate orders. Stop. Next, the advocate on record of the petitioner shall communicate this order on the respondent in the course of the day.
My lord, one submission, my lord, we had also communicated the order of the last date passed by this honorable court that you please give a clear proposal for settlement. And this was received by them, my lord. May this matter be kept on record.
Learned counsel, next, learned counsel appearing for the petitioner submits that the petitioner had asked the respondent for a crystallized proposal for settlement and places a document in this regard. Stop. Next.
Grateful.
Item number 10, Kobelco Construction.
Does it require to file our notes today, my lord?
Yes.
May I be permitted to file my notes?
The only thing, my lord, my notes are ready, only my lord, cost title has gone wrongly. May I file it during the course of the day, my lord? I'll only change the cost title and file it with my lord's officers. My lord.
You have made yourself the respondent.
No, I am the petitioner, my lord.
YouTube
Respond.
he responded আমি order নেবো তোর কাছে, ঠিক আছে?
We can respond later.
Where is your flow chart, Mr. Ray?
I've abandoned it.
Flow chart.
I remember I was talking to my junior about this only.
Very well. Learned counsel appearing for the parties have indicated their points by way of short notes. Stop. Mr. Ray, what have you done? You have annexed
The judgments, my lord.
the judgments.
Yes.
Have you placed these judgments?
Yes, yes.
Yes,
In
yes,
the
I've
course of
dealt with
submissions?
them also.
All of them.
I've dealt.
Nothing new, my lord.
Yes. List this matter. Mr. Banerjee, I've recorded that, so please do it in the course of the day.
Yes,
all
yes.
right? আর শোনো, ঠিক জায়গায় রেখো নোটটা হারিয়ে যাবে।
Great.
List this matter on
Now, what are the judgment taken?
7th August 2023.
My lord, very grateful.
And please ensure, Mr. Banerjee, that it's kept in the
Yes,
proper
yes,
place.
yes, yes. What
11.
Same order, same notes.
Two matters because there are two
Two agreements, my lord, that is why two matters.
Very good. একই order করো।
Kothari is appearing.
Item number 12, Cholamandalam Investment.
Lordship, I am appearing for the petitioner. We have instructions to withdraw this application.
The advocate on record of the petitioner submits that seeks to withdraw the execution petition,
Lordship, section 9 application.
seeks to withdraw the present application filed under section 9 of the 1996 Act. Stop. Next, AP 185 of 2023 is accordingly dismissed as withdrawn. Stop. Interim orders of any shall stand vacated.
Grateful, Your Lordship.
They have appeared in the matter?
No, Lordship.
No. একটা অর্ডারটা দেখিয়ে দাও তো যেখানে অ্যাপিয়ার করেছে।
The service was not complete, so they have not appeared.
Yes. Next, call on the next matter.
13, IDFC First Bank Limited.
Lordship, I am appearing for the petitioner. Lordship, on the last occasion, there was order for substituted service in terms of hand service, but hand services was refused. So I am praying for paper publication.
Where are they based?
Maheshtala.
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 So what newspapers circulate in Maheshtala?
Lordship, Ajkal,
Ajkal. All of them are in
Business
Maheshtala.
Standard and Ajkal.
Business Standard. They
Lordship.
read, they will read Business Standard.
Lordship, as your Lordship pleases.
The advocate on record of the petitioner submits that the respondents refused hand service, which was directed by the order dated 11 July 2023. Stop. The advocate on record accordingly seeks an order for substituted service by way of paper publication. Stop. Next. The petitioner is given leave to publish the gist of the prayers in the present application. It's a 9
Lordship.
present application in Times of India and Anandobajar Putrika. Within, how much time do you want?
6 weeks.
Within 6 weeks, comma as prayed for, stop. List this matter after 6 weeks.
Item number 40, Cholamandalam investment.
But item 14, my lord, it's a post-award section 9 application. We want to withdraw this application because we are in the course of filing an execution application now. The award was passed on 27th of March.
Learned counsel appearing for the petitioner seeks to withdraw the application filed under section 9 of the 1996 Act. Stop. AP number 234 of 2023 is accordingly dismissed as withdrawn. Interim orders, if any, shall stand vacated.
Fifteen, Tata Capital Financial Services.
My lord, this is my section 9 application, my lord. By an order dated 4th July 2023, there was a direction upon the petitioner to try other modes of services. So, my lord, the collection manager of the petitioner company went and tried to give them physically. My lord, this is my affidavit of service. My lord, in the meantime, the respondents approached and told and gave 12 lakhs of rupees, my lord.
What I can't understand, what 12 lakhs of rupees?
12 lakhs of rupees they have given one-time payment, my lord.
This is a pre-reference 9.
Yes, my lord. Pre-reference 9, my lord.
So you are happy with the 12 lakhs?
No, my lord.
Then?
They have promised to pay the rest amount, my lord, by the next
So
month.
what is it that you want? Adjournment?
Adjournment, my
How
lord, for
much
4 weeks, my lord.
You're the advocate on record?
Yes, my lord.
The advocate on record of the petitioner submits that the respondent has already made payment of rupees 12 lakhs and has promised to pay the balance amount. Stop. The advocate on record accordingly seeks an adjournment on this basis. Stop. Next, list this matter after 4 weeks
4
as paid for.
Deeply obliged.
16, IDFC First Bank Limited.
My lord, this is my section 9 application. Yesterday, my lord directed to serve the serve the respondent with the supplementary affidavit, my lord. The service is not complete yet, my lord.
Learned counsel appearing for the petitioner seeks time on the ground that the respondent could not be served. Stop. The services of the supplementary affidavit of the petitioner. Stop. List this matter when?
Next week, my lord.
On 31st July 2023 as
Much
paid for.
obliged.
এখানে দাঁড়িয়ে থাকবে, ওখানে গিয়ে বসলে শুনতে পাবে না। Service is not complete. Stop. List this matter on 31st July 2023 as paid for. Next.
Much obliged.
17,
A similar order may be passed, my lord.
Same.
item number 18, Loan Builders.
He was filing for the notes, my lord.
Mr. Ray, I remember the point,
My lord.
29A. This is the one, 29A.
Yes, my lord.
Yes, but I just need you to just formulate your points, please.
My lord.
Note ta dao to na. Just 1 minute. Let me have your note first. Yes. What have you done? Again, these
judgments, my lord.
judgments are new or what?
No, my lord. These are all judgments which I have cited, my lord, just to make it complete, my lord, be annexed. If your lordship, my lord, I can take.
And have you referred to the relevant paragraph and all that?
Yes, my
in
lord,
the
that
note?
is what I will. Yes, my lord.
Yes.
And I've
Yes.
made it a bit, I mean, it's gone into a few more pages, my lord, because I thought, my lord, here I needed to make a note in that fashion, my lord. My lord, the point which I had taken, my lord, is that 29A can only be resorted to for coming to your lordship's court only before the expiry of the mandate. Why I have said this, my lord? 29A clearly mandates that where the award is not passed within that period of 12 months, my lord, then it would terminate unless by consent of the parties, it is extended under 29A(3). And that consent period is to a maximum of 6 months.
Thereafter, my lord, because that, my lord, extends the period of the mandate. Thereafter, my lord, it has to come to court if there is any further extensions required. I have specifically based my case on the point of the meaning of the word extension. Because extension means that there is something which is valid and that time period is being extended. It is not a case of renewal. And I have said the legislature has not permitted the court.
Renewal or resumption?
Resumption. But resumption also, my lord, would be only on the ground if there is a suspension. I am coming to that, my lord. But a suspension was therefore considered and not accepted. I'm grateful to my learned friend, he pointed that out, because that also gives me a further clarity in the matter, my lord, that if suspension was being considered.
That was the first report or the second report?
First report, my lord.
First.
176, where they were considering that suspension would only be considered because they considered that there would be a termination otherwise. So if it was not suspended, then, my lord, your lordship's powers would get curtailed. So they considered that. Irrespective of that, my lord, they did not include it in the main amendment, my lord. So I say, my lord, suspension has been considered, and therefore it would be, I know it is not only persuasive, my lord, it is not binding what the Law Commission report has said, but my lord, it would be a persuasion to that extent that suspension having been considered, the legislature did not accept it. Therefore, the words, my lord, are strictly to be interpreted. And I also said, my lord, the second proviso to 29A4, my lord, was again brought in 2019, saying that provided further that where an application is pending, the word is pending, not filed, the mandate of the arbitrator shall continue till the disposal of the said application. And why is this, my lord? Because, my lord, your lordship has the power to extend it either prior or after the expiry of the period. This has been the contention of my learned friend, that look,
But Mr. Ray, according to you, this is not suspension.
No, my lord.
These words are not suspension.
My lord, it does not say so, my lord, because that is what, my lord, the 176 commission report provided for a section. The original 29A, my lord, there the words were included as suspension. My lord, I have placed that it would be a part of it. That has not been considered, rather that has not been taken into contention and not as a matter of discarded, my lord. And therefore I say, my lord, when it says either prior or after the expiry, my lord, it talks about your lordship's power to extend this time period during the pendency of the mandate. Now, my lord, an application is filed, let us say the expiry is tomorrow, the application is filed today. Then your lordship can pass an order today. That makes it prior to the expiry of the mandate. But let us say, my lord, your lordship's business of the court does not allow your lordship to take it on that day. Your lordship can extend it thereafter, expiry. Why? This is provided for the proviso that once it is pending, the mandate continues here. They can continue. This is the legislature, the statutory extension granted by the legislature on filing.
Yes.
Therefore, my lord, that is the only way, my lord, it can be prevented from terminating. Because the question is, if there is no consent, or, my lord, the 12 months period expires, my lord, it would be in limbo, if I excuse my language, my lord. There would be nothing which would give them the mandate, because 12 months is the mandate. And now, my lord, considers after 6 months, my lord, or after 7 months, the parties come to your lordship and say, yes, we are giving a consent post facto. And then your lordship takes up another application is filed after, let's say, another 2 months.
Mr. Ray, the other way of looking at it is the entire purpose of 29A, as I see it, and you can correct that, is the momentum.
Expedition.
But on the other hand, what you are saying, if one of the parties or the respondent does not agree to the extension under 29A3, then what happens to the efficacy of the arbitration?
Yes,
it just stops.
No, my lord, I'm coming to that, my lord. This is the thing which has to be done, my lord. Today, my lord, 12 months period is pending. On 11 months, but I should, whatever, before that, my lord, the arbitrator has to seek the consent of both the parties. If one party does not give the consent, then, my lord, that other party, the disgruntled party who has given the consent, will immediately file an application before Lordship under 29A4. 29A3.
So that is before expiry of the 6 months.
Well, that is what I'm trying to come to.
Or is that before the expiry of the 1 year?
Before the expiry of the 1 year. I'll point out why, my lord. 29A3 is not a precondition to 29A4. 29A3 is not a precondition. If parties do not consent that 6 months extension, my lord, a party can come before Lordship on 29A4 for an extension of the 12 months after the 12 months. My lord, if your Lordship kindly sees the wording. My lord, 3, the parties may by consent extend the period specified in subsection 1 for making award for a further period of not exceeding 6 months. Now 4, if the award is not made within the period specified in subsection 1, now that is 12 months, my lord. On a 29(4), if your Lordship kindly.
Yes. Yes, I have it.
Within the period specified in subsection 1, that is one condition, my lord, which is 12 months. Or the extended period. It is not and, my lord. Therefore, 29A3 is not a precondition to 29A4.
Yes.
If someone within that period seeks the consent is not given, my lord, the court has to be approached within the mandate being alive under 29A4. And the arbitrator can continue. This is, my lord, to expedite the process. And after 5 months, 6 months, I don't give a consent, then it comes to your Lordship's court. This can happen after even 1 year. If the time limit is not.
See, the only troubling point is, as I keep saying, a rogue litigant or a rogue litigant who is faced with a statement of claim. All right. So at the receiving end of the arbitration, doesn't consent to the 29A3, says that I'm not going to, whatever, you do whatever you want. And then your answer is that then the petitioner should immediately come to the court under 29A4 and not let the arbitration go for a toss.
That is the provision. That is the provision. 29A4 has done, in my case, I don't think I'm a rogue litigant. With humility, it looks as if I'm a rogue litigant, but I've given a reasoning. Today, arbitrations are, first of all, it has a cost. And we do not know which way this award is going to go. Now, this is a statutory provision. Obviously, what your Lordship interpret, that's a different thing. It's a statutory provision. Consent was being sought for after the period the mandate had expired. So therefore, if I give my consent, which is not allowed in law, at the end, if my learned friend, client, is found to be on the receiving end, he'll take this as an inherent lack of jurisdiction. It would be an inherent lack of jurisdiction. Unless extended, in the manner provided for, it would be an inherent lack. And there cannot be waiver of any law. Section 4 will not stand here. Because this is a statutory right being given. And a rogue litigant will not have too much of advantage. Because this will go to 40-50 litigant, it will start off. Here, your Lordship is also to see whether the arbitrator has proceeded in the correct manner or not.
Very well. And
at 32, I've already said the arbitrator himself has said, I do not have any further thing to do. Approach, whatever. Again, according to
32, page 32.
No, the arbitrator in his last minutes has said,
Yes. That
and he says, act in accordance with law. He doesn't even ask the parties to come to your Lordship. He says, act in accordance with law. He accepts it. So that tantamount to termination itself. But these are my points. Because I have understood.
Yes, Mr. Ray. And lastly, how do you distinguish the Delhi High Court?
Delhi High Court, this point was not.
Which point?
The point of 29A4, the extension and the renewal part has not been considered at all. And I've shown the Delhi High Court judgments at the end says that the period before where the arbitrator acted is regularized.
No, that is the other one.
Both of them says the same thing. That is what I submitted before Lordship, that is absolutely yours, the provision of the law. And Delhi High Court is persuasive in nature. So it's not binding.
No,
to
no,
your
that is
lordship.
fine, but I like to distinguish judgments. If
My lord,
I'm
yes,
giving
my
a
lord,
yes.
there this point was not at all considered, my lord. But there this point was not at
Because
all argued.
I don't like this way of, saying facts are different, this, that.
No, no, my lord,
If it's a point of law, then you
the
should
point of
distinguish.
law has not been discussed there, my lord.
Yes.
Why I say, my lord, it has a persuasive value, not binding, because, my lord, even if it was this court, my lord, it would have been deemed acceptance that these have been considered and your lordship is bound by it. But there, my lord, it wouldn't be persuasive. Therefore, I can say that this point was not even discussed in that judgment.
This point as in the extension point.
Extension point. They have taken it as a matter of course that yes, it can be filed both ways and it can be extended. Extended means renewal. The distinction between extension and renewal, and obviously, my lord, with the 176 Law Commission report, my lord, it now becomes clear. And my lord, we have dealt with these judgments from paragraph 12 onwards, my lord. If your lordship allows me, my lord.
Very well. Paragraph 12.
12 onwards in my notes, my lord.
This Wadia is the one of Delhi, paragraph 13.
Yes, my lord.
Yes, yes. Yes. And what about this JWIL in?
And that is also, my lord,
Delhi.
this is the Delhi one, my lord. There was a consent of the parties, my lord.
Yes. No, I think in one of them, the respondent had said that no extension. In Delhi.
That is Wadia, my lord.
That is Wadia.
That is Wadia. But my lord, this section and my lord, the concept of an extension and renewal are different. That has not been considered. That was not placed before that court, my lord.
Very well.
Just 3 points.
Yes.
Very, very short. I'll be very short. With utmost love and respect to my learned senior friend, my lord, may I humbly submit, subject to your lordship's interpretation of this, that whatever is being submitted by the
you don't love and respect the interpretation.
No.
Of the court.
It cannot. No.
Whatever he
I'm
says, my lord,
saying
I am not conceding.
with your lordship is not decided, my lord. I'm saying, my lord, that the interpretation which is sought to be advanced by the respondent cannot even be remotely considered. The reason being a statutory provision to consider it as mandatory, the consequences of not following it has to be clearly specified and spelled out in the statute. If not, the consequences, if not given, it's a mere directory provision. So even if I take my learned senior friend submission to be correct, then also because the consequence is provided that what would happen if an application is not preferred after, then that would not make it a mandatory provision. That's my first limit. Second, the whole.
So you're saying if the words are shall, but the consequences are not provided,
given,
it will become directory.
It would become directory. And since those are not there in my note, I'm not carrying it right now, but I have judgments to, my lord, substantiate that. That, my lord, it's a directory provision. And may I simply give an example, my lord? In a respect of a commercial suit, the language in Order 8, Rule 1 is filing of the written statement, maximum period 120 days and not thereafter, and the defendant shall forfeit its right. So somewhat akin to that, these language has to be there in order to construe a provision as mandatory. If not, it's directory.
So you're saying that the termination, the mandate does not terminate.
I'm saying the submission that an application has to be filed before, and it cannot be filed thereafter.
Under
This analogy, under 29A4, this is even if this is correct, this is a merely directory provision, even if the submission is correct. So in any event, consequences of not filing that post-expiry or not filing in that pre-expiry, has not been provided for in the statute. So even if my lord accepts the submission of my learned senior friend, then also the petitioner before your lordship cannot be shunned. So even if I take the case to be the highest, then also in my utmost, in my humble understanding, my lord,
this provision cannot be said that it's a mandatory provision that because the petition is not filed before the expiry, the petitioner has to, the petitioner's application should go. That's the first link. Second is, what my learned senior friend's contention is that the application has to be filed before expiry. That is a period of limitation which is being provided for as per the interpretation of that. The statute does not provide a period of limitation.
Limitation?
For filing an application.
The time periods are provided under
Yes,
29A1.
but for filing an application and to shut out an applicant to come up with an application, there has to be a specific bar in the limitation, either in this statute or in any other law. So without there being a specific bar, like in a section 34.
So you're saying that it has to be spelled out.
Spelled out.
Under 29A4.
Yes.
That no application after 1 plus 6 months will be allowed. 1 year plus
after
6
1 year
months.
or after 1 year, in case there is no 6 months under 29A3 can be allowed. So that's limitation bar has to be clear and specific. But for that, there cannot. Like in a section 34 case, not thereafter. 3 months, 30 days, and not thereafter. So the statute prescribes that. And but for that, a limitation period cannot be interpreted in a statute by merely wordplay of the provisions. This is my humble submission. Your Lordship will test it, of course, but this is the answer to that in my humble submission. The other
Except that I don't want it to become a rogue judgment. That's the only point.
But this third issue is your Lordship would not deliver a judgment on the basis of a fact. It has to be a law which your Lordship would interpret, which would be applicable uniformly, either before or after. Now imagine a situation, my lord, that on the last day of the arbitration, on the 365th day, the arbitrator has the sitting. All along, the respondent had represented that they would extend. And in the evening, the respondent says, no, I cannot. So 365 days expire, the respondent does not extend. So the petition is out forever.
Why? 29A4?
29A4, then we did not file it before the 12 months expiry. Because the expiry is on the 365th day. In the evening, there is no scope of filing it before. And it's filed after. So it's gone for good. So that in my humble submission, possibly, where the autonomy is given to the parties to extend. And on the basis of party autonomy, a limitation period cannot be drawn into. That is my humble submission.
Mr. Gupta, the autonomy point I have thought about. The risk in that point is that if it is autonomy, then a party can equally have the autonomy to say, no, I will not extend.
Absolutely. So the party on the 365th day says no. That means the claimant is gone forever to seek an extension under 29A. It has to then follow either the route of 14, 15, whichever it is. But for extending the mandate, the petitioner cannot thereafter. Because on the 365th day, the party has said no, which they are entitled to.
So you're saying that the petitioner will then be shut out from 29A4 as well?
Absolutely. If the interpretation of my learned senior friend is taken as correct, then that would shut out the petitioner. So in other way, if your Lordship looks at it from a different angle, a limitation period is being imported in a statute on the basis of the whims and fancies of a respondent, which in my submission, in my humble submission, possibly cannot be the case.
The only problem is that the word under 29A4 is extend.
Yes.
Extend presumes that there is something existing which can be extended.
Absolutely. But at the same time, your Lordship will see the scope of section 29A and the other provisions of the and general provisions of the Arbitration Conciliation Act. The act has been couched for speedy disposal and for continuance. The act does not prescribe for shutting it out. So, my lord, if this interpretation is taken as, my lord, correct, then this would possibly, my lord, give the scope or give the leverage to, my lord, rogue litigants to, my lord, shut this out on the ground that the extension is not there. And because it expired, you cannot do so. So your Lordship would possibly, my lord, think it from that angle as well, in trying to, my lord, interpret this provision. And one of the fourth point is the second proviso to 29A4 has been interpreted to mean that where a proceeding is pending under 29A, arbitration can continue. So this does not say that the proceeding has to be filed before or after. So once the proceeding is filed, it can continue. If the court is of the opinion that no, that mandate cannot be extended, it may so happen that my lord, considering a 29A application, feels that it cannot be extended for XYZ reasons. Then that can be undone always. But this gives once again, and this is possibly inures to my benefit, this second proviso, that the intention of the legislature is to continue the proceeding and not to put it to an end. So, my lord, this mere filing of the application shows the intention of the claimant or the applicant, rather, it can also be the respondent or the applicant, to continue with the proceeding, and the legislature respects that and puts in this proviso permitting that proceeding to be continued. So that, in my humble submission, possibly would be in aid of the contention of the petitioner that this can continue.
Very well. Mr. Ray, 2 points. You please answer. One is you must be expecting the 365th day argument. And number 2 is the related, is the continuity aspect.
Yes, my lord. My lord, as I said, my lord, this, my lord, your lordship kindly takes note that 29A requires an award to be published within that specific period. If it is not, it is termination. That is the consequence. It is given under 29A4. Either unless it is extended by your lordship. The word again is
By the parties first and then by the court.
Well, no, my lord, with humility, my lord. It can be by the parties. If not by the parties, by the court. But if that period of 12 months has expired and it has not stood extended by these two provisions, the word is the mandate of the arbitral tribunal shall terminate. Let us test it on that angle. Has the award been published within 12 months? No. Has there been a consent of 6 months? No. Has your lordship passed an order? No. Then we'll have to go back. Now I'm trying to argue my learned friend's case. I just try. I think that is a better way. Then I'll have to go back to the proviso, the second proviso. Then I'll have to go to the second proviso that an application has filed, therefore I can extend it and I can continue. Now, then again, the question of extension comes in. And when can it be extended? If the matter has been filed, for your lordship to extend it. My lord, with humility, today, what your lordship will be doing, my lord, kindly does not take me amiss, my lord. I'm saying your lordship will not, excuse me, but your lordship will not be extending it. Your lordship will be renewing the mandate.
Mr. Ray, if a litigant, not you, were to say on the 365th day that I am not going to extend, then what happens? Then the 29A4 also goes?
That is why I'm saying, my lord, this is something, my lord, which requires, my lord, litigants to be diligent. My lord, Mr. Gupta, therefore, while he was making submission, very candidly says that the arbitrator was given an impression that it will be extended. But on the 365th day, he comes and says, I'm not going to extend it. But the arbitrator has to take this consent much prior to allow the parties to come to court, or in this case, come to court. That is the diligence which is required. But it kindly considers what would happen, my lord, if this application, I'm just seeing a very extended hypothetical situation, my lord. The application made after 5 years. But the consequence is, my lord, this 29A4 is to prevent an arbitrator from delaying or not acting in terms of the time limit set. then what would happen, my lord? Then I'm asking myself, well, then your lordship will extend it then? My lord, it has to be a sufficient cause. Let us say it was proceeded with. Then, my lord, the requirement under the act, the expedition, is no longer there. Rather, in this case, my lord, parties will be diligent. They will come before your lordship within that period. Your lordship will set the time period again. Not 6 months, maybe 3 months, my lord. There's a lot of things going on in this. And my lord, it is, as a matter, I'll tell your lordship, my lord. Now I'm just going off the matter, my lord. It has its positive effect. I am seeing it. I'm sure Mr. Gupta is seeing it. Oh, he has not yet seen.
No, but I don't usually give 6 months in any order.
But that is
in,
why,
in any matter.
Malad, that is what I'm submitting, Malad. Your lordship is.
Of course, if I see that the arbitration has commenced in 2023, then I give it.
Malad,
But if I see it's commenced in 2018, 2019, then never.
I'm very grateful, Malad. Your lordship, that is the expedition which is required. And that can only be achieved if there's a time limit. And that is the word has been used as extended. And my learned friend suddenly says that this is not a mandatory provision. Well, it is completely mandatory, 29A4. If it is not extended, well, it is terminates. That is the consequence. Though he had not argued this earlier, but I'm just replying to this. 29A4 says that the award is not made within the period specified in subsection 1 or the extended period. So that takes into contention there's an extension. Period specified in subsection 3, the mandate of the arbitrator shall terminate unless the court has either prior to or after the expiry of the period so specified, extend the period. So there was a dilemma on this. Now this has been stopped by the further amendment coming in 2019, which says only if it is filed, then you can proceed. Pending. The word is used pending.
I will come to Mr. Gupta.
Possibly, this is not what I had submitted. That's why that provision mandatory. I have not stated that. That is
yes.
I've said some other provision.
Now, Malad, the next thing is, Malad, is it? Malad, with humility, I've only said, Malad, it is not on the parties. Limitation is not being set on parties. I'm only saying, Malad, but kindly does not take me amiss. What is the power of the court given by the legislature? It has got nothing to do with limitation.
You're saying humility because the court doesn't have the power. That's what you're saying.
Malad, that is what what would mean from that, Malad. That's why, Malad, because we have to see a lot of things which might not sound good, Malad, but that is what
that is fine. I
Malad,
will just
not your lordship,
interpret
Malad,
the law. That's all.
That is why, Malad. If it would have allowed your lordship to renew, then that is fine. But that is not allowed because there's a provision for that. 14 and 15. They have to go back to the original rules and appoint the arbitrator. The only way your lordship, Malad, can hold on seeing that this arbitrator within that period fixed for him has not acted properly can substitute here. And not for any other purpose under 29E. So the powers given to your lordship is to extend, not to renew.
And what about the other submission, the interesting one, that if the consequences are not provided for, then it becomes directory.
Well, the consequences are provided for. Terminate. 29A4 clearly says so. Unless extended. Now, already your lordship, again, we are coming back to that definition, extended.
Yes.
And my learned friend has made a submission on shutting out a litigant. Well, this will not shut out a litigant. The litigant has to be diligent. Let us come to the facts of this case, Malad. If my learned friend's client had been diligent, he would have taken the point before the tribunal. Has he done that? I'm asking myself this question.
No, I'm really sorry. My learned senior friend was not there in the arbitration. All along, the impression was given by the learned senior advocate appearing for the respondent that it would be extended as a matter of course. So I do not think my learned senior friend should make this submission. I was there in the arbitration.
No, I will not even, this is not the 365th day anyway.
No.
So I will not take that.
So it was all along given that it would be extended on the next day. The next sitting got cancelled. That is why the sitting before the 12 months got cancelled. That is why the whole problem started.
And the 29A3 Mr. Ray's client did not agree.
Did
for
not
the-
agree
that's
because that
seven-
was done after the 12-month period, because the sitting which was scheduled before the expiry of the 12-month period, the last sitting, that got cancelled. And all along the impression was given, yes, record the consent, not a problem. That's not a problem.
My
That
lord,
was never an issue.
my lord, first of all, my lord, Mr. Gupta with lot of vociferous submissions has made this, but I think he should look into the records, my lord, that on 7th of February 2023, before the expiry, we had called upon for a sitting, which was not agreed upon. The arbitrator did not take steps also. So to say that,
Exactly, I'm saying that.
just a
Before-
minute, Mr.
I'm sorry.
Gupta, may I? To say that we have been the rogue litigant may not be correct. We asked for a sitting, and my lord, if we had always given this impression that yes, we will extend, why was it not recorded? Why was it not recorded? That is the scope. That is the consent to be recorded. My point is very simple, my lord. Now the arbitrator's 12 months period is over. Can I give a consent now or not? It has not been recorded, my lord, today on the facts of the case. Now I have to give a consent post 12 months. Can I do that? Am I allowed in law? I'm on that one. The law, according to me, my lord, cannot allow that because it's a consent to extend again. And this is not a case of a rogue litigant, my lord. We do
Yes.
not know who would turn a rogue later.
As I said, a rogue judgment can also be there.
Yes, my lord, kindly, my lord, I am only harping on the point of the time limits to be interpreted for expedition purpose. It has to be expeditiously done. What my learned friends are saying, that can give the court powers to even extend after, my lord, 2-3 years.
Yes.
And if what I am saying is, my lord, is correct, my lord, within the extended period by the parties, then, my lord, your lordships would have that power to curtail that time period. It cannot be after 2 years.
Very well. Understood.
Those are my submissions, my lord.
Yes.
May I file the notes?
Yes. Learned counsel appearing for the petitioner and the respondent have indicated their respective points by way of short notes. Stop. List this matter on 9th August 2023. And Mr. Ray, what is nothing about this. Is the 3 months a problem? Then I will review that stand.
No. But I respect it, my lord.
No, you said it's
my
led to a
lord,
lot
it
of
is- No, it's not a problem, my lord. If your lordship allows me to be candid.
of course.
But then I might say a lot of things, or whatever it is, but I won't say everything because then my arbitrators will be not too happy with me. My lord, arbitrations, my lord, take time nowadays. So, my lord, there are arbitrators who are giving time. As a matter of fact, parties are saying that I want to appear, even though they are not arguing.
I want to appear.
I want to appear. Let us say, my lord, now the dates are a problem. Now, let us say I am appearing, I am submitting. So, obviously, my dates are required. Maybe the other side will say, no, I want to be there. Now, that's extended again because the other party wants to be there, though not required. So, your lordship, my lord, the arbitrators now have a weapon in their hands that your lordship is not extended more than 3 months. So, that allows them to be not too
Lenient.
Consider, yes, my lord.
Lenient.
So this is a good approach, my lord. That is what I'm saying.
I thought it was a problem for the
No, my lord.
arbitrators.
It becomes it is the right way, my lord. Or else, my lord, these arbitrations are going on.
But may I pray for an extreme indulgence, my lord? Could it be on 10th or 11th, whichever day, instead of the 9th? My learned senior
Yes,
is-
yes, of course. 11th August 2023
I'm
as
so
prayed.
So,
Yes, call on the next matter. Thank you, both of you.
Very good.
Mr. Ray, Mr. Gupta. Yes.
Item number 19, Complement Blends Private Limited.
May it please your lordship, this is my application under section 29 capital A subsection 4. Now, your lordship, may I just indicate some of the important?
Miss Banerjee, are you agreeing or not agreeing?
My lord, I am agreeing.
You're agreeing? No, because you were listening to the other matter with a lot of attention. So
Yes,
I
I
thought-
am, my lord, and I agree with what Mr. Gupta was saying, but since I am not the petitioner here, my lord.
Yes.
Your lordship, may I indicate some
No,
important?
first, why do you just want an extension?
Yes,
That's
your
all.
lordship.
When did the mandate terminate?
Your lordship, on 4th June 2023. This is a 12 plus 6 months. After that, 4th June.
So 1A and
Yes, your
1-3.
Yes, your lordship.
29A1 and 29A3. So the 1 plus 6 months ended on 4th June 2023,
Yes, your lordship.
terminated.
Yes.
Then what happened?
Your lordship, thereafter on 13th, at page 130. Your lordship, a 34th sitting of the tribunal had taken place on 13th June 2023.
Why are you saying 36 sitting?
Your lordship, I'll tell, I must respectfully submit. The issue whether the mandate of tribunal had expired or not had come to the knowledge of the parties on 13th June 2023.
Why? You're saying that the party is.
Yes, your lordship. Your lordship may kindly take page.
Forgot to calculate.
Page. No, your lordship may kindly take page 135.
What is the point? Just tell me, please, first.
Your lordship, 4th June 2023, the mandate had expired, but the parties realized this fact on 13th June 2023. In the sitting held on 13th June 2023, it is recorded that the issue of the mandate of the tribunal has cropped up and the parties have decided to move before the Honorable Court for extension.
Under 29A4.
Yes, your lordship, under 29A, 29 capital A subsection 4.
Very well. What is the stage of the arbitration?
Your lordship, the claimants have begun the submission on the final merits of the matter.
What do you mean, arguments?
Arguments. We are at the argumentative stage.
Arguments.
Yes,
You
your
have just begun.
Yes, your lordship.
And arbitration is continuing till from?
4th June.
4th September 2019, my lord, it was constituted. And pleadings were completed 18 December 2019.
So if it's 18 December 2019, then how can the 1 year plus 6 months be 4th June 2023?
Your lordship, may I submit on that? 18th
Has
December.
to be 1 year from the date of completion of
Yes, your lordship.
pleadings.
18th December 2019, the pleadings was completed. From there onwards, we had 12 months time for making of the award. However, 18th December 2019 to 14th March 2020, about 87 days were exhausted of the balance 365 days.
Supreme Court order?
Yes. Thereafter, 15th March 2020 to 28th February 2022, because of the Supreme Court order,
So 83 plus?
87 days were exhausted. Thereafter, when the clock again resumed on 1st March 2022, we add 278 days, and on 4th December 2022, the 1 year period had expired.
4th December 2022.
Yes, your lordship.
Mr. Dutt, anything else? Ms. Banerjee, you're agreeable to the extension?
Yes, my lord.
Yes, how much? So you have just started, Mr. Dutt?
3 days of I've argued and take another
2 sittings. Ms. Banerjee?
My lord, will,
of the whole 3.
my lord, depending on what they argue, my lord, I cannot comment, but of course it should finish within another.
Name of the arbitrator, don't tell me, don't announce it in court, just show me a
Page 134.
Very well, yes, I've seen it.
The list of dates that we want 36.
This is an application for extension of the learned arbitrators mandate under section 29 hyphen capital A within brackets 4 of the 1996 Act. Stop. Next, according to learned counsel appearing for the parties, comma, the 1 year under section 29A1 within brackets expired on 4th December 2022 after taking into account, after factoring in FACTORING, factoring in the exemption from the periods of limitation under the general and special laws given by the Supreme Court in the suo motu writ petition by the order dated 23rd March 2020, which was to be given effect from 15th March 2020. Stop. The limitation ended, the period of relaxation ended on 28th February 2022. Stop. The petitioner hence calculates the 87 days before 15th March 2023 and the balance days after 28th February 2023 to say that the 1 year expired on 4th December 2022. Stop. Next, the additional 6 months expired, the additional 6 months under 29A within brackets 3 expired on 13th June, on 4th June 2023. Stop. The parties, however, realized the termination of the mandate in the sitting held on 13th June 2023. Stop. Next. Learned counsel appearing for the respondent does not oppose extension of the mandate as prayed for. Stop. The court is informed that the petitioner / claimant has commenced arguments and will need another 3 sittings to complete the arguments. Stop. The respondent will resume. The respondent will commence the arguments thereafter. Stop. Next, since parties are add item on the point of extension on the prayer for extension of the arbitrator's mandate, and the arbitration has advanced to stage near completion, comma, AP 479 of 2023 is accordingly allowed and disposed of by extending the mandate for a period of 4 months from today. Stop. How much did you pray for?
Your Lordship, we had prayed for 6 months. Page 12 is the prayer.
It's a tribunal. Yes. Next.
Item number 20, Blue Dreams Advertising.
I'm for the petition. Lordship, this is.
I can't hear you. Microphone, please.
Application under section 29A. The pleadings were completed on September 2022. Pleadings were.
If you give such vague submissions, I will impose costs on you. You know, the 29A is a matter of dates. Don't say September 2022. It's a matter of dates.
Lordship.
What do you mean September 2022? If you're not ready, take time.
No, I'm ready, Lordship. May I? The pleadings were completed on 22nd September 2021. Thereafter, the 6 months expires on 21st March.
If the pleadings are complete, then you first have to calculate the 1 year under 29A1. Learned counsel appearing for the petitioner needs to get ready.
29A1.
Needs to get ready in the matter. When will you come back?
Lordship, I'm ready in the matter.
You're not ready in the matter. You haven't even read the section 29A1. Yes, when will you come back? Ready?
Tomorrow, Lordship.
Please this matter tomorrow. Next. Pleadings are complete, then you're straight jumping to 29A3. You have to first.
May I get a chance?
Yes.
May I?
You will get a chance only for 2 minutes in this court. Next. Call on the next matter, please.
21, Damodar Valley Corporation.
My lord, this is, my lord, an application under section 34 and a section 36, my lord, too. My lord, they have taken a point, my lord, with
Both
regard
for
to.
stay and setting aside.
Yes, my lord, my lord, they have taken, my lord, what my lord is hearing now, my lord, they have taken a point, my lord, with regard to jurisdiction of this court. And
Yes.
this is
What are the
because,
two applications, GA1 and GA2?
my lord, GA1, my lord, is my application, my lord, for stay
Yes,
under section 36, and my lord, GA2 is, my lord, on a question of jurisdiction that this court doesn't have jurisdiction.
yes, so
Lovely.
that's their application.
Yes, my lord, will recall, my lord, there are two clauses
The
here.
seat, yes.
Yes, yes, absolutely. That's the point, my lord.
The South Kolkata, North
Yes,
Kolkata or something.
yes, my
Yes.
lord. Lord, I don't know why, my lord, they, in the clauses, they put terms like that, Kolkata, then, my lord, South 24 Parganas, then New Alipur Court.
So you're relying on the second agreement
I'm relying on the first agreement. On the
first, and
basis
they're
of
relying on
which,
the second.
or rather, my lord, they're relying on the first, I'm relying on the second, the final one. And my lord, that is the contract on the basis of which, my lord, section 11 arbitrator was also appointed, the one I'm relying on.
And you invoked the arbitration clause in your 21.
They had invoked, my lord, they are the
And
claimants.
which one did they rely on?
They relied on the clause I'm relying on now. And that is, my lord, section 11, my lord, shows that. Clause 16, my lord, is the clause. And that's the only one, my lord, which talks about arbitration and venue of arbitration. Otherwise, my lord, the other clauses don't, my lord, talk about that. But there's a clause, my lord, with regard to saying that all suits will be, my lord, in clause 16, it says all suits will be it will be Kolkata. The other ones say that all suits will be, my lord, that other clause, my lord, complicated South 24 Parganas, New Alipur Court and all that.
So your other contention is the ambiguity.
I am saying, my lord, that venue means seat. So that clause will be governing all arbitration matters. That's my first submission.
Yes. And
And
the
that's the
dismissal is because this court does not have
Yes,
jurisdiction.
yes, yes.
Yes, very well. Mr.
Well,
Banerjee, just
Yes,
formulate your
yes.
point.
My lord, can I, my lord, show, my lord, quickly just to
What is this table at page 9,
page 9.
paragraph 17?
My lord, that's, my lord, the sitting list, my lord, which is there in GA2. As to where, my lord, the arbitrations were,
No, so you want me to look at GA1?
my lord, GA2 is, because that's the application to challenge, my lord, the contract agreement I want to show,
This is the dismissal application.
dismissal application. Kindly, my lord, come to state, my lord, the contract agreement is, my lord, 30th April 2018. And
That's at page 56.
51 at 56, absolutely. my lord.
Yes.
If it just looks at that clause once, my lord, then I'll be.
Venue shall be Kolkata.
Yes, no, yes, venue shall be good. Any disputes or differences? In the event of, and this is the only clause, my lord, which deals with arbitration. Kindly see, in the event of disputes and such, arbitration and the venue of arbitration shall be at Kolkata. And the next it says all suits arising out of the annual rate contract and agreement, if any, are subject to jurisdiction of court in the city of Kolkata, only and no other court when resolution, settlement through mutual discussion, arbitration fails. And then also kindly look at.
No, what are courts in the city of Kolkata? Any courts?
Well, that's what, my lord, city of Kolkata, my lord, so far as, my lord, the city civil court is concerned, that's the only definition, my lord, we could get, which says, my lord, that's within the jurisdiction original. So, my lord, it will be, my lord,
So
High
this
Court.
is the jurisdiction clause.
Jurisdiction clause.
And the arbitration clause is above. the
Yes,
one
venue
above.
of, that's right.
Yes.
Venue of arbitration shall be at Kolkata. So we are saying, my lord, at Kolkata venue means that seat. Seat means you have to come to the Calcutta High Court if the pecuniary jurisdiction, my lord, is here.
What does the Supreme Court judgment say? Venue is equal to seat, or seat is equal to venue?
Venue
When
equal to
one
seat.
is not
BGS, my lord, that's
specified.
BGS Soma.
Soma.
My lord, we have, my lord, some judgments, my lord, Calcutta High Court, one judgment they have relied upon, where, my lord, it seems, just my lord, where it seems that the learned judge has given priority to, my lord, a forum selection clause more than, my lord, the arbitration clause. Which, my lord, in my respectful submission is perhaps, my lord, not the law, my lord, which as laid down, my lord, by BGS Soma. But there are other Calcutta High Court judgments, my lord, where the arbitration clause, arbitration venue clause has been given priority because it relates to a matter in arbitration than, my lord, the general forum selection clause.
No, BGS Soma, that's Justice Nariman.
Yes,
That says that if if one of the two is not specified, then the other will mean seat or
Correct.
venue or something like that.
Correct, correct. But here, my lord, nothing is said about seat. So it says venue shall be Kolkata, which, my lord, we are equating it to seat because that's what, my lord, the judgments appear to be saying. And that's how, my lord, I do not see any conflict. I'll tell my lord why. Because if you rely on clause 16 is very clear that city at Kolkata, my lord, will have jurisdiction. In this application, what they rely upon is, my lord, kindly come to, show me that other clause. My lord, page 71. This is a contract, my lord, which is
That is the one which they're relying on.
that they're relying on, 23rd March 2018. And that causes a little bit of confusion.
No, the jurisdiction clause is the same, except that it
So,
says
two
South
th-
24 Parganas, New Alipur
Yes.
Court or something.
Two things, my lord. First of all, my lord, will not find any clause with regard to the arbitration at all. This is important. It doesn't say, my lord, venue of arbitration, nothing.
Even though the heading says and arbitration.
Yes. And then in it says all suits arising out of annual date contract in a subject jurisdiction of court in the city of Kolkata, South 24 Pargana, New Alipur Court, India, only and no other court when.
But they did not rely on this when they invoked.
Correct. That is, my lord, straight away, my lord, page 48. And we had given production, my lord, of the section 11 application as well.
Yes.
It's part of the records. My lord, sees by this sorry, my lord, say for page 48.
Yes, yes, please.
By this application under section 11(6) of the Arbitration Conciliation Act and such, petitioner approached this court for appointment of arbitrator to adjudicate the disputes between the parties relating to the annual date contract agreement dated April 30th, 20.
Yes.
And then, my lord, will find, my lord, it is in the next page also, page 49. Mr. Sansach, learned senior counsel, the third paragraph, my lord, second paragraph beginning on that page.
Yes.
Learned senior counsel appearing on behalf of the respondents could not dispute
Yes.
existence of the arbitration agreement contained in clause, let's say 16.
Yes.
Clause 16 of the said agreement dated April 30, 2018, how and where the law laid on such. And my lord, even there, the chart which they give there also, my lord, will find, my lord, most arbitration sittings, my lord, were held, my lord, in Kolkata, my lord, except for one.
Yes. So why would they give the chart if they, what do they want anyway? They want 24 Parganas, South 24 Parganas.
Yes. They might not say that either they should go to, my lord, Raghunathpur, my lord, which is my office, or, my lord, South 24 Parganas.
Yes.
That is, my lord, what their prayer, my lord, is return the Sansach, not having jurisdiction. And the chart, my lord, they really show that by saying that 38 out of 66 have been held virtually. That's what they say. But that is neither here nor there, my lord, because the others, my lord, if they're held, my lord, in Kolkata, my lord, then also shows, my lord, that venue was, my lord, given importance.
So, Mr. Banerjee, your point is that the venue is Kolkata. Therefore, the seat will also be in Kolkata.
Yes.
And you're relying on a judge.
Yeah, I'm relying on, my lord, some judgments, my lord. I'll just show that. But, my lord, just to complete that, I'm sorry, my lord, I just, since I, my lord, went away, my lord, from that page 50, 6, my lord, there's another clause. Can you see 18G also?
Page?
My lord, 56 itself at the bottom. It says legal suits arising out of the agreement, if any, are subject to jurisdiction court of the city of Kolkata, no other courts elsewhere. And it uses the word legal suits.
Yes.
So venue and legal suits. And what they rely on, my lord, is the clause all suits arising out of, which, my lord, we say, my lord, is not, my lord, something, my lord, which deals with the arbitration then. Because their clause also, my lord, no venue, but only all suits. The language used is, my lord, all suits. So my first submission, my lord, just, my lord, factually, my lord, to cover up my submission, I'm saying, my lord, that you can only rely on the annual rate contract.
That's the 18.
Yes, the contract agreement, not, yes. That's the 30th April, sorry, contract agreement, 30th April, 2018.
Yes.
Annual rate is the other one, sorry. Because that is the basis on which
Yes.
arbitration has started. And there we can only look at clause 16 and clause 18 G,
Yes.
where venue of arbitration is what covers the jurisdiction for arbitration and applications relating thereto.
Yes.
And also 18G says legal suits arising out of the agreement. My second submission is
So legal suits, how would that help you, Mr. Banerjee?
Well,
Just the jurisdiction.
just the jurisdiction. I'm also not sure, my lord, what does legal suits in that sense mean.
Yes.
But my lord, because the other clause, my lord, I find all suits arising out of the annual rate contract. So, my lord, I want to, my lord, quite naturally, my lord, I'm submitting them, my lord, this clause should be really ignored because we are not on all suits now. We are really on question of arbitration and proceedings relating there.
Yes.
Because one of the judgments, that's why, my lord, I'm just making this distinction because Justice Boshak's judgment, my lord, actually says that, my lord, this kind of a forum selection will override an arbitration clause, which, my lord, may not be, my lord, with the greatest respect, my lord, to the learned judge, my lord, may not be, my lord, really, my lord, the correct proposition. And I'll show, my lord, the later Supreme Court judgment also to deal, my lord, with their, what's that, Ravi Ranjan, which, my lord, goes back to PGA Soma and covers, my lord, or, my lord, really, my lord, follows or, my lord, looks at BGA Soma itself. Now, my lord, will kindly, so, my lord, that is, my lord, what our submission is. Secondly, my lord, I submit, my lord, that the annual rate contract 23rd March 2018 is not to be looked at because that is not the basis on which
Yes.
that is not the basis on which you came to court. And this is also, my lord, clear.
And this is, they came to court with a section 11.
Section 11. My lord, in section 11,
Yes.
my lord, my lord, this is, we had given
Production.
copies of AP 595. A copy would may be there.
Have they mentioned the other one at all or not? Or
Yes,
only?
very interesting. My lord, what they say it's overtaken. My lord, they say,
Just 1 minute, let me have.
I'm sorry, my lord, sorry. AP 495.
It's not here before in the record.
We had, my lord, handed over a copy. Do you have a copy? My lord, we'll find out my lord's copy, my lord. In the meantime, my lord, can we just hand over a copy? My lord, we'll
Yes,
just find
yes.
out because that's the. Just এখানে দেখুন আছে বলে এরকম একটা হবে জাস্ট একটা অ্যাপ্লিকেশন সেকশন 11 মানে অ্যানেক্সার বাই এই হিসেবে রাখা যাবে
Yes.
well kindly come to page 6 sorry page 4 they said the Sansach paragraph 6 said annual rate contract contained and issued over contained arbitration clause 32.
No, they say thereafter on 30th, a formal contract was executed. Paragraph 9.
Yes, absolutely. And then Malad sees paragraph 10 also. And they set out clause 16 Malad in paragraph 11.
This is page 56.
Page 56, correct. And then Malad sees paragraph 12. I think Malad that really seals Malad their
Wait.
I'm sorry. Paragraph 12 Malad page 9.
Yes.
The arbitration agreement contained in the annual rate contract merged into the arbitration agreement contained in the agreement contract dated 30th April. The arbitration agreement.
So
contains-
clause 16 is the final agreement?
Yes, yes.
That's what they're saying.
Yes. So they can't go away and then try to rely on the earlier annual rate contract.
So here they're just resisting your
34 and
34 and
36.
36.
To say jurisdiction should be somewhere else. I don't know why, my lord. I'm not, my lord, understood. I'm sure, my lord, they must be. Because we have suffered and we wanted to, my lord, give, my lord, the security. They are, my lord, resisting, my lord, for, my lord, now with regard to jurisdiction as well. Now, my lord, kindly take, my lord, BJ's. Let's have copy here. My lord, may I, my lord, first show, my lord, BJ's Soma, and then, my lord,
That's page 23 or 28?
my lord, in our compilation, my lord, maybe will be page
23.
29.
Twen-
23.
This- very good.
Oh, my lord, I think they have also given, my lord, a
Yes.
compilation. My lord, here, my lord, paragraph 2, page 46. And my lord, 47, my lord, will find the clause. Clause, my lord, placitum D, my lord, will find, or marginal note D.
That is running page?
My lord, running page, my lord, 47 at the top right, and if my lord has taken, my lord, R, another completion page. I'm sorry, I don't know which. my lord.
47. I'm looking at your compilation.
Yes, my lord. Then, my lord, 47, my lord,
Yes.
it should be 252 of the reports, page 252 of the reports, and my lord, clause 6, my lord, is the arbitration proceedings, placitum D.
Yes.
Arbitration proceedings shall be held at New Delhi, Faridabad, India, in the language of the arbitration. So held at New Delhi, Faridabad. Then, my lord, will straight away come to and here also, my lord, there was a question of, my lord, return of, my lord, the question. Then kindly come to paragraph 61, if I straight away. 54, paragraph, my lord, 49, my lord, at page 76 is, my lord, Balco is discussed. My lord, I think, my lord, I'll straight away show 60. I'm sorry, my lord, may I show, my lord, from 57 at page 82. Just to show, my lord, how they rejected Antrix, and then, my lord, the High Court, Bombay High Court judgment.
This is the Devasantrix.
Yes, my lord. Yes. It's item. Yes, my lord. Antrix, my lord, Devas Multimedia.
Very well. So they
Rejected that
Antrix
view.
was rejected.
Yes, 57. Then, my lord, sorry, my lord, may I just show at page 83, thus Balco, my lord, at the top, placitum A, thus Balco does not unmistakably hold that two courts have concurrent jurisdiction, that is the seat court and the court within whose jurisdiction cause of action arises. What is missed by this High Court judgment, subsequent paragraph in Balco, which clearly and unmistakably state that the choosing of a seat amounts to choosing of the exclusive jurisdiction of the courts at which the seat is located. Then, my lord, 58, 59 is.
So says that High Court should have held that once the parties choose a seat, then the location is also there.
Absolutely. So, my lord, another forum selection clause, my lord, will be, my lord, then with regard to the contract itself, my lord, which is outside. And in fact, our clauses, my lord, must have noticed, my lord, it says if arbitration fails,
Yes.
all suits arising out of if conciliation or arbitration fails. That is, my lord, what it says. I don't know how, my lord, arbitration fails. It will come back to civil court, but that seems to be one of the clauses, my lord, even in our contract. Then, my lord, kindly look at, my lord, 60, page 84, paragraph 60. And kindly see 61. So now, my lord, they're determining seat. It will thus be seen that whenever there is an
So this is what will apply in the present case.
yes, whenever there's an express designation of a venue and no designation of any alternate place as a seat combined with a supranational body of rules governing the arbitration, no other significant contrary indicia, the inexorable conclusion is that the stated venue is actually the juridical seat of the arbitration.
And what is the supranational body of rules?
My lord, here, my lord, of course, my lord, we don't have a supranational body of rules, but there, my lord, the Delhi, I think, my lord, the Delhi High Court, my lord, the
Yes.
and then, my lord, 82 and sorry, 65. That's, my lord, paragraph 65. Again, my lord, kindly look at, my lord, paragraph 65, page 86. Not required. I'm sorry, my lord, not required. My lord, 65, though I marked it, I don't think, my lord, that is, I'll trouble my lord with that. So 82 is, my lord, what, my lord, we can just straight away come to, and my lord, and that's at page 96. This is, my lord, the conclusion, my lord, of the on a conspectus of the aforesaid judgments, it may be concluded that whenever there is the designation of a place of arbitration in an arbitration clause as being the venue of the arbitration proceedings, the expression arbitration proceedings would make it clear, this is, my lord, very important, would make it clear that the venue is really the seat of the arbitral proceedings.
And plus the last 4 lines.
Yes. This coupled with no other signal contrary.
But that is more with with regard to the international
In the internet.
commercial.
But what I'm showing, my lord, here also, my lord, sees no other clauses in the contract has, my lord, anything to do with venue of arbitration. Only clause 16 has, my lord, venue of arbitration.
Yes, last line at page over the page 97.
In a national context, this would be replaced by as applying the stated venue, which then becomes seat for the purpose of arbitration. Grateful. So BGS Soma, my lord, is quite clear. And I don't know how, my lord, the courts, my lord, then can interpret by saying that if there's a forum selection clause, because the forum selection clause really applies to suits. Suppose, my lord, I was to challenge today, my lord, the arbitration agreement itself by saying it's fraud. In some cases, my lord, fraud, even in domestic, my lord, remembers, my lord, that Justice Banerjee's judgment, then, my lord, affirmed by the division bench also, where we filed a suit, my lord, and, my lord, to get, my lord, at question, my lord, that it declared that it's a unenforceable or, my lord, an illegal contract. So those clauses, my lord, can govern that kind of situation. But when arbitration comes, it is only, my lord, venue and seats.
Yes, forum selection clause may not be that relevant in a 9 or a 34 or a.
I'm grateful, my lord. That's, my lord, the submission, my lord, because that's exactly, my lord, what we'll find, my lord, is to the contrary, my lord, in the other judgment. And some of our courts, my lord, have also held that actually the arbitration seat will really apply. And Delhi High Court has also held, my lord, we have 2 Delhi High Court judgments. My lord, this is BGS.
Mr. Banerjee, how much more time will you take on this?
My lord, I've got about, my lord, 3 judgments. We have Delhi. My lord, I can come back, my lord, once. 3 judgments, my lord, because I just.
Yes, on the same point.
On the same.
That if the venue is
Yes, yeah.
signified and not the seat, then the venue will become the seat.
On the question, my lord, that the venue will govern, will overtake any other forum selection. So venue equal to seat, and then that will overtake. Correct. So just want to extend the.
In this case, the other forum selection clause is what, the city of Kolkata?
No, the other forum selection clause is
South 24 Parganas.
South 24. But that's in the other contract.
Yes.
And that is important. I'm saying you overrule, you don't look at that contract at all.
The March contract.
The March contract.
And you're on the April one.
I'm on the April contract. I'm saying April contract is very clear. There's no contrary indicia, it's only this.
Yes. Sorry, you were, Mr. Who was up here? Mr. Kaur was
Mr.
appearing?
Kaur is.
Yes.
Lord, any other day, my lord, I'll finish and then Mr. Kaur, my lord, if he wants to rejoin, my lord, he can rejoin, my lord, on that day perhaps.
Learned Counsel has placed a decision of the Supreme Court on the point that when the agreement between the parties does not designate a seat, comma, the venue specified will be regarded as a seat. Stop. Next, council also submits that the later agreement of April 2018 will govern the arbitration, constitutes the arbitration agreement between the parties, as is also the, as also has been relied on by the respondent in its application under Section 11 of the 1996 Act. Stop. Next, list this matter. Give me a date, please, Mr. Banerjee.
My lord, except for 31st July, my lord, any day next week, my lord, 1st, 2nd, 3rd, 4th, whatever is convenient.
List this matter on 1st August 2023.
I'm grateful. I'm grateful.
Call on the next matter, please.
Pass over matter, item number 2 for judgment. The state of West Bengal.
Yes, Ms. Addo, just one clarification to you also. What is AP 746 of 2022?
That is the section.
Microphone, please.
That is the section 34 application.
Section 34.
Yes.
And AP 808 is the one where, which has been made for releasing,
Yes.
for
36,
withdrawing the secured amount.
AP 808 of 2022 is the state's application under section 36(2), which has been disposed of, and
808 is the application, your application under for stay of the award.
Yes.
Yes.
And that was disposed of.
Yes.
When?
That was disposed of on
17th January 2023.
that was in January. Lordship on 14th of March 2023.
14th March.
Yes.
And then what happened on 17th January then?
17th January. There was an order whereby parties were directed to
So
file.
14th March 2023, the state's application was allowed and the award was stayed.
Yes, and they had submitted, deposited the money, and thereafter I have filed the application.
Very well. And what happened on 17th January 2023?
There was a direction by order dated 17th January, there was a direction for affidavits, and also directions were given in AP 746, that is section 34 for filing affidavits.
And 746 is the state's application.
Yes.
Section 34.
And there was just 17th January is just an order for affidavits.
There was also direction to make the payments. There was an extension of time. This is annexed to my petition also, the order, which is at page 17. May I read it out? Counsel on behalf of the
Page
state.
17, 17.
17.
Yes.
Heard counsel appearing on behalf of the parties. Thereafter, counsel on behalf of the state of West Bengal, the award debtor submits that they will deposit the sum of 9 crores within a period of 6 weeks from date. This
So
amount
you're
is
saying it's a 34 application, then why will they deposit?
No, there is this matter on 17th of January, both matters were taken up together. The execution case as well as 746, that is section 34 and 36(2). All three matters were taken together.
So
Which is-
34, 36 and
The
and-
execution.
and the execution.
All three matters were taken up analogously.
Very well. I just had to change one paragraph of the, because there was no indication as to what was 17th January and 746. Very well. I will just. The present application is hence found to be maintainable for the above reasons. This court is of the view that the award holder is not under any obligation, statutorily or otherwise, to file an application for release of the money in the application filed by the award debtor for stay of the award. Stop. GA1 of 2023 is accordingly allowed for these reasons. The award holder is permitted to withdraw the amount of rupees 9 crores upon furnishing a bank guarantee of an equivalent amount with the registrar original side. The award holder shall furnish the bank guarantee before withdrawing the money. The bank guarantee shall be from a bank which is a constituent of the RBI. The award holder shall be at liberty to take these steps within such time as is reasonable. The award debtor shall be at liberty to take steps for listing of the application for setting aside of the award. Stop. GA1 of 2023 is disposed of in terms of the above.
Actually, only one submission in my prayer.
And it is 9 crores.
Yes,
Yes,
yes.
it's 9
Not
crores.
one request, not kindly note, the bank guarantee will be kept renewed till the disposal. My lord. The bank guarantee must be kept renewed till the disposal. of the-
Lordship, I had indicated my
1
prayer.
minute, please. Yes, tell me.
Lordship, I had indicated in my prayer B that the money that is lying with the registrar may be transferred electronically. Lordship, that, Lordship.
I don't think we have. very good- Name of the system. Next system.
Yes.
I don't think not the registrar, not because I had tried for a matter of mine, my lord. The registrar, not they only issue check, no, they said we have no system. Lord, your lordship can find out from, but I have no problem with that, but I don't think that the registrar not is using that process of making payment.
Very well. I have not said anything about that. So.
Grateful to your lordship.
Yes, call on the next matter, please. দুটোর সময় supplementary list করো। Yes.
Lord, I am for the respondent. my lord.
I don't know, 22, Samsujja Sarkar.
I'm for the petitioner, my lord. In this matter, my lord, I am praying for only 1 week time, my lord.
My lord, last
Because,
two
my lord,
occasions they have taken time.
my lord,
This is, what is this?
my lord, under section 34, my lord.
34?
Yes, my lord.
Why do you want time?
My lord, the petitioner is engaged a new lawyer, my lord, but
Sorry?
the petitioner is wanted to engage a new lawyer, my lord, another lawyer, my lord.
And last
He could not arrange, my lord. He is living in the remote village of Murshidabad, my lord. I am, so my lord, only 1 week time, my lord, so he can arrange, my lord.
Yes, Islampur, Murshidabad.
Yes,
Yes,
ma'am.
I will give him some more time.
My lord,
Yes,
this
yes.
award is of 8 lakhs, my lord. The court does not have pecuniary jurisdiction to entertain
It
this
will be hard,
application, my lord.
my lord.
Very well, I'm keeping it on Monday. And
My lord,
now that your learned friend has said that, keep that in mind,
Monday, my
that
lord,
there is no pecuniary
Wednesday,
jurisdiction.
my lord, Wednesday, my lord.
Sorry?
Wednesday, my lord. Wednesday.
Yes, you're the advocate on record.
No, my lord, no, therefore,
Then who are you?
my lord, I have instructed, my lord, by
Adjournment is prayed for on behalf of the petitioner on the ground that the petitioner is yet to engage a lawyer. Stop. Next. Learned counsel appearing for the respondent submits that this court does not have pecuniary jurisdiction to entertain the matter since the value is of rupees 8 lakhs. Since the amount awarded is approximately rupees 8 lakhs. Stop. Next, list this matter on, you want it tomorrow, you're saying Wednesday.
No, no, Lord, next, coming, my lord. Coming Wednesday, my lord.
List this matter on 2nd August 2023 as a last chance to the petitioner to represent himself is the matter, in the matter.
I'm deeply obliged, my lord.
Much obliged.
Next.
Twenty-three, Rajkumar Singh.
23, my lord, this is my application and section
Mike,
34.
please.
This is my application, my lord.
Yes,
Yes, ma'am. In this matter, my lord.
I can't hear you. Speak properly.
Yes.
Yes.
In this matter, my lord, the arbitrator has passed an award, my lord, wherein my lord has directed for execution, my specific performance of an agreement, which was executed, well, alleged to have been executed on 26 May 2010. Now, my lord, the only first point I'll be taking before lordships that, my lord, there are 12 owners in respect to the suit property. The property is also consisting of tenants, and this is
You want to argue the 34 today?
34 the admission.
Admission? What admission?
Affidavits will lordship direct. Then my point is that it's totally patent illegal on the face of the record.
Why? Why?
Yes, madam. First of
If
all,
you say that affidavits are not called for, I will record it and I will hear you. There's not a problem. There's no problem.
I have not. And if a lordship,
No, I have done this, so I can hear you if you say that affidavits are not
let
required.
them file an affidavit. I don't have. I cannot. object
Patent
on-
illegality on what? What
Yes,
ground?
The point is that, my lord, the 12 owners, they have given, as alleged that they have given a power of attorney to the 3 owners, and they have executed an agreement with the Siddheshwari developer being the claimant. Now, my lordship knows that, my lord, if I am going to give a power to somebody to deal it with the property, my lord, it has to be registered, my lord. Lordship knows that, my lord, under section 17(1)(b) of the Registration Act, together with section 60 and 61 of the Registration Act, my lord, if the document is not registered, my lord, that power, my lord, what I'm giving to my brother or sister, anybody, my lord, that power cannot be taken into care because it is an unregistered power of attorney. This objection was taken at the first instance before the arbitrator, my lord. They have also called for the records from the RA Calcutta that whether this document is registered or
What is RA Calcutta?
Register of Assurance Control.
Yes.
Now, my lord, after that, my lord, this evidence was before the learned arbitrator that there is no registration of the document, my lord. He has not considered, he has not even adhered to see that whether if this document is unregistered, how can agreement be a concluded contract? The lordship knows to pass a decree for specific performance of contract, my lord, all the owners have to come and they have to sign it, and then the agreement will be completed. Second thing is that, my lord, all the payments made are since 2006 to 2010. And when this matter was taken on, there is a excessive barred by limitation in respect to the payments. Third point is that, my lord, lordship knows that, my lord, even if, my lord, somebody is taking in respect to a, my lord, power, if it is not registered, then, my lord, how can a decree in respect to specific performance has been passed, because it is barred under section 17 of the Specific Relief Act. And, my lord, other points, my lord, I feel lordship, my lord, yes, this is the, my lord, most, it's a perverse on the face of the record. I'll show you the documents that the learned arbitrator has gone the reports from the Register of Assurance Kolkata. We have given the specific objections, but has not considered.
Very well. How much time do you want to file your affidavit?
3 weeks.
It's an award dated?
But it's an award dated, my lord, February 2023, my lord. Yes.
20th February.
Yeah, 20th February 2023. Ma'am.
Affidavit in opposition to the petition shall be filed within 2 weeks from date, reply within a week thereafter, list this matter after 3 weeks.
Well, could it be 3 weeks, my lord?
Why?
Could it be 3 weeks?
Why?
Well,
I'm asking you why. Give me a good reason and I will say yes.
instructions were to pray for 3 weeks.
Sorry?
My instructions were to pray for 3 weeks time.
3 weeks as prayed for, reply within a week thereafter, list this matter after 4 weeks.
Grateful.
Instructions is not good ground enough.
The records are voluminous, my lord. All the records are not before your lordship.
If grateful, ma'am.
Yes. The respondent shall be at liberty of bringing the documents on record, which the advocate on record, which its advocate on record says are not before the court.
Great.
Next.
Item number 24, Anirban Mitro.
Matter, I'm appearing on behalf of the respondent, my lord, paying 2 weeks time for filing my affidavit in opposition.
Your lordship, this is my
Even before the 34, what it is about is heard by the court, you want affidavit?
No, I'm not, but I'm just respondent, I'm just.
I can give you an liberty to file an application for dismissal of the 34. You want to do that? Yes.
Your lordship, this is a 34 application wherein an award has been passed against me and my mother and other relatives. And I have filed it within time, 3 months and 29 days. So there is a condonation of the 29 days period that is there.
What do you mean by award against me and my mother? What does that mean?
It's a partnership. Your lordship, item number 29 today is another arbitration, section 34, which is up for hearing today, which was also filed from the same order, same award. It was filed. She had filed before. It was, if your lordship remembers, it was a partnership.
So this is the sons and that is the mothers. That is what you're saying.
Yes. Your lordship, that is what it has happened. It's a partnership. It was a partnership. We were part of the partnership, but we had left the partnership. And now the award holder has suggested that we were somebody who were signatories to some kind of a loan agreement, which was entered into the now present partners. We say it is forged and unilateral appointment of arbitrators. We had given a letter also saying that we oppose this such appointment. Your lordship, while dealing with the other case, had also indicated that it has not been dealt with. So this is the synopsis. If they want to use us affidavit, we can do the hearing immediately after.
What is the ground taken for setting aside?
Your lordship, 3 grounds. One is that unilateral appointment, and we have cogent reasons, and it doesn't fall
So
within.
named arbitrator.
Not named arbitrator. In the award itself, it says that I am unilaterally appointed by the claimant. We have opposed it immediately, saying that we don't consent. That is not taken into consideration, does not indicate or even go into the decisions, Perkins, and otherwise why it should be allowed. One. Second point is that 12.5 declaration with regard to 12.5 declarations not given. There is a judgment now which says that itself is a ground for setting aside an award. We'll show that. And the third one is on the facts.
So there 12.5 declaration is not given. And what is the other one?
And the third point is with regard to the facts, your lordship, not considered any of the points or objections have not been considered. And also the fact that it has been decided in 7 days. It shows manifestly, it shows that something is amiss. That will show from the facts.
Yes. The petitioner seeks setting aside of an award
Your lordship, it's in
dated 28th February 2023. Stop. Next, affidavit in opposition within
2 weeks.
2 weeks as prayed for. Reply within a week thereafter. List this matter after 3 weeks.
your lordship, the delay, the 29 days delay. That
Yes. Next, which paragraph have you said that?
21, your lordship, page 21, paragraph 21. Actually, I don't reside in Calcutta, so I was outside.
Yes, having perused the grounds taken for the delay beyond 3 months under section 34 within brackets 3 of the 1996 Act, this court is of the view that there are sufficient reasons for the delay, given by the petitioner, and the delay is required to be, and the delay should be condoned. Stop. Next, the delay of
29 days.
29 days is hence condoned.
Item number 25, Radha Bhattat.
But this is only for the purpose of filing notes, my lord.
Our notes are ready. Lordship will kindly, there's 3 typographical errors, my lord.
Your notes may be ready, but I may not be in a position to accept the notes.
Yes, Lord. The 3 errors which I've prepped in, I want to correct it and file it in course of the day, my lord.
What is the point, Mr.
Well,
Ghosh?
this is with regards to whether a review is maintainable from an order appointing
yes,
an
yes.
arbitrator.
The incorporation by reference.
Yes, my lord. There is, they have relied upon one Supreme Court judgment, which is specifies that the court in exercise of powers under Article 215 can exercise powers of review.
Yes, yes, Mr.
Banerjee.
Banerjee was arguing.
And I had relied upon 3 judgments of single benches, one of our Calcutta High Court. Only.
Mr. Ghosh, I will do this. Mr. Paul.
Yes, my lord.
Yes, I will keep this matter on Friday.
Very good.
All right. Yes, list this matter on, or do you want Friday or Monday?
Any day convenient,
Monday.
Lordship. He wants Monday, then Monday.
Monday would be.
Monday. List this matter on 31st July 2023 for the notes of learned counsel appearing for the parties.
Great.
Next.
Cholamannar investment.
But I'm for the petitioner in this matter.
But I'm for the respondents.
The lordships had heard this matter, my lord, and directed us to file a written note, my lord. But
Yes.
the written note is ready. May I file it with your lordship?
What was the point?
But the point, my lord, which was canvassed by the respondent was regarding the declaration wrong.
The NPA?
NPA, my lord.
Yes.
Kindly permit
May
me
I,
to
my lord,
file
hand
the-
over the copy of the notes?
But one
This
additional.
is a section 9.
It's a
Section
section 9, my lord. I was praying for an order of security because
Yes.
I was able to demonstrate that the debt is undisputed, my lord. But one additional judgment, my lord, I had just cited in the note, my lord. I missed out on the last date, my lord, on the same point. My lord, a judgment passed by the single judge of the Bombay High Court, Justice G.S. Patel, on the point, my lord, that if the debt is undisputed, my lord, the court will then exercise its discretion under section 9 and direct the parties to furnish security. In this judgment, my lord, which I may
Have you given the citation to your learned friend?
but I'm handing over a copy, my lord.
Very well. I will keep the matter on some other day so that your learned friend can come and distinguish it. Mr.
In the meantime, Lord, may I also hand over a copy of the notes, my lord, I have prepared?
Yes.
May I hand over a copy of the judgment, my lord, for your lordship's perusal?
Yes, yes.
My lord, in any event, my lord, I have tried to establish before your lordships that the date is disputed. Because, my lord, since the NPA is itself, my lord, disputed, so, my lord, the date is tried to, my lord.
Where
my
is the
lord,
judgment?
This judgment.
Mr. Sharkar?
Yes, my lord, I've just. But paragraph 31 to 36. But there was an investment by Kotak Mahindra Bank into McNally Bharat. There was a put option.
1 minute.
Yes, ma'am.
Yes, so this was a 9 as well.
Yes, my lord. This was a section 9 application.
Yes, and what does the court say?
But the courts held at paragraph 31 that the principles of order 38 rule 5 may not be mandatorily be followed, my lord. But which is also now followed in the judgment of SR, ArcelorMittal in 2022. But paragraph 31 and most importantly is paragraph 32.
1 minute. But this Bombay High Court, SR ArcelorMittal, that went up to the Supreme Court, isn't it?
And I had also cited the Supreme Court judgment on the last date, my lord, paragraph 48 to 51.
Yes, and then what else are you referring to?
3 judgments I had.
So it says that section 9 doesn't, a section 9 court does not have to look at all these issues of a 38.5.
38.5, because I have been able to demonstrate from the statement of accounts that my learned friend clients had paid the first 3 installments and thereafter defaulted from the month of March.
Yes.
And my lord, as on today, the account stands declared as a non-performing asset and the date which has been calculated is from the March 2023. And the date is not, during the course of the argument, the date is not disputed by the respondents. But therefore, my lord, in order to protect me for the purpose of, my lord, initiating the arbitration proceedings, let my learned friend secure me to the extent of the outstanding amount which is due and payable by furnishing either cash or a bank guarantee before this honorable court.
Lord, if your lordship would permit me a 1 minute reply.
No, you come back with your comprehensive answer together with the case, all right?
Very well, I'll come back.
Yes. Learned counsel appearing for the petitioner has relied on a decision of a single bench of the Bombay High Court. Stop. List this matter on 2nd August 2023 for learned counsel to respond to the decision.
I'm
Which
grateful.
paragraph of your note refers to this, Mr. Sharkar?
But paragraph 9, I have referred to all the judgments.
Paragraph doesn't have a paragraph. Your notes don't have paragraphs.
Copy
Which paragraph in your note refers to this judgment?
Paragraph 9, point number 9.
So your note doesn't have paragraphs. Can't you understand what the court is telling you? Dakao to.
Lord, my lord, that might be my note, my lord, in that email.
I'm
It's
sorry.
in bullets, my lord.
I'm sorry.
Paragraph 9.
Paragraph 9. Your last paragraph is paragraph 8. Dakao to.
Kindly permits me to file a corrected note by, my lord, by 1 p.m. I'll file it.
File it on the next day. Yes, call on the next matter, please.
I'm grateful, my lord. Union of India versus Senbu Engineering.
My lord, I appear for the respondent, my lord. This is a section 34 application filed by Union of India. My lord,
First time.
yes, my lord, I had mentioned because, my lord, we were, my lord, the award holder.
Yes.
And there is, my lord, an order of security based on which the operation of the award is stayed. Execution, I cannot proceed. So, my lord, there was
And
some,
that is which order? What is the date of that?
my lord, my lord, there is an order dated 6th of September 2021 passed by your lordship in GA1, my lord, which was really, my lord, the 36-2 application, my lord.
Give me a better copy of the order. Can't be read at all.
My lord, may I hand up, my lord, a copy, my lord?
Yes. And they have furnished the security?
Yes, my lord, they have furnished the security, it's stayed, my lord. I can give them, my lord, notice again, my lord, if lordship wants, my lord.
But then they have not done anything about the 34?
No, my lord.
Satyendra? No, this is Mr. Ghosh. Who was appearing for the petitioner? Mr. Ghosh?
Mr. Ghosh was leading me. Mr. Dhruva Ghosh was leading me.
So this is a 36. So how can Mr. Ghosh's name appear first?
My lord, I have to check that, my lord. I don't know, my lord, why if there is some error in the order or not. But my lord, fact remains, my lord, they have complied with your lordship's order and they have secured, my lord. My lord, operation of the
No,
award.
says Union of India versus
Yes, because they were challenging, my lord, the award. They had suffered the award.
very well. This matter has been brought to the list on mentioning. No, okay, Kirada. Learned counsel appearing for the respondent has taken steps for listing of this matter. Stop. The application is for setting aside of the award by the award debtor / Union of India. Stop. Counsel appearing for the respondent / award holder submits that by an order dated
My lord, 6th of September, my lord,
6th September
2021.
2021, comma. Where do I get the date of the order? It's not here.
My lord, may I just indicate, my lord?
কোথায় order date? The first page of the order.
The subsequent order is the last order. My lord, there are 3 orders, my lord, annexed, my lord, all together, my lord. The first order is, my lord, 6th of September 21. And thereafter, my lord, 2 other orders because there was some modification with regard to the mode of, my lord, security.
Yes, কি বললো? 2021, comma. This court had directed the petitioner, applicant / Union of India to secure the amount, Union of India Railways, to secure the amount for stay of the award. Stop. The award debtor was directed to furnish security of an amount of rupees 29 crores in the manner as directed in the said order. And the application for stay, being GA1 of 2021, was disposed of in terms of the directions. Stop. Council submits that the award has remained stayed from 6 September 2021, and that the petitioner / Railways has taken no steps for hearing of the Section 34 application. Stop. Next, list this matter. Give me a date, please, Mr. Dotto.
My lord, I will communicate next week. I can come back subject to my lord's convenience, or my lord, whatever
List
date.
this matter on 7th August 2023. Stop. The advocate on record of the respondent will communicate this order on the petitioner Union of India / Railways by 27th July 2023.
My lord, 7th August being a monthly list day, my lord, may I pray for 8th, my lord?
8th.
Grateful, my lord.
And Mr. Dotto, give me a better copy of this.
Well, I'll
order,
carry,
please.
my lord, all my lord orders, my lord. Next day, my lord, I'll
Yes.
prepare a compilation and I'll come. Grateful, my lord.
Item number 28, Lil to Mehena.
I can't hear you.
And for the respondent, my lord.
Yes, my lord, I have already received the opposition, but reply is not ready. I am praying for 1 week time, my lord.
When did you give the opposition?
My lord, opposition has been served to them long back, my lord. May I
Did it
file within time?
On
May I-
17th, my lord.
17, don't know the month.
17th July, my lord.
17th July 2023. my lord.
Yes. You're the advocate on record.
Yes, my lord.
The advocate on record of the petitioner seeks time to file the reply. Seeks extension of time to file the reply, capital R, stop. The affidavit in reply should be filed by 1st August 2023. List this matter on 3rd August 2023. What is this, a 34?
Yes, my lord. May I, with the lordship's leave, may I file the affidavit in
The
opposition?
affidavit in opposition is taken on record.
Written.
29, Mondira Mitro.
Your lordship, this is my 34.
I can't understand
My 34
For the
application, your
respondent.
lordship.
May I file the affidavit in opposition?
We filed the opposition out of time. I don't want to rely upon our reply on this. I can argue just
And you don't want to rely on the opposition also?
on the opposition surely, but not on the any reply. We will not file a reply.
So so all the statements made in the opposition, you are fine by?
No, your lordship, I will show that they have only, there are 3 contentions. As I said, the 3 contentions. One is an unilateral appointment.
What do you mean by, as I said?
Your
When did
lordship,
you
I
say
will-
that?
In the last occasion when we are arguing this, I'm again, the 3
Yes.
contentions in this matter.
Yes.
One, it's a unilateral appointment. Another one is the 12-5 declarations were not given. And the third is with respect to the
So
how
this is the mother.
the mother.
The other one was the son.
Son, yes, the mother. Now, your lordship, what has
So what,
happened?
nobody else has challenged the award?
No, the other two people are the people who have actually taken the money, so they have not challenged.
Yes.
Your lordship, the thing is, they admit it is an unilateral appointment. The entire course of action which has happened, they have admitted it in their opposition as well as in the award, it is there.
No, my lord, I stand corrected. We have not admitted it to be a quote unquote unilateral appointment.
Yes.
The arbitral award says that it's a unilateral appointment. Arbitral award says it's a unilateral appointment. And the second thing is that the 12-5.
So you're saying that as soon as the words unilateral appointment are uttered, it becomes a sacrosanct, a non-starter.
No, no.
Non-starter from the.
No, your lordship, I'm not putting my case that high up. In fact, I have prepared an entire set of judgments. Your lordship, I will hand over one to them and one to your lordship also. I'll indicate the paragraphs. And these are the judgments, your lordship, I'm not going, the Perkins and all those judgments are there already. This is what has happened afterwards. All the judgments, how they have relied upon Perkins and where the managing director or any of those positions.
How they? Who's they?
The courts, your lordship, I'm saying all the courts across the country, how they have relied upon, and another Supreme Court judgment, Glock judgment, which has come out in 2023. And those provisions, how they have how it has been interpreted, Perkins has been interpreted by the courts. I've made an indication of all those judgments. I've made a summary of those. I'm giving a copy to my learned friends also.
And did you waive the operation of the proviso to 12-5?
No, your lordship.
No.
No, your lordship. I have not. I will come to paragraph 50 and 51, your lordship, where your lordship had the occasion to deal with that particular in McLeod. Your lordship will see I rely upon McLeod's judgment also. There is no nothing in writing, express in writing that I have waived. In fact, there is a letter which starts before the arbitration proceeding starts, where I write and say that I have an objection. I have an objection to your appointment. It's a unilateral appointment. I have not given any consent, and other things which are there. I have done so. Thereafter, the arbitrator continues the proceedings.
So you have unequivocally said that you don't consent to the appointment.
Yes.
To the arbitration clause.
Yes, I have said so. I have said so. I said that I have not even signed this agreement. This is forged. My signatures are forged. None of this is considered. Your lordship had the occasion to take it up in my section 36 when we had filed. And your lordship had also said that prima facie it appears that nothing has been considered by the arbitrator. I'll come to that order if your lordship so pleases later on. But as of now, your lordship, I am only on these judgments. Now,
yes.
I will first show with regard to unilateral appointment, I will rely upon these judgments and I will indicate all the paragraph numbers. And then I'll go to another judgment of the High Court here, which is not there in this compilation. This compilation is only with regard to unilateral appointments. The other one is with respect to 12-5 declarations not given. Then itself
12-5 declaration
not given.
So the 5th and the 7th schedules.
5th and 7th schedules, if it is not given, and that was in respect to a MSME award, and the court said no, even in the MSME, because one thing which is important to note is that when MSME under West Bengal,
yes,
the MSME rules, actually there is a provision with regard to the Arbitration Act. It says that it has to be, the entire thing has to be done as per the Arbitration and Conciliation Act. So the overriding provisions, the court says, does not override the requirement to file appropriate declarations under 12-5. If you have not given that, even an MSME award can be set aside only on that ground.
What do you mean by even an MSME award? Why should that be in a special category?
Because MSME, your lordship.
Because under 18.3, it's all the Arbitration Act.
Under the Arbitration Act, but
yes,
so that's because of the overriding provision. Provisions, that's all. The court deals into that. Your lordship, may I just take your lordship to, if your lordship, the paragraph numbers I will note first, and then your lordship I'll take through the paragraphs. I'll first rely upon your lordship.
No, Mr. Sinha, you will rely on my judgment last.
Very well.
Just formulate your point, please.
Very well.
But unilateral appointment cannot be a bogey, in the sense that the moment you say those words, everything goes out of the window.
Your lordship, may I just show the judgments? May I just show the judgments? if there is no express right in express writing, if I have not even participated, in even prior to participation, I have indicated that I do not consent, then perhaps, Your Lordship, unilateral appointment by itself will be something that cannot be taken into consideration.
And that was taken into consideration or not taken into consideration by the arbitrator?
Not taken into consideration. It says that letter given on 8th of September, which is part of my application. 8th of September, the letter of 8th of September, that is kept on record. It's kept on record, that's all. That is the only sentence which is there. None of the contentions which are raised are given any credit.
And that was taken before the commencement of the arbitration?
Yes, when the
proceedings?
first notice has been given, we have given that letter, and thereafter arbitration has started. And
So,
then
Mr. Sinha, I'm not, I don't want to hear you in detail today.
Very
Just formulate your points. One is unilateral appointment. What is the other one?
the other one is 12.5, not given, declarations
Declaration
are
not
given.
And Supreme Court has said that if you don't give that declaration, the award
I
goes.
am showing a Calcutta High Court judgment. Calcutta.
Saying that if you don't give it, then the award should be set aside. On the ground of which clause of, which subsection of 34?
Your Lordship, because it's contrary to public policy.
Public policy.
Contrary to public policy.
What
I'll
is
show
the,
that
what
I
is the public policy?
in the sense, Your Lordship, that the entire thing has to be transparent, and Your Lordship, may I just then take you to that judgment?
Coordinate bench.
Yes, Your Lordship, coordinate.
Justice Saraf.
No, Your Lordship. Justice Subhashish Dargupta.
Which one is that?
Your Lordship, that is not there in that compilation. I'll give another copy. Your Lordship, I'll give you answer.
Public policy.
I'll send you the copy. I'll send
You don't think it's public policy to choose an arbitrator?
Your Lordship, it is public policy to choose an arbitrator only by consent of both parties, because it's at the end of the creature of a contract between the parties, if they have taken into consideration. So that is my second point.
Even the clouds are not agreeing with your submission.
Maybe. But Your Lordship, as I said, with regard to 12.5, the declarations which have to be given, there was a reason why those schedules were brought in. There was a reason why the schedules were brought in. And if today the practice starts whereby those declarations are not given and people proceed with arbitration, then the entire purpose will be defeated.
Very well. Mr. Sinha, I'm fine. As long as you don't ask me to give a judgment which is contrary to my earlier judgment, I'm all right.
I will, Your Lordship, I will indicate that judgment also. I'll indicate that. That's why, Your Lordship, I've indicated, I've based my entire case on McLeod Russell. I'll show exactly on that provisions on how it can be done. And Your Lordship, this is my second plank of
And
my
also let me know if McLeod Russell has been set aside or not. All right, because that is important.
Your Lordship, as of my understanding, it has not been set aside.
No, because
There
the
are-
division bench has to be tested.
Yes, there are contrary judgments which are there in Delhi, the division bench in Delhi, as well as Your Lordship, the Calcutta coordinate bench here in Calcutta, which that has not considered that aspect of express in writing, because Your Lordship has based in paragraph 50 and 51 of Your Lordship's judgment. The thing 50 and 51, Your Lordship, Your Lordship has based on it the fact that the people filed petitions exercising the jurisdiction of the arbitrator. Thereby, there is a clear unequivocal understanding that there is an express right, in express writing, they've accepted the jurisdiction.
So it's a 12.5 proviso situation.
Yes, that is what Your Lordship based it on. Whereas those on the other judgments, they have not gone into that part at all. Without going into it, has just been said that it has been, because it's a unilateral appointment, by ipso facto, it's bad. That is the only difference. But Your Lordship, I will show also a judgment of the Bombay High Court, which is there here in this compilation. Exact facts as our case.
Yes.
That also, it is held that the arbitral award has to be set aside. These are the basic arguments which I will formulate, Your Lordship, and on the facts of the matter, how the arbitral proceedings have been conducted, no marking of evidence, none of the procedures otherwise to be followed, nothing has been done. In 7 days, one hearing and the arbitral award has been given. By itself, it shows no indication, no opportunity provided to cross-examine witnesses, cross-examine or even challenge documents, nothing done. That is my fault.
Very well. When will you come back, Mr.
Any
Sila?
day, Your Lordship. I'm ready whenever Your Lordship pleases.
Learned counsel appearing for the petitioner seeks setting aside of an arbitral award dated 28th February 2023 on primarily the ground of unilateral appointment. Stop. Unilateral appointment of the arbitrator. Stop. Counsel submits that there is no waiver under the proviso to section 12 within brackets 5 of the 1996 Act, as the petitioner had specifically objected to the arbitrator's appointment before the arbitration started, before commencement of the arbitration. Stop. Next, list this matter on any date in the first week of August.
Whenever, Your Lordship, whenever. I'm
on 3rd August 2023. Call on the next matter, please.
Meena Agarwal.
Lordship,
For the petitioner, my lord.
I am appearing for the respondent, Lordship. On 15th June, Lordship had been pleased to pass directions for exchange of affidavits. Lordship, the affidavit in opposition is not yet ready on account of 3 instances, Lordship. Firstly, my advocate on record had written to the learned sole arbitrator seeking information as to how the award was served on my learned friend's client.
Very well. How much time do you want?
My lord, 2 weeks, my lord.
But 15 June, you were supposed to give it. You're out of time by how much? How
My
many
lord,
days?
the time has expired on 6th July. Lordship, two further informations are required. Firstly, Lordship, my learned friend's client has pleaded that she is not aware of the arbitration proceedings at all. We endeavor to show that she was
You're the
contemplating.
counsel.
I am the counsel.
Learned counsel appearing for the respondent seeks extension of time to file the affidavit in opposition. Stop. Next, affidavit in opposition should be filed within 2 weeks as prayed for. Reply within
1 week hence.
2 weeks thereafter. Stop. List this matter after 4 weeks.
I am
Grateful, my
deeply
lord.
obliged.
Supplementary list. Item number 1, examination of judgment debtor Avansi Financial Services Limited versus Najia Anis.
I'm appearing for the degree holder.
I can't hear you. Microphone,
Your
please.
Lordship, I'm appearing for the petitioner award holder.
Yes.
JD
There is
number-
only one judgment debtor.
No, there are two, Your Lordship, but only one has been arrested and he has been produced before.
Yes.
আমি শপথপূর্বক বলছি এই মামলায় সাক্ষ্য দিতে এসে যা কিছু বলবো সত্য বলবো, সত্য ছাড়া মিথ্যে বলবো না, কোনো কিছু গোপন করবো না। মোহাম্মদ জাহিদ হোসেন। লেট জমির উদ্দিন, মোহাম্মদ জমির উদ্দিন। আমার 52 ইয়ার্স। আমার দোকান, চুড়ির দোকান আছে স্টেশনে ছোট। অ্যাড্রেস MH স্ট্রিট বাইলাইন আসানসোল, মুন্সি বাজার আসানসোল, আসানসোল।
Your Lordship, no affidavit of assets has been filed as.
Yes, Mr. Sen, if the judgment debtor
I am not appearing.
not appearing, then why are you sitting over there?
I thought that the item number 1 of the original list.
Yes.
Sorry.
May he file affidavit of an assets. Your Lordship.
Yes, put the question to him. Since nobody is appearing for the judgment debtor, you have to put the question.
आपने क्या affidavit?
But I have been instructed by the judgment debtor on behalf of him, I am appearing.
Very well. Ask him when he is going to file the affidavit to assets. How much time?
My lord, kindly direct the
I can't understand what you're saying. Sit down and take your breath for 2 seconds.
My lord, the judgment debtor is not having any copy of any proceedings, my lord. Kindly direct to supply us the copy, my lord.
Copy of what?
Any award, anything, nothing.
Award. So you think this is section 34?
I don't know, my lord, he.
You don't have a copy of the execution petition? That's
No.
all that you're entitled to.
No, my lord.
Execution petition you don't have?
No, my lord, what instruction I received from him.
Very well. Yes, did you serve the copy of the execution petition? Yes, just ask him how much time he wants to file the affidavit. Otherwise, I will have to keep the warrant pending. Ask him. I can't hear you. Do you hear the judgment debtor? Microphone, please.
আপনি আপনার সম্পত্তির হলফনামা
হ্যাঁ,
এই আদালতে কতদিনের মধ্যে প্রস্তুত করবেন, কতদিনের মধ্যে জমা
আর আপনামা আমি একটু বম্বে যাব, আমার বউয়ের ব্রেস্ট ক্যান্সার হয়েছে। আমি এসে আমার ওখানে যতদিন লাগবে আমি এসে জমা দেবো।
সেটা না 1 মাস 2 মাস
হ্যাঁ, এক মাস মোটামুটি অপারেশন বলেছে, 1 মাস।
দিনের মান
হ্যাঁ হ্যাঁ
সাবমিট মাই
হ্যাঁ
অ্যাফিডেভিট অফ
হ্যাঁ
যদি আপনার সম্পত্তির হলফনামা এই কোর্টে আপনি জমা না করেন
হ্যাঁ।
তাহলে কিন্তু আবার অ্যারেস্ট করে আপনাকে ধরে নেওয়া হবে।
এটা
আপনি জানেন?
এটা জানি না, যদি আমার ওইখানে একটু দেরি হয়ে গেল বা কিছু ওইখানে ট্রিটমেন্টে কিছু দেরি হয়ে গেল।
Ask him what is the maximum amount of time within which he can give it.
How much time you want?
MRI 31st MRI আছে, তারপরে অপারেশন করবে।
আপনার কত সময়?
So you want to speak to him in English?
বলিনি 1 মাস এমনি
Normally speak in English all the time.
No, my lord.
Then?
আপনার ম্যাক্সিমাম কতদিন বেশি টাইম লাগে?
1 মাস আছে স্যার, আর 15 দিন বেশি লাগতে পারে, খুব বেশি যদি লাগে।
He is asking for 45 days.
45 days. Very well.
Within 45 days.
This judgment debtor number 2.
Yes, Your Lordship.
Yes, the judgment debtor number 2
হ্যাঁ হ্যাঁ স্যার আসবো।
has been, has he surrendered or he's been arrested?
He was arrested.
He was arrested.
Has been arrested and produced in court today and is produced in court today.
वो मिला है service से।
Stop. After the preliminary evidence, comma, after the preliminary deposition, comma, the judgment debtor number 2 assures the court that he will file the affidavit of assets within 8 weeks from date, and he will be present in court whenever the court requires him to do so. Stop. Next, learned counsel appearing for the judgment debtor number 2 submits that the judgment debtor number 2 has not been served with a copy of the execution petition. Stop. A copy of the execution petition should be served to, are you the advocate on record or counsel?
I'm the counsel, madam.
Should be served to, on the advocate on record of the judgment debtor number 2 by
Any day, I'll serve it within.
by 27th July 2023. Stop. Next, list this matter after 10 weeks. Stop. The warrant of arrest shall be kept in abeyance till then.
Deeply obliged, Your Worship.
Non-commercial list, item number 1 to be mentioned, ITD CM joint venture.
Well, this matter is an application under section 34 of the Arbitration and Conciliation Act.
Yes.
It was mentioned yesterday, actually whilst trying to mention for the purposes of mentioning and enlisting the matter, we found, my lord, that it should be heard by the commercial division. So my lord was pleased to keep it for today, although we mentioned yesterday on notice to the other side, so that, my lord, a formal order could be passed for transfer of
The value is how much, Mr. Bose?
My lord, it's more than 100 crores.
Yes, Mr. Sen, that's fine.
This application was filed in 2020 after commercial court was constituted, commercial division was constituted. So, my lord, probably, my lord, this will not come under section 15, whereby the commercial court can transfer it. Section 15, if your lordship sees.
Mr. Sen, you are the award holder, I presume.
Yes.
If the matter is transferred to the commercial division, it will be heard that much earlier. Good for you.
It is good, my lord. It's a question of
Why would you want this matter to
I
backfire?
have another right.
Yes.
As of today, my contention is that this application is, well, the court cannot exercise jurisdiction at all.
That you take.
Time of the
No. Once it is transferred, the court will assume jurisdiction. Today there is no power of transfer.
No, I'm going to record that your objection will be treated as a preliminary point in the 34.
After your lordship will transfer, kindly consider section 15 once, my lord. I cannot advise.
What are you relying on? 15.4?
15.1, 15.1, 15.2. What is the purpose of section 15? Section 15 has been given only to exercise jurisdiction for those matters which were pending in this court on the date of constitution of this act. It is only in those cases.
Mr. Sen, I can have a sense of where your argument is going, but this is done as a matter of course in many matters. And not only by me, I have seen this in my coordinate
this is the very difference between section 15 and the other provision. Section 15 is not a provision for regularization of a suit or a proceeding which has been filed in a forum.
No, are you saying that the petitioner should have filed more or filed some amount of money at the time of filing?
I am saying it is a case of quorum non judice. the court in its ordinary original jurisdiction does not have the jurisdiction to assume over the subject matter of this proceeding. It is like, my lord, if I have filed a suit challenging, my lord, a securitization proceeding, I have a right, the other side has a right under Order 7, Rule 11.
How is that an analogy for this?
Yes, this is because this in 2020, the old court in its ordinary original civil jurisdiction was not competent to exercise jurisdiction over this matter, which on that date was a commercial proceeding, having specified value more and subject matter also within section 3.1.2.1. So therefore, at the outset, this court did not have jurisdiction. So therefore, this cannot be cured by exercise under section 15. Now, this is like, well,
very well. I will send it back to the department, and then I will direct them to take steps.
Well, only one thing may I say.
Instead of a direct transfer to the commercial division.
10th February 2020, this petition was admitted. My learned friend was present.
Yes, yes, I accept. I cannot give a consent for jurisdiction.
Yes. My lord,
it's an inherent lack.
My lord will
The most easy method is,
Mr. Bose,
withdraw and file afresh.
Just tell me. Just tell me.
Well, it was said that, my lord, we were challenging this. We were making a challenge to the award because 2 of our claims were not allowed.
Yes.
It was admitted. My learned friend was present. It was fixed for hearing. It just so happens that the hearing thereafter did not take place because matters under section 34, my learned friend will bear me out, were not being taken up very regularly from court to
Mr.
court.
Bose, let me do this. It's a point which your learned friend has raised. And even if this court or other courts have done it as a matter of course, if it's a point taken, then I will have to address it and go and decide whatever. So instead of doing that, what I will tell you that I will give you leave to withdraw this and file afresh before the commercial division.
Is my lord going to do it today, or is it my lord's pleasure to send it first to the department and find out from the department whether such transfers are being done as a matter of course? They have always been done.
Department cannot act in advisory
I am not
capacity.
saying that, but since it fell from your lordship also.
Very well. Mr. Bose, I will allow you to withdraw the matter. It's the easy way out.
That's so easy.
Because in any case, now that
Otherwise, I will come up with an
Mr. Sen
application.
has indicated what his objection is going to be, that what did you say? That this
It's a
is not
quorum non-judice.
very well. So it's a
Point was
34.
not taken when this application
Yes,
was
it was
moved.
not taken.
Mr. Bose, it's something like a section 3 of the Limitation Act.
Yes.
Parties don't have to take that point. If the court finds out and if one party raises it, then it's not a subjecting to jurisdiction kind of
What
conduct.
I mean is, my lord, I paid court fees whilst moving this application. It was moved upon notice to my learned
No,
friend.
that can be adjusted, Mr.
Very
Bose.
well, yes.
That can be adjusted.
Very
That order,
Lord will
the
kindly
court can
make
always
provision
pass.
for that.
Yes, learned counsel appearing for the respondent / award holder takes a point of maintainability Yes, all these arguments are now resolved because the order passed by Justice Chakraborty, as his
Yes.
lordship then was, records that this matter was listed in the commercial division. I don't know why it's come to the non-commercial division.
Then it is a different thing, my lord. If it is a commercial division matter,
Yes,
may I have a look at the order, my lord?
yes.
Then, of course, my lord, I was not aware of
Then
Then it is probably
Then
wrongly
kindly
appearing in
fix
the
the matter
non-commercial.
on any day convenient to my lord's pleasure. Let it be included in the list. ठीक है, ठीक.
But there is no order on that. But the cause title is also original jurisdiction.
The order passed by a learned single judge of this court, as his lordship then was, on 10th February 2020, reflects that this matter was listed in the commercial division of this court. Stop. For some unexplained reason, thereafter, for some unexplained reason, This matter thereafter, this matter has been listed today in the non-commercial division. Stop. There are a learned counsel appearing for the, is this the last time this matter was heard, Mr. Bose, 10th February 2020?
Yes, thereafter, my lord, it has not been heard.
This matter was not taken up for hearing after 10th February 2020. Stop. Next, 10th February 2020. Next, counsel appearing for the petitioner prays that the matter be transferred to the commercial division of this court, which has been objected to by counsel appearing for the respondent. Stop. The latter relies, counsel appearing for the respondent relies on section 15 within brackets 1 of the Commercial Courts Act, 2015, which relates to transfer of pending applications to the commercial division. Stop. Next, since there is an obvious anomaly, ANAMOLY, an anomaly in the ANOMOLY, anomaly in the last order passed by the learned single judge and the contentions of counsel appearing for the parties today, comma, the department is directed to ascertain whether the matter was filed in the commercial division of this court. Stop. And send a report. Stop. Next, list this matter on 3rd August 2023. Stop.
Grateful.
Obliged. Non-commercial side decrease the knowledge.
Item number 2, Mrs. Arjun International India.
Lord, I am humbly beseech for the petition.
I can't hear you.
Appear for the petitioner, my lord.
Yes. Yes, the arbitrator has communicated his inability to act as arbitrator. So what do you want to do? Till 24th
24th of June, 2024, my lord.
yes, so he can only give his consent after 24th June 2024. So do you want to wait till then?
No, my lord.
No,
No, my lord.
I can't hear you. Microphone, please.
My lord, appoint any other.
24th June has already gone. What do you think? What do you say?
2024, my lord.
Sorry, 2024. Yes. You want somebody else? The registrar original site
My lord,
has.
on indulgence, my lord. This is the second time it was refused, my lord. The first time it was
So what do you want to do? You want the court to give directions on arbitrators
pointed out.
across the panel? The learned arbitrator who was appointed by the order dated 3rd July 2023 has communicated his inability to act as the arbitrator till 24th June 2024 on account of the arbitrator holding an official post till that date. Stop. Next. You're the advocate on record.
My lord.
The advocate on record, the petitioner seeks appointment of another arbitrator in place instead of the arbitrator who was appointed by the court. Stop. What is the amount of the claim?
2 crores, 2 crore 10 lakhs.
Next, blank is accordingly appointed as the learned arbitrator to sort out the disputes and differences between the parties, subject to the arbitrator communicating his consent in the prescribed format to the registrar original side within 3 weeks from date. Stop. The advocate on record of the petitioner will communicate this order on the arbitrator appointed today by 27th July 2023, along with the relevant details of the contact person.
Extremely grateful.
Next.
Item number 3, Mrs. Gatik Tea and Co. Private Limited.
My application, section 91. Your lordship had two queries.
Yes, yes.
One was with regard to the prayers in the suit. The suit for recovery of money.
Yes.
Could hand over a copy of the plaint, my lord.
Yes.
Taken the liberty of just taking out the prayer
That's
portion.
fine. Thank you. This is the
Suit
suit,
that I have filed
this is a
against the
plaint, and what about you did not take out any interim application, Mr. Banerjee?
There's an interim application that's pending that is for attachment of his bank account.
Attachment, that's the only prayer.
Yes, attachment before judgment, yeah. For the 32 mention application? I'm not sure, my lord.
Mr. Banerjee, I can keep it tomorrow.
Kindly does that.
Just get the, and do something, please.
Yeah.
Just get me a photocopy of the plain prayers and the
I'll
interim
give the
application.
plaint and the interlocutory application.
Yes, that's
And
all.
with-
What? Who are you?
The private
There were
lordship's
two
query
queries.
was
Yes.
that they were, apart from the.
Yes, yes, there were three other.
Three other, where were they on record? Were they on record? They're not on record. This was handed over by the private respondent.
Yes.
Look, if your lordship, sorry,
Yes.
if your lordship desires, then in course of the day, I could hand over both to your lordship's officer.
I'm giving it tomorrow.
Very.
Yes, so these are the three letters written before the 11th November 2022.
Yes.
Yes, the advocate on record of the private respondent has handed up the three notices preceding the impugned notice dated 11th November 2022. Stop. Next, learned counsel appearing for the petitioner will place the prayers in the, has already placed the prayers in the plaint today. Stop. List this matter tomorrow for counsel to place the prayers in the interim application. Stop. In the interim application.
Item number 4, Mrs. Olok Lai.
সুদীপ্তকে এখানে রাখো তো, তুমি ওখানে যাও।
But for the petition.
Yes.
Well, this is my application under section 11 of the Arbitration Conciliation Act.
Yes.
Petitioner, if your lordship was a subcontractor. Well, we had entered into a work
This is a
contract.
section.
Section 11.
Wait till I get the papers at
Oh, sorry.
least.
I'm sorry.
And you are for the respondent.
I appeal for the rest.
Are you opposing the appointment?
Yes, my lord, I am opposed.
Yes.
Now, my lord, this was a work contract. We had entered into a work contract with my large friends, client, the respondent authorities.
No, you have to say who the petitioner is.
My petitioner is a subcontractor. We
Yes.
had entered into a work contract with regard to my construction of the building at Raniganj areas.
Yes.
So, my lord, this is an arbitration agreement. But
Yes.
in respect of the parent work contract, but there are 4 amendments. Now, on the same terms and conditions, only one
What is the work for?
work for construction of the building.
What building? The building means what?
Construction of buildings, my lord, That is what it is. It's a project. It's a government project. They had, respondent had entered into a, being the contractor, had entered into a contract with the government, state government, and they subcontracted us with the project.
Yes.
So, well, accordingly, but we became the successful. To them, we have been received the work contract with the contract that within such and such time or period, we had to complete the projects and hand over to the contractor.
Yes.
So, then in respect of the parent contract, work contract, there was 4 amendments. So in respect of one, there are 4 works contract awarded in our favor. So in one work contract, this is the application what you are today is placed before your lordship. But in earlier occasions, we moved these applications, but it was withdrawn because they raised the objections. Because we in earlier occasions, AP in 42/2022, we filed a composite petitions under section 11. They took a point that in view of Dura Folgura judgments and other judgments also, it is not maintainable. We have to split it. Since each contract, work contract, consists arbitration, separate arbitration agreement, therefore separate application has to be filed. So today, we have filed a separate applications under section 11. The reasons for that is why we have filed. There is a dispute arose between the parties. There was no dispute up to 5th April 2021. After 5th April 2021, in terms of the payment, we had submitted all our RA bills, but they refused to make any further payments.
Who is they?
But the respondent or contractor, respondent contractor. I'm sorry. So therefore, after this is our grievance that after 5th April 2021, no payment has been made. That is the disputes. Although they didn't deny, even after receiving notice under section 21. So
they didn't deny what?
Deny the claim. So far the pending bills are concerned, the total amount is 33 lakhs and odd. But this is the subject matter. We have served notice under section 21. They objected in earlier section 11 applications. That's why we have withdrawn that applications. We have filed afresh, splitting in a separate contract.
So in this case, you don't have a 21.
This case, we have a claim of 27 lakhs 78,000.
This case, do you have a 21 notice or not?
Yes, yes.
You do have
Separate notice
21.
we have served.
So give me the dates of the notices
Yes,
and the page
kindly come
numbers.
to 21 notice. Page
Start
53.
from the beginning, please. Give me the page numbers.
53. Page 53.
Yes, learned counsel is unable to comprehend the queries of the court. List this matter tomorrow. Next. Next.
I'm sorry,
Next. Call on the next matter.
same matter, same application.
If you can comprehend, then we will do the matter. Otherwise, we will. not
Yes,
do it.
I'm ready, but just.
Yes, next.
Item number 5. Mrs. Sima.
4 and 5, same matter, Millard. Kindly takes off once again 4.
4, I could not understand because of the insufficiency of your submissions. Place your facts properly.
Yes, madam.
Yes.
But my responsible submissions, Millard, since after 5th April 2021, we have sub demand notice because there was in terms of the arbitration clause at first conciliations. So we requested them to conciliate the issues and we wanted to resolve in terms of the agreement, arbitration agreement, but they didn't adhere of our request. Subsequently, we have sub notice under section 21 of the arbitration conciliation. That is at page 53. So we have requested them to appoint an arbitrator and on expiry of the notice period.
Is this the way you do section 11, Mr. Nandi? Or is this the first time you're doing it?
No, I have not first time.
Then is this the way you do a section 11? I'm asking you. Yes, what is the objection? I will not allow it because you're not ready. Yes.
Good.
I will dismiss it because you're not ready. Yes.
So there are several.
Microphone, please.
There are several amendments to the work order, my lord. Each of the amended work orders contain a separate and independent arbitration clause, my lord.
No, so now that point was taken before and now the separate applications have been filed. So what remains of that objection?
My lord, what remains is, my lord, the section 21 notice which they have issued to us, my lord, they have only invoked only one arbitration clause, which is part of the parent work order, and have not invoked the separate and independent arbitration clauses, which are part of the separate amended agreements, my lord. My lord,
Yes, show me the differences, please.
my lord,
Difference.
my lord, may I please the prayer once, my lord, before my lord showing the work orders, my lord?
Yes, yes,
The prayer, my lord, is at page 9 of the application, my lord.
yes.
My lord, prayer A says, an order may be passed appointing a fit and proper person to act as a sole arbitrator for adjudicating the disputes between the parties
arising out of arbitration agreements as attached in Annexure A. My lord, Annexure A contains, my lord, 5 arbitration agreements, my lord. The initial work order as well as the 4 separate amended work orders, my lord. I will place, my lord, each of them containing the arbitration clauses, my lord. My lord, the first work order, my lord, is at page 24, my lord.
First work order is at page 11.
Page 11, my
Why
lord,
is it
clause
24?
24 at page 13. Page 11, my lord, starts and clause 24 at page 13, my lord. My lord, this is the, my lord, arbitration clause, my lord. It says that in the event of any difference or dispute arising out of or in connection with this work order, my lord.
Where is the arbitration clause?
My lord, clause 24, my lord, at page 13. It's at the bottom, my lord.
Yes.
My lord, it says in the event of any difference or dispute arising out of or in connection with this work order,
Yes.
the same shall be first amicably settled by mutual dialogue, and if the parties fail to settle their dispute or dispute arising out of or in connection with this work order, the same shall be referred to arbitration.
Yes.
My lord, this similar arbitration clause is also, my lord, part of the amended work orders, my lord, which is at, my lord, page 23, 31, 39, and 47. I'll first place page 23, my lord. My lord, page 20, my lord, the amended work order starts, and page 23, my lord, is the arbitration clause, my lord, at the top. In the event of any difference or dispute arising out of or in connection with this work order,
Yes.
the same shall be first amicably settled by mutual dialogue. In case they, my lord, fail, then, my lord, arbitration would be invoked. My lord, thereafter, my lord, similar, my lord, arbitration clauses are there in the other amendments as well, my lord.
So are the clauses similar or different?
The clauses are similar, my lord.
Similar.
Yes. However, my lord, if your lordship may kindly come to the section 21 notice at page 53, your lordship will find that first I'll show regarding. My lord, my learned friend says disputes in connection with the original work order dated 1st August 2018. Does not refer to the other work orders, my lord. And thereafter, my lord, at page 54, my lord, the 3rd paragraph, my lord, he says he has a claim of 27,78,558 along with interest calculated from 31st May 2021 till realization. And thereafter refers to the agreement, arbitration agreement, which is part of, my lord, the original work order of 1st August 2018. However, my lord, this 27,78,558 is from their own submission, my lord, will be apparent at page 8, forms part of all the amended work orders. My lord, kindly have a look at a chart at page 8, my lord. It says claim for unpaid arrears arising out of work order this, as well as amendment numbers 1, 2, 3, and 4. So this 27 lakh, my lord, in this chart, 27,78,000 is a claim on account of the work order as well as claims arising out of the subsequent amended work orders. Today, my lord, he invokes arbitration, which is part of the original work order and does not invoke the arbitration clauses of the subsequent amended work orders, and thereafter asks, my lord, this honorable court to appoint an arbitrator to adjudicate claims arising out of all the work orders. My lord, this, my lord, my submission would be is not possible, my lord.
So according to you, if he had dissected the claim and made it in respect only of the parent work order, then that would have been fine.
Yes, my lord.
Yes. So that means the only problem with page 53, according to you, can be rectified if the amount mentioned at page 54 is changed. That is all?
No, my lord. My lord, his prayer today is, my lord, his prayer is that he wants the claims of 27 lakhs, which arises out of all the work orders, to be adjudicated by the learned arbitrator. Therefore, the section 21.
Can't you understand the court's point?
Yes, my lord.
If I direct him to amend this figure, I can't direct him to amend the figure in the letter, but if I direct him to amend his claim
Yes, my lord.
in accordance with the parent work order,
Yes,
then
my
what
lord.
remains of the problem?
My lord, in respect of the parent work order, my lord, whatever claim, my lord, he has already invoked, my lord, that, my lord, can be, my lord, adjudicated by the arbitrator, but not the remaining portion which arises out of the subsequent amended work orders, my lord.
And what happens to the balance claim?
My lord, he had to invoke, my lord, all of the arbitration clauses arising out of each and every separate independent arbitration clauses being a part of the.
And this all relates to the same underlying contract,
Although, my lord,
all the work orders.
the contract is with regard to the same project, my lord. However, my lord, the amended work orders do not, my lord, record that this is in relation to the principal work order, my lord. There is no, my lord, question of incorporation by reference or anything, my lord. It does not refer to the principal, my lord, agreement, my lord. None of the work orders, my lord.
Yes,
But
Mr.
my
Pillai.
dispute submission, in response to my Latin friends, the objections, but so far the other, my claim, today's claim is which contains parent work orders and all subsequent 4 amendments work orders. So there is no difference. All work orders, subsequent work orders or amended work orders, but there is a copy paste of the parent order. So there is no difference.
No,
And my total claim,
Mr. Nondi, that is not the point. The point is, he's not saying they're different. He's saying that you have invoked arbitration clause of the parent work order,
Parent.
but claimed in relation to all 5.
yes, but only parent is there, definitely there. My claim is there, but subsequently, what I have stated in this petition, my claim is rest 4 is also included. Claim. Rest 4's claim is also included in this.
What is that? How is that argument dealing with the point raised?
Yes. Now, my humble submissions, this point my Latin friend has raised before the earlier proceedings, where they have filed an affidavit. In this affidavit, they said they didn't dispute these things. But kindly see only paragraph 3. Now, today my Latin friend is taking different stand.
This was
No, I will not see any document to make your arguments.
But here they stated, in paragraph 3, kindly give me an opportunity to read out. At the outset, it is stated that this honorable court does not have the jurisdiction to try, entertain, and determine the present application filed by the petitioner, as the reference to the arbitration goes beyond the purview of 4 work orders, being work order number so and so, and 4 amendments in 1.
Please take your seat. Yes.
1.
Yes.
So therefore, and second amendments, that is work order number, no, second work order number, third work order number, 4th work order number. So therefore, according to my Latin friend's contentions, as he used the pleadings as he made in this affidavit, that they did not have any objections with regard to 1 work order and the subsequent 4 amendments. They had the objections since in earlier section 11 applications, we claimed that before this honorable court, our prayer was to appoint a single arbitrator for adjudication of 4 work orders dispute. Now, they didn't have any dispute with regard to 1 work order with which contains 4 amendments. Today, that is the application we were lordship. And so far, other work orders are concerned, I have not come with before your lordship. Item 5 is another
Very well. So what about the claim?
27 lakhs in total claim. In item 4.
No, if you have claimed 27 lakhs, you have claimed 27 lakhs in all 5 applications.
Parent and 4. Parent.
How can you do that, Mr. Nondi?
Very well, Madam. Can you?
Can you not understand?
Yes, Madam.
how
I
to do
understand.
that?
What is falling for your lordship, I understood. For a moment, give me a second.
What is this?
That has not been ascertained, my lord. So far, the
No,
first claim is
there is an obvious error in the claim which the petitioner now seeks before the court, in respect of which the petitioner seeks appointment of an arbitrator. Stop. The notice issued by the petitioner under section 21 of the 1996 Act on 12th November 2022 mentions the parent a work order of 1st August 2018, but a claim of approximately rupees 27.78 lakhs. Stop. Admittedly, the claim relates to not only the work order of 1st August 2018, but 3 others or 4 others.
4.
But 4 other work orders which were issued by the respondent's contractor on the petitioner. Stop. Next, how much time do you want to come back with the prayers? 1 week?
Within a week, we shall cover.
List this matter on 2nd August 2023 for the advocate on record of the petitioner to make suitable corrections.
Grateful.
Next.
Same order I'm praying before lordship, item number 4 and 5.
Similar,
I don't know, 5.
Similar
Similar,
objections, my lord.
Same order.
Claim amount is different, my lord. Claim amount is different, but the objections, my lord, relate to the same. Deeply obliged, my lord.
ওই ক্লেম অ্যামাউন্টটা দিও না কিছু, বুঝতে পেরেছো তো? ক্লেম অ্যামাউন্টটা শুধু যেটা বললাম সেটাতে থাকবে, পরেগুলোতে ক্লেম অ্যামাউন্ট The claim amounts are different in the others.
Different.
Yes.
That is 19 lakh in item 5.
Just tell my court officer the claim amounts, please.
Item 5, 19 lakh. claim amount. So item 4. 19, 19.
Yes, next.
Item number 6, Mickey Metals Limited.
I appear for the petitioner, Milord. Can I hand over the copy of the affidavit of service, Milord? But it has, Lordship will kindly take page 5, Milord. It has been returned.
This is what section?
Section 11, Milord.
Yes. Page?
Milord, service page 5.
Yes.
Lordship will find on 8th of July 2023. Lord, the remarks is item return addressee cannot be
Page
located.
5. Page 5 of your application.
No, no, Milord, affidavit of service. Milord. No, it could not be, service could not be affected, Milord. That is what.
Yes, says item received on 11 July.
So that is to SO, that is sub office or something. Milord. And it has been returned with endorsement as returned. Milord. Lordship will
So how much
kindly-
more time do you want?
Milord, I am Milord, seeking for my substituted service.
Where are they based?
Lord,
Degonga.
yes, Lordship.
Degonga.
Yes, Lordship.
So what newspapers, how do you want to serve them?
Lord, in newspaper publication,
What newspaper?
one Bengali, one English. One Bengali, one English. Lord, may I also indicate one thing, Lord, that Lordship will kindly take,
I can't hear you.
Lordship will kindly take page 22 of my application.
Yes.
Lord, the arbitration agreement is, Lord, unstamped. And that has to be impounded.
So then what's the point of service?
Lord, then Lordship. will
First you have to
impound-
do this,
Very
then you serve. What's the point in serving them and dragging them to court and then saying that you have to, the collector should impound the document?
I bow not to Lordship.
33 to 35 of the Stamp Act?
Yes. And as held by Lord, the NN Global 5 judge.
Yes. Learned counsel appearing for the petitioner, comma, who seeks appointment of arbitrator, comma, submits that the agreement entered into between the parties is an unsigned and unstamped document.
Unstamped. only.
Is an unstamped document. Stop. Counsel therefore seeks appropriate directions on the collector, capital C, under the Indian Stamp Act, comma, 1899 or 1889,
Lord, 1899.
1899, for taking the needful steps, Stop. Next, AP 402 of 2023 is accordingly adjourned for how much time?
3 weeks. Lord.
For 4 weeks from today. Stop. The appropriate authorities under the 1899 Act, under the Indian Stamp Act, will impound the document and assess the stamp duty payable in the meantime, before the returnable date. Stop. The question of service shall be considered later.
Grateful. Lordship.
Item number 7, A1 Associates and others.
But I'm appearing for the petitioner.
Appear for the respondent.
This is my application under section 11, subclause 6 of the Arbitration and Conciliation Act for appointment of an arbitrator. But the dispute, if the Lordships will kindly take the petition,
Yes.
that the dispute arises out of an agreement dated 19th of March 2014. Lord, I am a carrying and a forwarding agent. Lord, I entered into a contract with the respondent. The respondent is a manufacturer of medicines. And as a carrying and forwarding agent, my lord, I am supposed to, my lord, distribute his medicines and his products in the state of Odisha and also store his products because I own certain warehouses also. The agreement was for a period of 2 years, my lord, starting from the year 2014 till 2060. And the agreement under the agreement, I'm entitled to commission. The consideration of the agreement is commission on the basis of the goods that I sell and also the expenses that I incur during the course of the transaction. But in 2006, the agreement also contains a renewal clause under which, my lord, the respondent can, either the petitioner can exercise its discretion, apply to the respondent for renewal, or the respondent, my lord, can renew the agreement at its own discretion for indefinite period, for which there is no requirement of any agreement into writing.
Yes.
And in the present case, the respondent have exercised its discretion. The agreement was renewed, although not reduced into writing, but it was been renewed, my lord, till
Who the respondent exercise discretion?
respondent exercise. Of course, my lord, with mutual consent, the petitioner gave its consent. And the agreement was renewed till 2021. In 2021, we come to receive a notice from the respondent where we come to know that they want to terminate the agreement and they do not wish to continue further. But we'll kindly take page 14 of my application, which is the agreement dated 19th of March 2014. But at page 16 of the application, my lord, my appointment is confirmed.
Yes.
And the term, your lordships will see the clause term. It shall come into effect from 1st of April 2014 and shall be in force till 31st of March 2060.
Yes.
And the renewal clause, right, my lord, the next clause, my lord, the first one says that the petitioner would apply for renewal 30 days before the expiry of the agreement. And right at the next page, at page 17, clause 2, on expiry of this agreement, the company may at its sole discretion renew the same for further period of 1 year or such further period as
Company is the respondent.
the respondent.
Yes.
Or such further period as mutually agreed upon on such terms and conditions as may be decided at the time of renewal. The contract, my lord, admittedly came to an end on March 31st, 2016, but thereafter, with mutual agreement between both the parties, the contract was extended, which I will, my lord, disclose from the correspondence between the parties, because in the year 2016, 2018, right up to 2021, I have been paid commission. And the expenses also that has been incurred by me has been also paid to me from time to time. But this would, your lordships, this will be indicated at page 43 of the application.
43.
43.
Yes. What is 43? Why do you want to rely on this?
It's an email,
Yes.
my lord, dated 1st of September 2016, after the date of termination, addressed by the respondent to the petitioner, whereby, my lord, admitting that we have transferred a sum of rupees 489,168 towards commission up to July 2060. So beyond the period of contract, my lord, I was paid the commission till 2060. So the contract, my lord, in my first submission would be that the contract was renewed under the agreement, which would be, my lord, evident from the correspondence between the parties. Lord,
Yes.
next page, page 44, is also another email dated 12th of September 2016. Lord, once again addressed by the respondent to the petitioner, my lord, stating the commission, the statement of commission, my lord, which is payable for the 3 years as it was indicated by the petitioner. Lord, at page 47, my lord, last one document, my lord, is the bank statement of the...
So, but Mr. Sarkar, these things are in any case of 2016. You're saying that it was renewed up to 2021.
Yes, my lord, in 2018 also I have been paid, my lord, which is why I'm showing the bank statement.
Yes.
But in 2018, at page 47 is the bank statement. Page 49.
Yes.
But third entry, 1,99,000, my lord, paid in the month of January 2021.
But page 50, the first entry, 481732. Not paid by the respondent. 55.
That's of August 2018.
2018. So lot 2016 payments were made, 2018 payments were made, and till 2021, my lord, payments were made to the petitioner under the same arrangement. But one important factor, my lord, which I missed out. Under the agreement, my lord, there was a security deposit, which was, my lord, we deposited a sum of rupees 25 lakhs, which was to, my lord, also continue till the time of the subsistence of the agreement. So till 2021, the security deposit was also, my lord, withheld by the respondent, admittedly, not denied.
So withheld post 2016
But 2016, my lord, with mutual consent between both the parties.
and till withheld till?
The 2021, it is still lying with them.
Yes.
But at page 52, my lord, few more documents I'll indicate.
Just tell me the point, please.
But the point is, my lord,
That the agreement did not then terminated in 2016, but
2016 continued till
Conduct of
2000.
parties.
Conduct of the parties. My lord, I'll rely upon a division bench judgment of the Delhi High Court also. Lord, before that, if I may draw your lordship's attention to the arbitration clause at page 30. My lord. So the clause is wide enough to confer, my lord, disputes between the parties, any disputes between the parties, man, irrespective of the time frame. Because today he withholds my security deposit and he offers to repay it back to me also. I've enclosed the document to that.
And how much is that? 25 lakhs?
25 lakhs, but he says that since my stocks are lying at your disposal, I'm going to adjust it against that. And after adjustments, I will pay whatever is the remaining amount which is due and payable, which I am denying.
So why do you want an arbitrator?
But we
You
want-
can settle it between the both of you.
But there is no settlement between the parties. We have, in fact, my lord, written letters, my lord, to the respondents indicating that please repay me back my security deposit and also my.
So it's not better to settle between the two of you rather than pay the arbitrator?
Lord, my lord, two headings, my lord, I'm entitled to payment. My lord, one is the commission, and also which they are now denying because they now say that the agreement was terminated in 2016. So you're not entitled to any commission. And the security
And
deposit.
I'm just saying because once the court appoints an arbitrator, then the arbitration usually goes on for 3 to 4 years.
Your lordship is right, my lord.
And
but-
then
but-
parties go on paying the arbitrator so much of incidental expenses. Then the parties will want adjournments, arbitration will continue for years. So that is something which I want to stop.
But the respondent has to come with an offer, my lord, because in this case they have denied, because they have come with an argument that the arbitration agreement now ceases to exist. You cannot refer it to arbitration because the contract was terminated.
You want to oppose the application or send a proposal for settlement?
I don't oppose the application.
Oppose the application. What is the ground?
That firstly, Millard, what has been argued today, Millard, that is completely contrary to the pleadings.
Contrary to the pleadings. That's the
Yes.
best point.
No, I'll come to that. There is not even a pleading that it was ever renewed. The simple, Millard, the
So let
pleading
the
is,
arbitrator decide all that,
No,
whether renewed, not renewed.
but Millard, the Honorable Supreme Court has already held that the arbitration can only be with respect to the dispute covered by the arbitration agreement. And it is my case that on
So then
31st,
why did you go on paying till 2021?
that was subsequent. That was, Millard, on mutual terms, the transactions continued, but not under
So the
this.
payment was with regard to some other contract, not the arbitration agreement.
No, not the agreement which covers the disputes. But what had happened in 2014, the parties entered into an agreement. That agreement was came to an end on 31st March 2016. As far as the dispute covered till that time, whatever the transactions between the parties are definitely, I cannot deny, is covered by arbitration. But then the question will also arise about limitation. If it's a
And
debt
so
claim,
there are no outstanding amounts under that agreement which came to an end in 2016.
even if there be, Millard, that I have not ascertained, Millard, I can, but that is also, Millard, as on date is time barred. It's a ex facie barred by limitation, and it's a dead
The
good
claim is barred by
Yes.
limitation.
Yes, because the cause of action had evidently could have arose on or before 31st of March 2016, not thereafter. And the transactions subsequent to 31st March 2016 were not under this agreement. It was on mutual terms, maybe oral agreement, whatever it may be. But then the arbitration clause, my lord, may I place it once? My learned friend says,
Your correspondence and mails does not refer to this agreement at all.
No.
Just ad hoc payments.
Yes.
For some other transaction.
For the transaction subsequent to 31st March 2016.
What do you mean by transaction subsequent? What does that mean?
Subsequent to 31st March 2016.
Yes.
Because the parties continued to transact.
Under that agreement?
No, that is my contention. Because that agreement stood determined as on 31st of March 2016. The transaction subsequent to that cannot be covered by the agreement, terms thereof, or the arbitration condition.
So you entered into a new agreement with
yes,
the
but
petitioner?
old terms.
Oral?
Yes. Subsequent to that, it was
Not
entirely.
acceptable. Yes, your
Lord,
next point. Your next point. Yes.
Lord, Lordship will kindly take page 30 of the petition, Millard. May I refer to the arbitration clause, Millard, and I'll place only one judgment.
Yes.
That any dispute or difference between the parties thereto arising out of.
I've read this.
Again, Millard,
this agreement.
yes, Millard, this agreement. So, Millard, the transactions subsequent to this agreement are not covered by this arbitration clause. That's
I'm asking you. So the fact that you continue to pay the petitioner till 2021.
Yes.
Was that under a fresh or a new agreement?
Yes.
Yes.
Under a fresh agreement, but not
Show
a
me
written
the
agreement.
agreement, please.
There was no written agreement there.
No written agreement. Very good.
And Millard, as far as renewal is concerned, Millard, it's his words versus my words. There is nothing
So
in
therefore
writing.
the arbitrator will decide that.
But there is nothing in writing whether there is at all any renewal or not. And that is not also the ground that they are clear. They are
very well. No, I
seeking
will
for
not go into the
adjudication.
merits. I will just say that the arbitrator will decide this. Yes.
But the contradiction of the argument is that there was a fresh agreement. Their own letter at page 58, which I did not indicate it, your lordships.
58.
58.
Yes.
Security deposit was in terms of the agreement dated in 2014, which is at page 25. And at page 58, he wants to now appropriate the same security deposit against the stock which is lying in my disposal.
Which line is that?
Third paragraph.
Yes.
According to the latest stock records provided by you, a stock value of rupees 890612 is still lying at your end, which will be adjusted with the security deposit amount.
If any.
Yes. And security deposit was given when?
In 2014, my lord, as per the terms of the agreement.
Yes.
Which is
Show me the
record-
terms of that agreement.
At page 25.
Then I'm denying the fact that they have ever paid any security deposit.
Very well.
There is
Denied
nothing on-
in the front of the arbitrator. Yes, page
Page 25.
25.
But the second clause, deposit clause.
Yes.
And at page 55, they write an email to me, promising that they will repay the security deposit within a period of 7 months. At page 55. It's an email dated 2nd of December 2021. So the contract, in my respectful submission, was, my lord, it was very well, but it was very much in existence between the parties till 2021, and in 2021, my learned friend's client had terminated the contract, because of which the disputes and differences have now arisen between.
Terminated when? Terminated on?
The 13th April 2021.
What is the claim now?
The claim is on account of refund of security deposit and the commission.
What is the claim?
Approximately
Amount?
35 lakhs.
35 lakhs.
35 lakhs.
Lordship,
Yes.
may I only indicate one thing, Millard. I have instructions that there is possibility perhaps for settlement. If Lordship allows.
Is this the first time you're talking about a settlement?
Yes, I think.
Or is this the second time? Or the umpteenth time?
No, there was no previous, my lord.
There was
settlement
never any
talks.
proposal for settlement.
I'm
from the
putting it after
surplus.
1 week, come back.
I'll just.
Yes, learned counsel appearing for the respondent proposes to explore a settlement between the parties. Stop this matter on 1st August 2023.
Grateful. Lunch.
Next.
I pay for the petition.
Item number 8, lovely promoters.
My lord, I pay for the petitioner, my lord. This is
What's your name?
my lord, Rishabh Dutt, my lord.
Petitioner's name.
My lord, lovely promoters. My lord, I will indicate, my lord, we will be praying for 10 days time, my lord. I will just indicate why. My lord, this matter, it's an invocation of an arbitration clause of an unstamped memorandum of understanding. My lord, the applicant.
So you want to go to the stamp?
My lord,
to
there
the
was a
collector?
division. Yes, my lord, I'll just indicate the background, my lord. My lord, there was a division bench, honorable division bench judgment where it has already been sent for impounding. We have already put in the court fees, my lord. And the original document
Court fees?
for the stamp duty, I beg your pardon,
Yes.
for the stamp duty, my lord. My lord, the original document is expected to come in. So 7 days time, my lord, I think we can complete the process.
So 7 days the collector will assess?
My lord, it has been assessed, my lord.
Already assessed?
Yes, my lord. Around, we have put in the money also. my
It
lord.
has been assessed pursuant to the division bench order, in an appeal which came up from a section 9 order. And they have requested for reconsideration of some points, that I believe is being done, or they are going to put in the money.
My lord, we have
Once that happens, there
Yes.
is no defense in this section 11.
Yes.
Kindly keep it, after 2 weeks. By then they should finish whatever they have to. If they have paid, I have no defense.
My lord, I will just put in a supplementary affidavit, my lord. Kindly grants me leave. We have already
Saying
deposited.
what? What do you
We
want
have
to say?
deposited the stamp duty amount, my lord.
If you're saying that, I can believe you.
Yes,
Why do you need why do I need an affidavit to believe what the council is saying in my court?
My lord. My lord, we have already kept it ready, my lord. We'll just
And
place
it's
it.
40 lakhs pay code?
Yes,
Oh, then it's.
We'll just hand over a copy, my lord.
learned counsel appearing for the petitioner seeks a week's time
Yes.
for bringing on record the assessed stamp duty which the petitioner pursuant to a direction passed by the division bench, by a division bench of this court. Stop. You know what the amount is, or you don't know?
Yes, my lord. It is
That's
around
40
40
lakhs 94,563.
My lord, yes, my lord.
The amount assessed is 45,96,563. That's what you said?
No, my lord.
4094,563.
563, my lord.
40,94563.
Yes, ma'am.
Stop. What do you want to do in this 1 week?
My lord, we will get back the impounded document, my lord. We'll put it.
Council submits that after payment of this amount, it's already, you have already paid
Yes,
it.
ma'am.
Council submits that this amount has already been paid and that the petitioner is awaiting return of the impounded document. Stop. Next, বললাম কি ডেটটা কবে আসবে? List is matter on which one? First week of August or second week?
Whatever, my lord, as per my lord's convenience. First.
List is matter on 3rd August 2023 as paid for. The supplementary affidavit of the petitioner is taken on record.
Item 9, Ritesh Agarwal.
My application under section 36, before I open my argument.
Yes.
May I pray for an accommodation for this week? The reason is personal. I am not passing through a very good phase of life. I am in some difficulty, not in the best mental state. I may
You as in you personally?
As a person.
What happened to you, Mr. Banerjee?
My clerk has met with a fatal accident. He is fighting a battle against death. It's a hit and run case. He was returning home Saturday night from my place only. Midway, met with an accident, has not gained consciousness yet, admitted in ITU. And my lord, as my lord knows, my lord, clerks are our my lord family members.
Absolutely, that's very
But I'm
unfortunate.
absolutely handicapped.
No,
Everything
apart
is-
from your discomfort, it's very sad.
my lord, kindly allow me, my lord, to come back
course.
anytime, my lord, next week.
Tell me when, I will put the matter on that date.
My lord, may I come back then on 7th? 7th is a holiday.
7th is all right, Mr. Sharkar?
Yes, my lord, whenever your lordship.
That's happy.
Yes,
7th holiday, na po?
list this matter on 7th August 2023 as briefed.
And may I also indicate, my lord, this is section 36, item number 15, my lord, is section 34, same note. My lord, I can wait. my lord,
Mr.
for the matter.
Banerjee, please wait. I will
I
pass
will-
that order.
I
Or
will.
if you don't want to wait, ask
No,
your
no, my
junior
lord,
to
I will.
wait.
I will.
Yes.
Item number 10 for hearing, Ram Pujan.
I am for the I'm led by Mr. Shah. He is now today engaged in courtroom number 1 since 2:30.
Adjournment is paid for on behalf of counsel appearing for the petitioner.
Lordship had put up this matter for passing orders, my lord. Your lordship has already heard this matter.
No, but I need counsel that
Lordship.
let the court decide.
Lordship, I'm sorry, my lord.
List this matter on 1st August 2023.
Grateful.
Next. লিখে দাও তো একটা learned counsel appearing for the state and the added respondents should be present on that date.
But I am
Next.
for the added respondent.
Next.
None.
11,
Same prayer.
Same, my lord.
Same order.
12,
He also said.
Same prayer.
Yes.
item number 13, Ashif Latif.
Lord, I beg to appear on behalf of the petitioner in this matter. I am led by Mr. Orindam Banerjee in this matter. I am praying for a short passover.
What is this
I
application
appear for
under?
the official. That's number one.
I appear for the respondent number
My lord,
four.
this is with regard to locking up of a tenanted shop room at 56A Mirza Ghalib Street, and thereafter my lord has intervened into the matter and thereafter ordered for removal of the musical instruments from the shop, and my lord has appointed a special officer and in presence of the special officer, the musical instrument has been removed from the shop and the special officer has filed his report. And my lord, on the last occasion, that was on 7th of July, my lord, my senior, my lord, Orindam Banerjee has made an outline of his submission regarding the matter and why his matter is so
So
much.
what is the relief you want now?
Well, I want the shop may be handed over to me because it was forcefully taken from me and an official government and a government officer
Yes.
without following the due process of law as laid down in the West Bengal Premises Tenancy Act as well as in the Transfer of Property Act cannot take an high-handed action by taking over the position of a tenant who is a bona fide tenant who is paying the
So
rent.
it's a mix-up between 226 and the provisions of
No,
the
it's-
premises tenancy act.
My lord, it's a mix. It's actually, my lord, it's an high-handed action on behalf of the official trustee who has taken over the position without following due process of law, where his suit has been dismissed before the Presidency Small Causes Court, and thereafter the restoration was also dismissed. There was certain submission, and my lord asked to bring certain judgments or certain authorities with in support of our submissions, my lord. So, my lord, I'm praying for a short Passover, my lord. I will. As my-
330. 330 is all right with you?
330.
330?
It is, dear lordship.
Yes.
Fourteen, Bimal Chandra Roy.
My lord, Mr. Shubhashish Sengupta is appearing as the counsel, my lord. I'm praying for a short Passover, my lord.
330. Next.
15, Ritesh Agarwal.
Yes. When do you want it, Mr. Banerjee?
7th August, my lord, the other matter has been kept.
Yes. List this matter on 7th August 2023 as paid for.
I'm grateful to your lordship. Grateful.
Item number 16, Shambhit Basu.
My lord, I appeal for the respondent.
34.
My lord, 34.
What is the grounds of challenge? What are the grounds of challenge?
No notice under section.
Microphone, please.
Well, it's no notice under section.
That's a fact. What is the law?
Law, that's 34, 2.
You will search the law now. Search out the law now.
2A, subclause 3. But the
What is that?
proper-
You were not given sufficient opportunity to
proper no-
represent your
proper-
case.
Proper notice, that is there also. One is the proper notice has not been given so far as the appointments and so far as the proceedings is concerned. Section 21 also not there. Nothing has been given. First point. And the second is that this is an
Microphone and speak properly, please.
second point is that your lordships has already delivered a judgment on that aspect. That is the unilateral appointment has been given.
Sorry? Which
The
one?
appointment of arbitrators is unilaterally given.
Unilateral. So you want to rely on that? But I have held in my judgment that unilateral appointment is not a problem.
But always not the issue has not there. Always not the unilateral appointment.
So you want to rely on that? I have held the opposite.
Your lordship, kindly, I am relying on 2 judgments of our court in respect of the executions matters and the Parkinson's matter also.
Parkinson's.
The part of that these.
The judgment is Parkinson's, as in the disease.
Parkinson's. Sorry, man. Sorry, man. And the other 2 judgment of our court.
Learned counsel appearing for the petitioner most certainly needs to get ready in the matter.
Your lordship.
Stop. Counsel is expected to look at the relevant case law in support of the argument that the impugned award is required to be set aside on the ground of unilateral appointment of the arbitrator. Stop. When will you get ready and come back?
Only not this the other points are there. I have taken your lordship.
When will you get ready? I'm not
Let
sure
it
you
be-
will
let
get
it-
ready.
Let it be taken up tomorrow, my lord. I will.
Tomorrow?
I will. My lord, I will.
Costs tomorrow if you're not
My
ready.
lord, I know. My
This
lord,
is
I
matter
know.
tomorrow as a last
Right.
chance. Next.
My
If you say Parkinson's, I will give you,
Subject to
I
my
will
lord's
give you
correction,
10,000
subject
rupees
to
costs.
My lord, subject to corrections, my lord.
Yes, next.
I will be ready.
Prashantu Majumdar.
May it please your lordship, I am appearing for the respondent number 1.
My lord, I am appearing for the petitioner, my lord.
This is what, you're Mr. Roy
No, my lord, I am Mr. Chakraborty.
Chakraborty. I can't hear you. Microphone, please.
Sorry.
This is under 34.
No, my lord.
Then?
Under section 11, my lord.
11. Yes.
Before my learned friend starts, my lord, would be pleased to recall this matter was heard by my lord. My lord, the point was I had taken a point of maintainability. There were 3 separate agreements. My lord, the first agreement was with respondent number 1. The second respondent, my lord, the second agreement was with respondent numbers 2 and 3. The notice which they have issued, the first point was, my lord, the notice which they have issued under section 21, my lord, it's with respect to the agreement, my lord, where I am not a party. And they are seeking to invoke the arbitration through that agreement where I am not a party, my lord.
You are the assignee.
But I am respondent number 1, where it's a separate my lord, entity. Respondent numbers 2 and 3 are separate entities, my lord. There are 3 plots of land. My lord, they are the, my lord, the landowners. So, my lord, the first agreement.
And you are who?
I'm sorry, my lord, I stand corrected there. I am the landowner, my lord.
Yes.
My lord, they are seeking to develop the property.
Yes.
My lord, I have 1 portion of the land. Respondent number 2 has 1 portion. Respondent number 3 has 1 portion. First agreement they enter into was on 23rd of June 2013. That is with us, my lord, the respondent number 1. My lord, thereafter they enter into another agreement with the respondent numbers 2 and 3. That's on 23rd of June 2014. Separate, my lord, plots. Then they enter into a deed of amalgamation by which, my lord, these 3 plots of lands were amalgamated. That deed of amalgamation does not have an arbitration clause. This deed of amalgamation was acted upon. After this was acted upon, there was a sanction plan in terms of the deed of amalgamation. And this sanction plan was thereafter, my lord, the basis of their developing the property. Any dispute, my lord, first of, my lord, if they have a dispute, then through the deed of amalgamation, it's a separate agreement, which does not have an arbitration clause. But my first point of objection was, my lord, section 21 is issued to the respondent number 1. That's my client, my lord. The reference is to the agreement, which is dated 23rd June 2014, which they have entered into with respondent numbers 2 and 3. The notice admittedly is not addressed to respondent numbers 2 and 3. It is addressed to me.
So he is relying, your learned friend is relying on which arbitration clause? The one with the respond numbers 2 and
With the
3?
numbers 2 and 3, where I'm not a party. At all.
And he has addressed that to you.
He has addressed that to me and he wants to initiate arbitration against me. Because according to the pleadings, according to the
No, maybe
petitioner.
he's got mixed up with the respondents.
Yes.
Is that the case or not?
Yes, my lord, that is the right point.
Because
My lord,
the-
You're mixed up.
No, my lord, please come to page number 99, my lord.
That is my
That is
preliminary
only a
objection.
typographical mistake.
Typographical error.
Yes, my lord. My lord, please see, my lord.
But are you saying that you have also typed out the date of the agreement wrongly?
The date of the agreement is 23rd June 2013. The date with respondent.
2013 is with the respond number 1.
Yes, my lord.
2014 is with the respond numbers 2 and 3.
2 and 3. And 23rd June 2014 is the registered power of attorney with him and also with the respondent number 1. And also 23rd June 2014 is also for respondent number 2 and 3. First, I thought that respondent number 2 and 3 is represented by him as because by law.
That's immaterial.
Yes, earlier order is represented. Now, when the section 21 notice has been issued, my lord, the notice there written is 23rd June 2014. So first it was written at 2014, 13, then it was corrected at
So what should the
2014.
correct one be?
2013, my lord.
2013.
Yes, my lord.
That is the one with Mr. Bag.
Yes, my lord.
And that has an arbitration clause.
Yes, my lord. That has an arbitration clause. The document has been impounded by the order of other honorable judges.
Everybody is saying that you impound the document.
Yes, my lord. Justice Bashak has ordered for that impounded document. Honorable Justice Prakash Srivastava has recorded in the order. The order is impounded document has come before the honorable court. That full court fee.
So the directions are being passed even before NM Global,
Yes, my lord.
even before NM Global.
First, the order was passed by my lord, then Justice Mr. Ashish Kumar Chakraborty. Then that was stated by Mr.
That was even before the pre-reference NM Global.
Yes, my lord. That is absolutely correct. But all the impounding has been completed.
So how many times was the document impounded?
2 documents, 1 time. My lord. 2 agreements, my lord. 2 agreements, all the impounding are completed.
Very well. So you're saying that the date in the 21 notice is required to be corrected.
Yes.
So if that is the case, then can I say in the section 11 that the 21 notice should be read as the agreement meaning 2013 and not 2014? Can the court say that? What do you think?
Yes, my lord.
Yes.
As because document, this is my humble submission. Document must be taken in the true spirit. They have not objected this. In section 9.
They are taking an objection now.
Yes, they have not stated objection before in the affidavit in opposition. 3 sets of lawyers have come. They have. Okay.
Please don't take points which are
Yes,
completely
madam.
extra legal.
I'm sorry, ma'am.
I'm only interested in the law.
Yes,
Please
ma'am.
go on the law.
Yes, ma'am.
Yes.
This is the only.
So you think that a section 11 court can say that the 21 notice should be read as this date and not as that date? That the court can do?
My lord.
Simply because a preliminary point has been taken and the court cannot do that. Because if the court does that, then it would mean that the agreement which is being referred to concerns 1 and not 2 and 3, which was the original intent. That the agreement is with 2 and 3 and not 1. Have you understood?
Yes, my lord.
Yes, Mr. Bag.
If my lord holds that, then I have to pray my lord's leave to file afresh.
Where is the 21 notice?
Page 99, my lord.
Every agreement you're writing of the Christian era, every agreement. Except that you're getting the dates wrong. The petitioner admittedly invoked the arbitration clause by way of the notice sent under section 21 of the 1996 Act on 11th June 2018 by invoking in terms of an agreement dated 23rd June 2014. Stop. Although the letter was addressed to the respondent number 1, comma, the agreement, comma, the respondent number 1 is not a party to the agreement dated 23rd June 2014, which was entered into between the petitioner and the respondent numbers 2 and 3. Stop. There is a separate agreement governing the relationship between the petitioner and the respondent number 1, and that is of 23rd June 2013. Stop. Next. You're the counsel.
No, my lord, advocate.
The advocate on record of the petitioner admits to this position, takes the above stand and submits that the 2014 is a typographical error, since the petitioner wanted to mention the agreement of 23rd June 2013. Stop. Next, since learned counsel appearing for the respondent number 1 has taken a preliminary objection with regard to maintainability of the present application, on the ground that the respondent number 1 is not a party to the agreement which has been invoked in the notice dated 11 June 2018, comma, the petitioner is given leave to withdraw the present application and file afresh. Stop. Do you want to do that or not?
Yes, ma'am.
AP 9 of 2020 is accordingly dismissed as withdrawn with liberty to file afresh.
I'm deeply obliged.
Deeply obliged. My lord, one small prayer. Original impounded agreement, my lord, department may be directed to hand it over by keeping a Xerox copy, my lord.
Which is the original impounded agreement?
That is with lying with my lord's office. Original agreement is also আপনার কাছে আছে?
Which is this, 2013 or 2014?
Both, my lord. 2013.
Yes, so what is it that you want?
I want to take back the original agreement and
Very well. The original agreements of 2013 and 2014, which were earlier impounded for assessment of stamp duty, may be returned to the advocate on record of the petition.
obliged.
Deeply obliged.
Item number 18, Mrs. Hindustan Builders.
This is my application under section 11. My lord was pleased to hear these applications on the last occasion. That is,
I can't understand. Please speak.
my lord was had this application on 17 July, and on the said date, my Laden friend, or I'm for the petition, but my Laden friend took a point that this claim is not alive, number one, and number two, since I have submitted no claim certificate, therefore subsequent dispute raised by the petitioner is not maintainable, and that is not arbitrable so far the dispute is concerned. So my lord, my Laden friend
Not alive as in the sense of barred by petition.
that was his contentions, barred by limitations. My lord, I am covered by the judgments of Honorable Supreme Court, my lord, BSNL versus Nortel. So my Latin friend also relied on this Nortel, but so far my responsible submission before your lordship is before your lordship that paragraph 47 says. So firstly, my lord, as your lordship knows, these judgments, Honorable Supreme
BSNL versus Nortel, Justice Malhotra.
Justice Malhotra.
No, but I don't know, subject to correction, that judgment is on
the point of limitations.
not only don't say limitations, please, on the point of limitation.
Limitation.
But over there, the limitation was, I think, dissected into one, the substantive claims and the section 21 notice.
Section 21 notice and filing of application
Yes.
under section 11 on two grounds. I grateful to your lordship.
Yes.
So my lord, paragraph 47 is my point, but I rely on paragraph 47 of these judgments, where the Honorable Supreme Court said.
Which
that
one? Which one? Nortel.
Nortel. But
To say what?
So if there is any slightest, but any doubt, but that
Then arbitrator should hear.
arbitrator should decide. So
No,
my
but I don't think I'm in doubt. Doubt as to what?
doubt will not see whether the claim is time barred. And second, since I have submitted no claim certificate, whether the dispute raised.
But what makes you think that the court is in doubt?
No, minute,
I may be completely in favor or against you.
not in favor of me. I believe not in favor of me. So my responsible submissions kindly appoint an arbitrator. Since this is 2020 matters, already one round of litigation was there. It is now over. My lord is hearing afresh. Kindly appoint any persons, my lord, as an arbitrator.
Mr. Nondi, is that the way you do a section 11 application? I asked you this question earlier on in the day.
Lord.
How do you do a section 11 application?
But at first I am to place.
That just appoint an arbitrator
No,
and
no,
that's
I
it.
have to place the arbitration agreement first. My lord, then,
And what else do you have to place?
but then arbitration agreement, parties raise the disputes, but or my lord, either accepted or rejected. Then invocation of the arbitration, section 21 arbitration clause.
So have you done all that?
Yes, everything I have done.
Very well. If you've done that, I will dismiss it because of insufficiency of preparation. Yes. Yes, Mr. Ghosh.
Yes, my lord, even my learned friend submission that as per the arbitration agreement, but even in the by the arbitration agreement, the claim is time barred because, my lord, on the 2nd September 2021, they 2020, my lord, they first invoked the conciliation notice.
Yes.
And on 11th September 2020, the petitioner refused conciliation. Then, my lord, on 1st October 2020, my learned friend's client wrote to the petitioner, state and the chairman and managing director, as per the terms of the arbitration agreement, that you appoint an arbitrator. My lord, that was not done. But my lord, if my lord takes clause 45.2, I will not trouble your lordship with other clauses. It very specifically says that no claim shall lie after 60 days of refusal of the conciliation notice. My lord, then on 11th September 2020, my client refused to go into conciliation. Therefore, they should have filed this claim or come before your lordship before be on or before 10th of 10th of
Ghosh, you're complicating the facts. You just have to show, are you saying that the 21 is barred by limitation or the substantive claims are barred by
the
limitation?
claims are barred by limitation.
Very well.
Claims
So
are barred.
then you just have to show the 3 years limit.
And,
That's all.
yes,
That
my lord,
you're not
that is
showing
the
that.
claims are barred as per the agreement. It is
Just
barred
give me
by.
the dates that which was the last date according to you, they should have filed the claim and when they actually came and filed the claim. That's all.
Yes, my lord. The last day, the conciliation notice they gave on 2nd September 2020, and we refused it on 11th September 2020, and they asked for they don't invoke arbitration within 60 days from that particular date. My lord, therefore,
From which particular date?
from 10th of September, 10th of November 2020.
Mr.
10th of
Ghosh,
19.
please file something because every time you're saying a different month. Once you're saying September, then the next time you're saying November.
I have a list of dates prepared, my lord. Serial number 14, my lord.
No, this is on which point? That barred by limitation?
Entire list of date barred by limitation will come from serial number 14, my lord.
14. Very well. Yes. What do you mean by the contract has
Barred
been
by the
discharged?
limitation under the Limitation Act, but then it is barred under the
Does it
agreement.
mean that the contract has been discharged?
No, contract has been discharged in 2018, my lord. That is 2018, my lord. Serial number 8.
Mr. Ghosh, I'm asking you, what do you mean by contract has been discharged? That's what the list of dates says. That's it.
But perhaps that is the language used in that in the notice, discharge. The contract has been fully performed. Contract was completed on 12th December 2017. That date, the contract was completed. They have completed.
Very well. From serial number 14, how does that help you?
or my lord comes from serial number 7, actual date of completion of contract.
You would have to get ready. Yes. Tell me, Mr. Nandi.
My lord, my first claim I have registered, my lord, with them on 2nd September 2019.
Yes.
So, my lord, that is, and second, my lord, further, my lord, I sent a notice for requesting them for conciliation on 19th June 2020. Then, my lord, they have replied that notice, rejecting the prayer for conciliations. Then I sent section 21, I invoked the arbitration clause, section 21 notice sub. That was on, my lord, at page 38.
1st October.
Is 1st October 2020. And they refused to appoint any arbitrator, and also my claim and dispute by a letter dated 27th October 2020. I have filed this application under section 11 on 7th December 2020. So my humble submission, there is no bar, no claim is not bar. So for the section 11 application is no bar.
Are you relying on something, some list of dates or something?
Only one
Well,
Are you
agreement.
relying?
I
Please,
didn't
you're not
submit.
ready, please.
I
Yes.
didn't submit any list of dates. So far, my lord,
Very well. I'm keeping this tomorrow. Do it.
lordship.
Yes. Learned counsel appearing for the advocate on record of the respondent takes a point of the claim being barred by limitation. Stop. A list of dates has been placed on that purpose, but without much clarity. Next, learned counsel appearing for the petitioner will file a list of, will prepare a one-page list of dates to lend clarity to the matter. Stop. List this matter tomorrow.
Good. All right.
Next.
Complete a copy there.
Pass over matter, item number 13, Asif Latif.
May please, Your Lordship.
What was the further relief you wanted?
Lord, the relief that we are seeking, Lord, is, Lord, for a mandamus directing them to allow us to have access to our tenancy, because the official, if your lordship recalls, the official trustee, my lord, which was taking care of properties belonging to the Armenian church, under which I am a tenant, has expressly locked me out, my lord, from my premises. Locked me out because it says, according to its affidavit, that a person present there had, on its asking, handed over the keys to it, and it is now keeping those keys with itself.
So what are you doing with the musical instruments?
The musical instruments have been taken out. They have been, my lord, dealt with, sold, some repaired, some I am told are extremely valuable, my lord. They are in fact invaluable assets, my lord, to the person who owns it. Now we have, my lord, taken them out, and
you're not the owner.
I'm not the owner of these instruments, my lord. I deal in these instruments. I bring them, my lord, from outside. I deal with it, deal with these instruments in my shop, and I sell it, my lord, to all and sundry. Sometimes I repair, and therefore, my lord, that's my business that I carry out, my lord, in the shop in question. Now,
very well. So now you want to get inside the shop.
Now I want to get inside the shop. There's only one question, Lord. I had outlined it earlier, my lord, on the earlier occasion when your lordship had occasion to, my lord, deal with this matter in terms of the final relief. I say, my lord, and with great humility, that I am protected by the provisions of Section 6 of the West Bengal Premises Tenancy Act. I am a premises tenant under the Armenian Church. The Armenian church can dispossess me, but not otherwise than by due process. Due process over here would mean institution of a proceeding.
Who's the owner of the property? The
Owner
Armenian
of the property
church.
is the Armenian Church. The official trustee under a scheme is managing the properties, my lord, of the Armenian Church. Therefore, at best, it is a trustee or a
And
custodian.
who ousted you from
The
the property?
official trustee ousted me, and he's taken responsibility in his affidavit saying
Under
that
the directions of the Armenian church.
he has not. He says that he's done it on his own accord. That's even worse. That's even worse. Because, my lord, there, if he could have said that my principal has told me and I'm an agent, and therefore you tell my principal to answer up, then that would be another question, which would also be, my lord, answered to the negative, if your lordship is with me. But here it's even better. The official trustee says, I feel that you have sublet your premises to someone else, and therefore I have taken back possession from you. Now, if this happens and is allowed to happen, it is set a very
No, no,
dangerous.
so,
precedent.
so there's the tenancy agreement between you and the Armenian church.
There was, my lord, Armenian church and me, there's a contract of tenancy, which is evidenced, my lord, by payment and acceptance
And
of
that
rent.
says that you can't sublet.
Under the laws of the land, I cannot sublet without the prior consent, my lord, of the landlord. I have not sublet. Braganza and Company, which also deals in musical instruments, keeps a part of its instruments with me so that I can sell them. That's part of my business. Whether I have sublet or not is a question which is to be decided by a competent forum. And if my tenancy is terminated by a pre-suit notice and a competent forum is approached, then I will, as a defendant, be entitled to defend the fact that I have sublet. After that, and only after that, can a decree of eviction be passed against me, dispossessing me from my shop. There is nothing in law in which, my lord, the landlord or his agent can walk up to, my lord,
And notice given for eviction or not?
not. No notice, my lord, has been served. What they did is, they say in the affidavit in opposition, I found a Mr. Braganza present in your shop room. I requested him to give him the keys, give me the keys, and he gave me the keys and I took it and I kept it in my custody ever since. If this Mr. Braganza is not a tenant, then his handing over the keys, my lord, to the official trustee, my lord, would not otherwise, my lord, help the official trustee at all. My tenancy does not
So
get
if according to you, Mr. Whoever was present was not the tenant, then how could he hand over the keys to the official trustee?
because he was present in the capacity of persons, my lord, taking after the, my lord, care of the goods of Braganza and Company. He was there. I was also there. I had gone out. He was there. I am very much there in the premises. Lord, I am not for a moment suggesting that the plea of subtenancy, illicit subtenancy, which he has taken, is not available to him. I am simply saying that because of his perception that I have illegally sublet, he cannot dispossess me straight away. He has to approach a court of law. Under Section 6 of the West Bengal Premises Tenancy Act, there are grounds enumerated under which he can sue me, Lord, and recover possession in accordance with law. The fact that he's an official trustee in whose custody the property of the Armenian church is, does not put him on a higher pedestal at all. The Premises Tenancy Act 1997 doesn't exclude building or premises owned or controlled, my lord, by the official trustee from the, my lord, ambit of the act. I am protected by the act. So what he needs to do is, if he feels that I have illegally sublet, he can't interfere with my possession.
So this is not Braganza as in the piano shop?
This is Braganza as in the piano shop. We had a senior master at St. James's, my lord.
No, I'm not sure whether I can, because I constantly go there and they come to my house for the piano, for repairing the piano and whatever, polishing it, etc. Then
our junior master at St. James's School, my lord, was attached to Braganza, Mr. Roderick. He used to play, my lord, the organ. I know Braganzas from then. But then my knowing Braganzas would not really.
No, is this, am I dealing with the Braganza shop?
You are dealing, my lord is dealing with the shop of Latif, Paramount, which is not Braganza. But there's an allegation that Braganza or someone from the Braganzas is an alleged subtenant.
There is an agreement I shall show between him and not him. One Latif Tisar and Company and D.K. Braganza, Mr. D.K. Braganza, Braganza and Company. They have, there's an agreement. They are possessing that. They are paying rent to them, to Latif Nissan at the rate of 35,000 or 1% of their total sales per month, whichever is higher. The Braganza and Company. Dealing with Mr. D.K. Braganza.
Very well. anything else, Mr. Banerjee?
My lord, only to outline, my lord, a bit of the law. The only part of the law, my lord, which I have to place, my lord, on the earlier occasion, I had outlined it just for your lordship's kind consideration very quickly. I have already submitted that I am not claiming immunity from the consequences of alleged illegal subletting. I am only saying that the landlord or his agent cannot act as judge, juror, and executor rolled into one and dispossess me from the premises on the perception that there's an illegal subtenancy.
Who is the juror and who is the executor?
Over here, my lord, all three, my lord, are the official trustee. In the manner in which he has functioned, he is now turning out to be an officious trustee as well. Now, my lord, may I show you, lordship, my lord, Section 6, my lord, of the West Bengal Premises Tenancy Act just once. Now, my lord, this has a non-obstante clause. This protects, Section 6 protects all tenants everywhere in West Bengal, all premises which are covered by this act. This is the protection given to all tenants. And I say that I am entitled to this protection, my lord, Section 6, subsection 1.
Yes.
notwithstanding anything to the contrary contained in any law for the time being in force or in any contract, no order or decree for recovery of the possession of any premises shall be made by the civil judge having jurisdiction in favor of the landlord against the tenant, except on a suit being instituted by such landlord or on one or more of the following grounds. Ground number 61A, where the tenant has sublet, assigned, or otherwise parted with the possession or whole of part of any premises without obtaining the consent in writing of the landlord, or the tenant has used the premises for a purpose other than that for which it was let out without obtaining the consent in writing of the landlord. My lord kindly sees there are diverse other grounds that are given. Now, my lord, if one is to sue, my lord, for that, then one would have to first institute a pre-suit notice, serve a pre-suit notice. That's 6(4). Kindly see, my lord, subsection 4.
Yes.
Notwithstanding anything in any other law for the time being in force, no suit for the recovery or possession of any premises on any of the grounds as aforesaid, except on the ground mentioned in clause E of subsection 1, that is where the tenant himself wants to surrender, shall be instituted by the landlord unless he has given to the tenant 1 month's notice expiring with a month of the tenancy. Yes. This is the procedure established under the law for evicting a premises tenant from any premises which this act, my lord, governs. This premises is squarely governed by this act. Save and except this, my premises, my possession in the premises, my lord, cannot at all be interfered with by, my lord, the landlord. On any perception of any of the violations of this, it cannot be done. My lord, I just wanted to cite a lot of judgments, but only one judgment would have.
But if according to you, the statute is so clear, why do you want to cite a lot of judgments?
Only on what is, my lord, the due process. Due process involves moving an appropriate forum which would adjudicate the rights with the parties, decide on the rights and liabilities, and make an ultimate order on the basis of the claims made by the parties. That's a due process. We always use the term, my lord. Sometimes, my lord, almost, my lord, sometimes mechanically, my lord, I have used the term not to be evicted without the due process of law. What does due process mean in connection with eviction is what this judgment says. This is, my lord, a locus classicus in his own way. Though, my lord, it's a single bench judgment of the Honorable Bombay High Court, my lord, argued by Sirvai. The entire law on the subject, my lord, is here. So, my lord, due process essentially means, my lord, what I have submitted. It is a process by which one cannot.
As in the American due process.
As in the, no, this they took, my lord, recourse to the American due process came in, my lord, from Cardozo. This they have taken recourse to basically, my lord, the English jurisprudence as it has developed in India. American jurisprudence from Cardozo onwards, Marshall Cardozo, etc., they developed it. Justice Nariman, my lord, has accepted the American jurisprudence more than the English jurisprudence. So by Justice Nariman's judgment, my lord, now they are all law which governs us. This perhaps is a bit more classical. It's on the English jurisprudence, but says more or less the same thing. You cannot muscle anyone out of possession in India. There is nothing called re-entry by a lessor if any of the terms of a lease are breached. In India, a lessor cannot go and say, look, there are terms A, B, C, D. You have violated A, B, and C. I muscle you out of possession. That's not available to a lessor in India. Lessor has to file a suit, get him out of possession after getting a decree from a competent court of law. Similarly here.
You're using muscle as a verb.
I'm using muscle as a verb here. Muscle as a verb. Now, my lord, similarly, my lord, here I'm covered, my lord, by the West Bengal Premises Tenancy Act. Under the Premises Tenancy Act also, I am immune from eviction at the instance of a lessor unless he executes a decree of recovery of possession obtained in a competent suit filed by him under the provisions of Section 6 of the Act. My lord, this is the long and the short of my argument. May I just cite, my lord? Notice of motion number 82 of 2007.
Mr. Banerjee, how many do you have to cite?
One in which everything.
You said lot. That's
a lot of judgments have relied on here.
Very
so it's an
yes.
kind of a collection by. May I?
Yes.
This is a.
And give the citation to your learned friends, please.
In fact, this is appeal from order number 418 of 2008 in notice of motion number 82 of 2007. In short cause suit number 45 of 2007.
Bombay High Court, single bench.
Single bench of the Bombay High Court.
This is not, this is Mr. Justice Wazifdar, but this is not the original Mr. Sirvai.
This is Navroz Sirvai. This is Navroz.
Yes.
Original one is Mr. H.M. Sirvai. Namlot kindly takes, like there are Banerjees, a dime a dozen in Calcutta, there appear to be a Sirvais, a dime a dozen in Bombay. Namlot kindly takes, only certain extracts of this judgment which I want to place.
The judgment doesn't have paragraphs.
It has, Miller, but it's sunken into the body. It's actually, it does have paragraphs. Would your lordship kindly take paragraph 28A. Oh, that's at page 12. Pagination is at the bottom, right?
Yes.
Kindly come to the next page, in fact, paragraph 13. Sorry, page 13, the top of the paragraph, where there's a quotation, Miller, of the Honorable Supreme Court in Ramratan versus State of Uttar Pradesh.
Yes.
May I just, Lord, place that extract? Mr. Tarkunde, learned counsel for defendant number 3, the appellant herein rightly did not go into the appreciation of the evidence, either by the trial court or the high court, or the factual conclusions drawn by them. It was, however, strongly urged by him that the period of license had expired long back and the plaintiff was not entitled to the renewal of license.
No, Mr. Banerjee, just the last 6 lines are important for you.
Yes, we
Just
find
last 6
ourselves,
lines.
my lord, I'm grateful, Lord.
It is a well-settled
It is a
law.
well-settled. It is a well-settled law in this country that where a person is in settled possession of property, even on the assumption that he had no right to remain on the property, he cannot be dispossessed by the owner of the property except by recourse to law. If any authority were needed for that proposition, we could refer to the decision of a division bench of this court in Lalu Yashwant Singh versus Rao Jagdish Singh, 68 to SCR 203. This court in that judgment cited with approval the well-known passage from the leading Privy Council case of Midnapur Zamindari Company Limited versus Naresh Narayan Roy, AIR 1924, PC 144, where it has been observed in India, persons are not permitted to take forcible possession. They must obtain such possession as they are entitled to through a court. Lord, I rest my case at that. There's a lot of discussions of similar nature in this judgment. This has held the field now. English jurisprudence, now a bit of American has come in. After Justice Nariman, my lord, has accepted my lord Cardozo's view. So now, my lord, it's all the more clear now that I cannot be taken out of possession except by in execution of a valid decree.
Very well.
Passed
That
by
is
a
all,
civil.
Mr. Banerjee.
These are my submissions. I want to show you, lordship, lord, just give me 30 seconds to show that in their affidavit in opposition to which they have in my allegation of being dispossessed by being locked out on a particular date has not been denied. The official trustee has taken responsibility of the fact. He says that on his rounds, he found a gentleman by the name of Mr. Dicky Braganza there. He told Dicky Braganza to hand over the keys. He took the keys from Dicky Braganza and he's kept it ever since in his custody. That is, my lord, his statement, my lord, in his affidavit in opposition. If this happens, then the dispossession and the forcible nature of the dispossession qua me.
Very well. So you're saying that even if it is a case under 6A1 or 61A of subletting, even then they cannot do it without a 6-4.
Without a 6-4 followed by a decree under 6. 6-4 is the notice. They have to terminate my tenancy by a notice of notice to quit, where they cite the ground and terminate it. Even after termination, from a contractual tenant, I become a statutory tenant. I'm entitled to continue to enjoy. Thereafter, they have to initiate proceedings against me by filing a suit before the appropriate civil judge, get a decree of possession against me, execute the decree, and then take me out of possession. Before that, there's no way in which they can come up, ask any Braganza to hand over keys, tell me to hand over keys and keep it in their custody. It's not recognized under the law. And I'm covered by the Midnapur Zamindari case, my lord, 1924 onwards.
Yes,
Settled.
you're for the official trustee.
Lordship.
Yes, just start your submissions today, please, and microphone.
Lordship. My lord,
What is your defense to the 6?
petitioner, the
Yes.
petitioner before your lordship is one Mr. Asif Latif. He claims himself to be a tenant in respect of the premises. The records of the office shows he is not a tenant. Tenant is one Mrs. Paramount Refrigeration Company, way back in 1955, of which one Mr. Abdul Latif was the proprietor. Now, my lord, in this writ petition, he has filed it. He claims himself to be a tenant. And in the cause title, I shall show you to your lordships, not he describes himself as one of the partners in succession of Mrs. Paramount Refrigeration Company. Now, my lord, I shall show to your lord. He says that he carries on the business of musical instruments from the said premises. Now, I have disclosed in my affidavit in opposition.
Mr. Nondi, before you proceed any further, The law of the land now is that even a trespasser cannot be dispossessed
Lordship,
without due process.
I
That's
bow-
the law.
I bow down.
So
But
if the
he-
petitioner
I
is
have
not the
taken-
tenant,
but I have not taken free, forceful possession.
yes.
Mr. D.K. Braganza was the person I should show. I mean, I should, I claim my lord's leave to place that agreement, which he
Yes.
has not entered into with Braganza and Company. At that time, annexed in my affidavit in
No, no.
opposition.
So what did you do? You did not dispossess him.
No. He handed over the key. We requested, he came to the office, he handed it there, and thereafter their meeting in the office also, he came. He agreed to that.
He agreed to
Mr.
what?
Braganza, that he had handed over possession. Well, I have not forced
Mr.
him to hand.
Noti, don't complicate the facts. Who is the tenant here?
Well, the
Every time you mention different,
tenant was one, as was submitting, Lord, the tenant was one Paramount Refrigeration Company.
you're saying
Now-
Mr. Braganza came to the office and handed over the
Mr.
key.
Braganza, yes.
Mr. Braganza
No,
is not the
how-
petitioner before the
No, they
court.
have parted with, no, they have parted with possession to Braganza and Company. They are nowhere there. I shall show your lordship. And that agreement was entered into not by this petitioner, by one Latif Nissan and Company, represented by one Mr. Shahid Latif. This petitioner is nowhere in the picture.
So
but
what is
he
the
is
right
claiming-
of this petitioner to the
No right.
premises?
To my respectful submission is no right. He has no right. He has failed to show that he has been inducted as a tenant. He has failed to show that even if I presume that Mr. Abdul Latif, who was the sole proprietor of Paramount Refrigeration Company, according to him also there's an admission, he died sometime in 1992. If I go by the fact that he is one of his son, there are other children, siblings, or his siblings are there. No, there is nothing. No one has come forward to the office to record their name as a tenant.
And who are you, Mr. Nandi?
I am the official trustee. Under the scheme passed by this honorable court in respect of Armenian churches, way back in 1877. So my recollection goes. I look after, supervise these properties. These properties, in fact, are vested to the official trustee, but properties belong to the Armenian churches.
Very well. Mr. Nandi, just conclude your submissions on the next day. When will that be? Just conclude your submissions, please.
Yes.
When will that be?
May I come back on Wednesday? Next Wednesday, Thursday and Friday, I'm not in town. We're on personal grounds. That would be, I think, second.
Yes, heard learned counsel opinion for the petitioner who relies on section 6 within brackets 1 within brackets A of the West Bengal and 6 within brackets 4 of the West Bengal Premises Tenancy Act, 1997, to urge that the petitioner could not have been dispossessed from the tenanted premises without due process of law. Stop. Next, learned counsel appearing for the official trustee, Capitals, will continue with his submissions on 7th August 2023.
7th,
Call on the next matter.
Item number 14, Bimal Chandra Roy.
Shivam for the petitioner. It's an application, Your Lordship, for extension of Your Lordship time for making and publishing of the arbitral award under section 29A of the Arbitration and Conciliation Act.
Yes, your affidavit of service.
Yes, sir. Lordship, on the last occasion also directed me to serve. Has been served, Your Lordship.
So 24th July, what did you serve?
The notice, Your Lordship, I have served, Your Lordship.
Notice?
Yes, sir.
No, you were also supposed to communicate the order passed by the court. Have
Yes,
you
yes,
done
sir.
that?
That has also been done.
Yes, show me that, please.
Affidavit of service, Your Lordship.
No, that just says 24th July. I don't know what you have served. That's why I'm asking you.
Order copy annex for us. Lordship, may it take that once. Page 5, Your Lordship, the last order.
Yes, so the matter would be taken up on 24th July and you have served them on 24th July, item received on 24th July. Today we are on 25th. That's what I'm telling you, Mr. Dashgupta, Mr. Sengupta. The order passed by this court on 13 July 2023
On the last
directed
occasion
the
also.
petitioner to communicate to the respondent that the matter would be taken up on 24th July 2023. Stop. The track report indicates that the respondent was served / communicated with this order on 24th July 2023. Stop. Next, when do you want to come back?
After 1 week.
This is matter on 2nd August 2023.
Except
as prayed
second,
for.
Your Lordship, can it be on 3rd?
3rd, as prayed for. Next,
May Your Lordship file my supplementary affidavit, Your Lordship?
the supplementary affidavit is taken on record. Next.
Item number 19, Paharpur Cooling Towers.
I appear for the respondent now. Section 11 application.
Yes.
Arbitration clause provides the general manager of the respondent will
Yes.
appoint an arbitrator.
Show me the clause, please.
That is at page 80. 81 দেখো Place 6 it is set out কোথায় আছে বলো না page 6 it is set out of the application তোমাকে brief নেই তোমার কাছে page 6 কোন পেজে annex আছে বলো
Page 82.
page 82 page 81 then. Page 80. 35.4 35.4 page 81 brief carry করো না তুমি সব তোমার তো brief দাও তুমি মামলা 35.4
35.1.
4.
4.
Those are the earlier stages. If after the engineer has given written notice of his decision to you, no claim to arbitration has been communicated to him by you within 30 days from the receipt of
A
such
person
notice.
appointed by the general manager.
General manager.
Yes.
So this is, as quote my lord language, 1 degree away from the
Yes.
manager himself being the director. And he appoints his past, his retired general manager, his previous general manager. So this was in the year 2000. We had invoked the arbitration in the year 2015 by a notice. And the learned arbitrator was appointed by the respondent's general manager on 31st December 15. 31st December 15. So we treating this as and there are not a single meeting held, not a single pleadings, nothing.
So you did not take the objection then?
At the time, so this was pre-TRF, pre-amendment, because pre-TRF, because our invocation was made on May 2015. The amendment came in October 15, and the TRF judgment comes in 17, the first judgment. But
And so Bharat Broadband and all that followed.
follow after TRF. Now, but luckily for us now at this stage, nothing happened. Not a single notice also given for arbitration. So there's the question of waiver never arose. So when the TRF judgment came in July 17, then we filed a section 17 application.
Section 17.
Section 11 application, what am I saying? Section 11 application in my lord's court, which is dismissed on the ground, certified copy is not annexed. So my lord, this was in December 17. So my lord, then we file a
So
revised.
your application under 11 was dismissed.
Dismissed in December 17 on the technical ground that certified copy is not annexed.
Yes.
So we then, in the meantime, our claim also increased. So we submitted a revised claim, and thereafter we had to go through the whole procedure because 35.1, 35.2, 3, 4, that mediation. So we went there, went through the whole procedure again, and the mediation and the settlement failed in February 19.
Yes.
And
Settlement as in 11.5,
35.1.
35.1.
35.1, 35.2, amicable settlement parties have to make an endeavor. February 19 meeting was held, then it went on till meeting was unsuccessful in February, ultimately failed in February 19.
Yes.
But our original invocation of 15 is there. Now, my lord, then COVID limitation come because one of the points taken is limitation. So then COVID limitation
One of
comes
the points taken by
limitation by my learned friend.
claims barred by limitation.
Claims barred by limitation and section 11 application also barred by limitation.
Yes.
2/4. Now,
So they are relying on Nautel.
the matter was argued at length before the previous bench. There they had relied upon those judgments.
Yes.
And then, my lord, so we thereafter, after the mediation failed, in September 2020, we invoked the arbitration agreement by nominating our retired judge as the arbitrator, saying that you cannot, general manager can't nominate. So we make one of the retired judges and we file a section and we
21
make
notice.
a petition, 21 notice. Now they respond saying that there's already an arbitrator appointed. January
that is
20.
in accordance with the clause already
According
there.
with the clause. Mr. Pradeep Chatterjee. In January 21, the present petition is filed.
Yes.
So, my lord, they have really raised 3 points, which I shall answer briefly. I advise because let them place their points because I know something what they have argued earlier, but then they should place it. One is limitation bar.
Yes.
Limitation bar, my answer to that is that section 21 notice was given in May 2015. May 2015. The proceeding is there. So for the purpose of limitation. There's a termination of proceeding under section 32. There's been no termination under section 32 of the Arbitration Act.
So you're saying termination or no termination?
No termination because termination has to be as per section 32 of the arbitration.
Which comes with an award or with parties?
Or there are 3 ways, Lordship.
Yes.
One is with an award, other is claimant withdraws, third is parties agree on the termination, and fourth is arbitral tribunal finds that the continuation of the proceeding has for any reason become unnecessary. That's the only way in law as per this can terminate. One can, of course, revise one's claim, one can amend one's claim, that's under 23 of the Act, or 23 or 24 subsection 3 of the Act. So, limitation stopped in 15. We have been unsuccessful because certified copy was not annexed and there were some defects in our application. Limitation from, if your lordship takes 15, there is no question of limitation bar.
15? What 15?
So it was in 15, section 21 notice, there is no question of limitation bar.
Yes.
Because the contract was of 2011 and it was performed till 2015. Now, if I make a fresh invocation today, there'll be a question of whether I can take exclusion of section 14 Limitation Act for the earlier proceedings time spent, but I don't need to because section 21 notice is there.
So the fresh section 21 is of September 2020.
That nominating the arbitrator. Once again, nominating an arbitrator, Mr. Justice Talukdar, as our nominee. Or it'll be the one arbitrator since we can't argue, since we can't agree. So that is we nominated an arbitrator. But 21 notice is there in the year 2015. So prima facie, this can't be said to be a dead wood because we had our first section 11 was filed also in 2015. It can't be rejected altogether. Absolutely.
So according to you, Mr. Mitra, when will the time start to run afresh?
Time stop will stop running when the notice under 21 is given. That is 2015.
So 2015. And
Limitation
then,
purposes.
And then after that, how do you save it from 2015 to 2020?
Because the
proceeding is pending for the purpose of limitation purposes.
Yes.
It's the arbitrator already appointed. I'm saying it's a void appointment. So under section 11 or 14(2), both sections provide the court can appoint an arbitrator. So arbitrator replacement does not change the limitation. For the purpose of limitation, it stops in 2015. I may have additional claims. In the meantime, naturally, my claims will get revised. Interest will come up. But the original claim is 2015.
And if it stopped in, if the time stopped to run on 31st December 2015, then what happens after that?
After that, it's a replacement of arbitrator now. The court appoints an arbitrator under section 14(2) read with section 11. 14(2) itself gives provision for appointment of arbitrator. So Lordship is simplicity appointing an arbitrator in exercise of your powers under section 14 and section 11. I don't need to go to the arbitrator, ask him to step down, because this is a bad appointment. Because the general manager can't be the arbitrator, and general manager can't nominate his immediate past or his retired general manager. That's one degree.
That is TRF.
TRF, Bharat Broadband, Jaipur Zilla Parishad, all the judgments.
Yes.
One more point I will touch upon it and let them argue is that they are taking the point of jurisdiction. It's because there's a forum selection clause for Kolkata. Venue of the arbitration will be Kolkata.
Where is it?
Page 82, 35.9.
Thirty-five point nine.
35.9, page 82. Subject arbitration as aforesaid shall be conducted in accordance with the provisions of the Indian Arbitration Act or any statutory modification or reenactments thereof and the rules made thereunder, and for the time being.
Yes, venue shall be Kolkata.
They are saying Kolkata should not be given the general meaning as we understand, but it should be Rajarhat. Because it should be Greater Kolkata. Because their office, because our office is in Diamond Harbour Road, while their office is Salt Lake. Their office is Salt Lake, so respond. That's very hyper-technical argument, right? In humble submission. It's Kolkata jurisdiction. And when Kolkata is the principal civil court, my lord judgment is there, and also justice, other judges' judgments are there, that one does not take a point of jurisdiction. Howrah, Calcutta used to be a very common thing. Howrah is more convenient, Calcutta is less convenient. When Kolkata has jurisdiction, venue is Kolkata. And number 2, section 14(2), 11, appointment has to be only by the High Court. His submission is, I should first go to section 14 application before whatever court in Barashat or Rajarhat Commercial, wherever, get the 14 separately disposed of. That would have been the case had it been not a case of a void appointment, TRF, Zilla Parishad, etc. Had it been a case of subsequently finding somebody by.
You're saying, Mr. Mitra, that in this case, the arbitrator has become de jure or de facto unable to perform. So therefore, you have filed a 11.
Come 14.
11 come 14.
11 come. Because 14 also, Lordship knows the court's power.
Mr. Mitra, I have passed a judgment, I think last week it was, where I have decided that you please study the judgment and come back, because I will have to deal with it. I may change my mind, I may change my views, but I will have to deal with that judgment. Is that if an arbitrator becomes de jure or de facto unable to perform, it was her 2 decisions in that case, then the route is not a fresh 11(6). The route is the court will appoint in accordance with 15(2), which is the rules which are relevant for the replaced arbitrator. That is what I have held. All right. Please look at that, because I may take a different view here. No problem. But I will have to deal with that.
But I was only wondering whether that's a case of a void appointment or subsequently becoming de jure.
Subsequent. I think
that will be different. That, but
I
I would like
think
to see.
one arbitrator was elevated and the other arbitrator were relocated outside India. or something.
Then I'll be able to distinguish it, but the Lordship knows the name or the advocates who appear, then I can get it from, Lordship remembers the counsel or solicitor.
Shrey Equipments versus Sarah Investments.
That was my lord's judgment also on forum selection, Kolkata, whether there is an earlier judgment of my lord, Sierra versus Srey on Kolkata. What does it mean by Kolkata as jurisdiction? Kolkata would mean the Rajarhat, or I think yes. Same matter. Then Srey versus Sierra.
No,
Sarah.
this judgment, I don't remember that one, but this judgment I've given, I think just last week, or maybe week before last.
Has any recall as to who was the advocate? It's easier for us to get it that way. Any recall?
Mr. Mitro, I will not give you any more clues. I don't normally give what I've told you.
No, but this have to deal with it.
Your juniors are supposed to do that work.
Right, except yes. What could be?
I've given you just last week, I'm telling you, last week.
But Lordship, then he can make a submission, but then I will deal with that case.
Yes, please look at it and come back.
May I start with your Lordship's then?
First, the judgment has to be seen and then.
Very good.
I can't hear peacefully.
Very good.
Mr. Mitro, when will you come back?
Week after next, then, if it's possible, any.
A learned counsel appearing for the petitioner seeks appointment of an arbitrator under section 11 of the 1996 Act on the first appointment being a unilateral appointment on the part of the respondent. Stop. The first appointment was made on 31st December 2015. Before the series of decisions of the Supreme Court on unilateral appointments. Stop. The petitioner thereafter invoked the arbitration clause again on in September 2020, which was objected to on behalf of the respondent on the ground of an arbitrator already having been appointed by the respondent. Stop. The present application was filed in January 2021. Stop. Next, the learned counsel appearing for the respondent takes a point of limitation as well as jurisdiction of this court to entertain the present application. Stop. Next, Lysis matter on Mr. Mitro, first week, did you say, or which one? Which
week after next, any day, I will.
Tell me, give me a date.
7th, 8th, 9th, whenever it comes.
Lysis matter on 7th August 2023.
Can it be it can be on the 10th, madam? 10th.
10th.
I'm grateful to you.
As prayed for. 10th August 2023 as prayed for. Next.
Ludlow, Jute and Specialties.
May it please your Lordship, and I am appearing for the petitioner.
For the respondent, ma'am.
This is a what?
So this is a application under section 11 for appointment of an arbitrator. It is, my lord, appearing after exchange of affidavits. My lord,
I will put it on some other day. How much time will you take?
Lord, I have made my submissions elaborately on the last occasion. My learned friend was not there. My lord, I'll not take more than 10 minutes, my lord.
Very well. Come back on some other day, please.
My lord.
When? Tell me when. This week, next week, whenever.
Lord, any day convenient to your lordship.
Yes, Lysis matter on this week, 28th or next week?
My lord, maybe on the next week, no, 28th, I mean.
Lysis matter on 2nd August 2020.
I'm deeply obliged.
Next.
Deeply obliged.
21, Malaroy and others.
I was addressing my lord, but
I
I must
prefer the
point
petitioner,
out,
ma'am.
last Thursday, Friday I was not here, so I had Hon'ble Mukherjee briefed also. He's not well today, so I was wondering, since he's briefed.
Yes,
if
yes,
he could
definitely. Yes,
Any
tell
day,
me,
my lord,
Mr.
subject to lordship's convenience, any day.
This is a.
Section 11, my lord.
Tell me, Mr.
Lordship,
Mukherjee.
or should week after next week? I don't know how, because he said he's going to flip us week after.
Yes,
But if it can also be on the 10th of August, like, my lord.
I'm not even.
adjournment is prayed for on behalf of counsel appearing for the respondent. Stop. List this matter on 10th August 2023 as prayed. Next. Next.
22 Breach Track and Tower.
My lord, this is my section 11 application. My lord,
I appear for the respondents, my lord. Mr. Oniban Ray is leading me in this matter. Is humbly praying, my lord, if your lordship may kindly grant me.
Mr. Ray was in court.
My lord, he's perhaps, my lord, on his legs before another court, my lord.
He's on his legs or he's online? Which one?
Supposed to be online, my lord. Perhaps, my lord, he's on his legs now.
Yes. Adjournment is prayed for on behalf of counsel appearing for the respondent. When do you want it?
My lord, any day convenient to your lordship, my lord.
List this matter on 28 July 2023.
Deeply obliged.
You're waiting for a matter? Next one. Call on the next matter, please.
But I appear for the respondent, my lord.
That's okay.
23.
Call on next.
Item number 23.
My lord, I appear for the respondent, my lord. Here, my lord, I had taken the point of an insufficiently stamped document, my lord. That was the point in issue.
Very
I'm opposing a section.
Chaudhary is appearing for the petition and all. He's on his leg, my lord.
We'll take it up any day, my lord.
Yes, adjournment is prayed for on behalf of counsel appearing for the petitioner. List this matter tomorrow.
Much appreciated.